ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ Milords, may I make one submission, Milords? Milords, in this case, the petitioner has paid already 2,23 lakhs, Milords, and the outstanding is 64 lakhs. Even then, the bank is taking physical
It
position.
can't take.
Milords,
It can't take.
Milords, there is an
Doesn't
OTS.
matter.
Milords, there is an OTS between bank and the borrower, Milords. Milords, the last date was 14/3, and after which the bank themselves have extended till 14/3. The last date was 14/2. The bank themselves have extended till 14/3.
If it is a fresh matter, it will come, give it to the court officer.
Milords, it is
Don't have to
posted on.
mention, don't mention any fresh matters. As per the SOP, they have to come, they will come. If they are not, then inform to the court officer, you'll find out from the registry.
Milords, it is posted on 16/3, Milords. That is why
Huh?
it is posted on 16/3.
And
The
then why
last
you-
roster has been,
Then why should we advance it?
Milords, on that date, the,
No, you were there.
Milords, the
Before you,
matter did not
is
reach.
adjourned.
The
We will
matter did
take
not
it up
reach.
now. Yes,
My
all
lords.
fresh matters.
The matter did not reach, Milords.
Nothing-
That's why,
not-
Milords.
It will not be taken up. No memos will be granted. I'm making it very clear. All fresh matters will come and remaining matters from the old matters I'll be taking up. It hardly takes a month to complete the entire DRT. Yes, call the list.
My lords, this is a pending matter, my lords. Work order is issued despite the interim order, my the respondent authorities.
Which-
No date is given, my lord. Fishing rights, my lords.
Which year is that?
2023, my matter is not listed, madam, after interim order.
That matters also will come. I will not take up any matter out of the turn. All matters will be listed.
Work order is not issued, my
We
lord.
will see. 23, nothing is happened. From 23 to 26, we're
There
waiting.
is an interim
All the
order,
list.
there is a work order is issued. That's the
No,
difficulty,
no,
my
no.
lords. Whole
Yeah.
purpose will be in vain, my
And
lords.
yes,
Any date, this week, any date may be given, my lords.
yes. Now take that.
Make a submission, my lord.
Matter pertaining to establishment of sugar factory, my lord. Since subsequent developments have taken place, any date may be fixed, not this month.
I will not give any dates. I have already directed the registry. Everything will come in a one day, complete police matters will come, one day, one department will come. Like that, we will take up all the old matters. I will not take any matter out of turn.
Probably
Yes.
by the end of this month, my rights may be defeated, my lord. My rights in prior.
It's your, from 2023 without any order, you're waiting.
Then subsequent developments have taken, any date may be fixed, my lord.
Yes, call the list.
Page-wise adjournments, list one.
One submission.
Fresh matter.
All the active subjects complied.
Huh?
Fresh
My
matter.
lord, all the active subjects complied.
Compared with it will come.
No, my lord, the said bank authority is trying to seize the property, my lord, since the matter is very urgent. The petitioner is a health issue person and also aged person, small children.
When was the petition filed?
Last week.
Then what were you doing from last week till now? 2 days it has to come. Why it has not come? Have you verified? Just find out about that, whether, when is it numbered? What has happened, whether the office objections are complied with or not.
My lord, one submission, my
One
lord.
submission, my lord.
My lord, one submission, my lord.
Wait.
My lord, once.
My lord, one submission, my lord. Petition of 2021, my lord. They've not.
I think if I say it is for everybody, no mentionings on by each and every advocate, and I don't have to repeat it again.
My lord, one submission, my lord. My lord, on the last occasion when your lordships were sitting in Court Hall 19, my lord, there's a batch of ozone matters, my lord, which
Yes.
further hearing. Could it be on Monday, my lord, in a
No,
separate?
we will take up, we'll take up. Let me complete this and one day we'll take up.
Please.
Yes.
Page-wise adjournments, if any. List number one, page number one.
Dismissal matters, no adjournment.
Yes.
Call from interlocutory or from preliminary hearing from 26.
Page number seven, 26 to 29.
Serial number 29, my lord. Appear for the petitioner, my lord. Petitioner is unwell, my lord, hospitalized, my lord. Kindly 10 days time I have to file this.
Memo for withdrawal, it is just being listed.
Kindly next week.
I will
my-
not extend the interim order.
Without interim order.
I will not extend. Let's this matter next week. No further adjournments.
On 20 days time, petitioner is hospitalized, my lord. Or hospital bed,
Who appears for the respondent?
respondent LIC our madam.
Let respondent come when the matter is called, we will.
Inform.
Yes, mister? He wants 2 weeks' time.
2 weeks madam, to file necessary memo my lord.
We are fine with it, your lordship.
Huh?
We are fine with it, your lordship. They want to, yes, your lordship.
List after 2 weeks.
Serial number 27.
Huh?
27 first list.
Yes, I'm seeking a 1 week time.
Why?
Senior is not in station.
It's a preliminary hearing matter.
Any
List
short,
after 3 weeks, 27. Yes, next.
Page number 8, 30 to 34. Page number 9.
Serial number 31, my lord, for the petitioner in this matter.
30?
31.
Yes.
Kindly, it may be taken up any day next week.
Why not today?
Today there is some inconvenience, my lord. We have a 2:30 matter.
Have you informed the other side? You have no objection. This is matter after.
They are seeking a mandamus to direct declaration of rescission of conveyance deed. That cannot be done. Though
We'll
they,
see when the matter reaches. Yes, next.
List number 2.
List 136. 36 months appearing for petitioner.
Huh?
Appearing for the petitioner in this case.
In which case?
36 months. Serial number 36. There are connected matters, my lords. May be taken up next week, my lords.
Why?
The senior is out of station, my lords, and next week.
Who appears as the respondent?
I pass 36, 36.
36 and 36.1.
You appear for.
Yeah.
This each time. Huh?
They have communicated.
Yes, let's this matter after 4 weeks.
My lords, next week, my lords, kindly. My lords.
We don't have time.
My lords, date
Whenever
will be
you
fixed.
want. This matter on 6th of April.
Alright, list number 1, serial number 8, I may permitted to withdraw the.
List number 1.
List number 1, serial number 8, I may permitted to withdraw the petition to approach the deputy cover tribunal.
That liberty I can't grant right now. We please wait till the matter reaches. Yes.
List number 2.
My lord, list number 2, serial number 20.
No dismissal matters, no adjournment.
No, my lord, I have received the wakalat last evening.
He call, let him call.
Number 6.
You follow what is happening in the court.
41, my lordship.
Page number 6. Page number 23. Page number 7. Report 29. Page number 8. Seal number 30. Page number 9. 31 to 35.
My lords, for the petitioner in serial number 31, we have to file the entire order sheet. There's been a delay. We have to file the entire order sheet of the DRT. So there has been a delay. We've informed the other side.
It's a 2016 matter. It will not be adjourned. Yes, next.
I'm kindly 1 week.
No. Yes.
My lord, seal number 32.
Yes. It's DRT matter of 2020. No matter will be adjourned. Yes, next. Yes, next. For the adjournment.
I appear for the petitioner. I may be permitted. 42. So cleared and
A memo is filed stating that the entire outstanding amount is paid in the loan account is closed and so suffice.
Page number 11. 43 to 48.
Just call the list.
Parted matters. Serial number 1. List number 1. Pratima.
Petitioner, my lords.
What happened yesterday, I have dictated, it is already there. From here, he is not having any other income. Then counsel for the petitioner further submits that the court, the amount of maintenance that is awarded by the court is without any basis, and the same needs to be set aside. Next para. Yesterday when the matter came up, and on the last 3-4 occasions, there was no representation on behalf of the respondents. When the matter was dictated, when it is halfway the dictation, at that time, land counsel, the respondent has appeared before the court. And when this court has specifically asked the counsel for the respondent On what basis the court has granted 20,000? He has sought for a passover. Then again, the matter is passed over. Yesterday, again, a representation is made on his behalf, stating that the council, stating that the council is held up in the other court. And the matter is posted today as directed the matter to be posted as first matter. Today also there is no representation. It appears that the respondent is not interested to pursue the matter. Next para, having heard the counsels on either side, peruse the material on the court. The court had granted the maintenance of 20,000 to the respondent wife. While granting the maintenance, the court had considered the amount of 25 lakhs that is lying in the account of the 26 lakh 10,408 that is lying in the account of the petitioner. Then counsel for the petitioner has placed the account statement before the court and submitted that except that amount, the petitioner is not having any other amounts. And from that, he is getting interest of 13,000 and odd. It is further submitted that the wife she has left the company. What is that you said yesterday?
She is an MSc graduate holder. Now she says she is not working. Earlier she was working. She is staying with her parents. No rent is there.
She is educated. She is a graduate, and earlier she was working. Now only for the purpose of claiming the maintenance, it is stated that she is not working. Considering all these aspects and the fact that considering all these aspects, this court deems it appropriate to modify the order passed by the family court. Accordingly, the petition is, accordingly, this court is passing the following order. The order dated so-and-so of the trial court passed in so-and-so is modified, and the amount of maintenance is reduced from an amount of rupees 20,000 to 10,000. Yes, next.
Serial number 2 for dismissal. Sharavanaji.
Please come. This is the red petition of 2022. The red petition is filed seeking the following prayer. Right from 2022, this matter has come up several occasions before this court. On 3/2/2026, the order dated 3/2/2026 reads that none appeared even when the matter is called in the second occasion. On 16/2/2026, the matter was listed, and at request, the matter was directed to be listed on 23/2/2026. And on 23/2/2026, an order is passed that none appears for the parties even when the matter is called in the second occasion, and directed the matter to be listed on 3/3/2026 on payment of costs of rupees 2,000 payable to the High Court Legal Services Committee. Yesterday, when this matter listed before the court, there is no representation on behalf of the petitioner, and there is nothing on record to show that costs of rupees 2,000 are paid. Hence, the matter was directed to be listed under the caption for dismissal, and today also there is no representation. It appears that the petitioner is not interested to prosecute the matter, which is pending from the year 2022. Accordingly, the petition is dismissed for non-prosecution.
I am a owner of the property of 22 guntas of the land.
Please come to the prayer. What is the prayer you are seeking?
Next year,
Page number?
Page number 46.
Notice issued by the court
Issued by the government,
respondent,
my lord.
dated
Directed,
28/1/2022.
yes, no, directed the petitioner to vacate the land which was constructed by me in the land belongs to the school, my lord. The notice issued by the respondent, your lordship, they have not held proper inquiry. They have not conducted the spot mahajar also. They have not, on the basis of the survey report.
Is it an order or a notice?
It is a notice, ma'am.
Then if it is a notice, you have what is the rights available to the petitioner?
My lord, they have they're saying they are conducted the spot mahajar. They have, on the basis
What does the notice say?
but they have not produced any material before this honorable court also.
1 minute.
Notice reflects that he has constructed a residential house on the government land. Admittedly, he only admits that it's a government.
No, this notice is issued under which provision, under the which act?
No, there is no specific provision invoked, my lord. The BU of the concerned area has issued, because he has constructed a house on this premises, on the land belongs to a school. There is no invocation of any provisions.
So if you say, you can't unilaterally decide that. You should say, you should issue a show cause notice to them saying that so-and-so is done, please come and, please explain to that.
No, even to the extent
not
of
done
this notice dated 21/2022, he is at liberty to file reply. He is at liberty to file
It
reply.
is not about his liberty. Notice should contain saying that you should explain to this or you please respond to the notice. It is more or less, though you term it as a notice, you passed an order directing him to vacate it. How can it be? How can there be a unilateral decision like that without an opportunity? Following principles of
May I
natural justice?
propose something, my lord?
Yes.
Since there is a dispute of, he claims that he is the owner of the land. The state claims that it belongs to school. We will conduct a joint survey by the concerned ADLR. We will file report before this court. If it is proved that it is a land belongs to petitioner, we will withdraw this
No,
notice.
no,
They have already filed a statement of objection, but they have not produced any material before the
Please
Honorable
wait,
Court.
please
Your
wait.
Lordship.
Conduct a joint survey.
No, they have not conducted, Your
So we
Lordship.
will
Then I
conduct
will,
joint survey by
shall I
this-
dismiss the writ petition? You're not understanding what I'm proposing to. Now, what we'll do is, I'll dispose of this writ petition to conduct a joint survey and basing on whatever is outcome of it, if he is aggrieved by it, let him question that.
Please, ma'am.
And I'll set aside this notice.
Please.
Please come. The present writ petition is filed, seeking the following prayer. The facts of the case are, the petitioner is absolute owner and in possession of the land bearing survey number 48/1A, situated at Honur village, Kulahatti, Davangere Taluk. The petitioner has purchased the said property in the year 1988, which was registered as document number 4211, book number 1, volume number 1861, dated 5/12/1988, in the office of the sub-registrar Davangere. And ever since, the petition is in peaceful possession and enjoyment of the property. And he has also paid the tax. He applied for the construction permission before the Gram Panchayat. The Gram Panchayat has given has given permission. And the petitioner has put up the construction. After purchase of the site, it is stated that the petition name is entered in the Pahanis. And he has also filed the Pahanis for the years 2009, 10, 2016, 17. He applied for the podi of the land before the concerned office. It is stated that in survey number 48/1A, total extent of land is 13 acres belonging to Ajappa and Sons, Nagappa, Vishwanath. Vishwanath has gifted some extent of land to the school. In some extent, he sold the land to different purchasers, and some other extent has given to National Highways Authority. The National Highways Authority has acquired the land for the road widening purpose. As far as the petition is concerned, he has purchased an extent of 22 kuntas of land. Earlier, he has applied for measurement of the land to survey department that there is a dispute between the adjacent landowners. The officials conducted the survey without prior information notice to the petitioner and submitted the report to the school authorities stating that the house which is constructed by the petitioner belongs to the school. Then the fourth respondent, that is the educational officer, has issued a notice dated 28/1/2021 stating that as per the survey report dated 18/11/2021, surveyed with the survey department, the petition has put up house in the school land, unauthorized fee, Hence, it is directed that the petitioner shall vacate and hand over the scheduled land to the respondent immediately, and the land is a government land. Agreed thereby, the petition is before this court. Land counsel appearing for the petitioner submits that the petitioner has put up the construction in the land belonging to the petitioner, which he has purchased by way of a registered sale deed. It is submitted that the respondents, without any basis, has come to the conclusion that petitioner has unauthorizedly has constructed by encroaching the land of the school. The respondent has failed to adhere to the principles of natural justice, and there is no basis for the notice issued. It is stated that, though it is stated that it is a notice, but in fact it's an order passed to the respondent directing the petitioner to vacate the land. And what is the business of educational officer? Still, no, still what is his role? Somebody else has to do it. He can't pass an order. And what is the binding nature of that? Educational officer is not there to protect to do all issue notices to parties to vacate the lands and all. He has no business to do it. If it is a government land, somebody else will do it. No, whatever it is a government land, somebody else, your Tahsildar is there, or somebody else will do it. It is submitted that the fourth respondent has no jurisdiction to issue such a notice. Next paragraph. Learned counsel appearing, the learned AGA appearing on behalf of the which respondent, all respondents appearing for the respondents submits that as it is a government land and there is a school constructed in that, as the petitioner has encroached the same. The respondents have issued a notice. If the petitioner is agreed with that, he should have responded to the said notice, but he cannot come before this court and file the instant writ petition. It is submitted that there are no grounds to interfere with the notice impugned dated so and so. Next paragraph. Having heard the counsels so and so. According to the fourth respondent, the property belongs to the school. According to the petitioner, it is his property in which he has made construction after obtaining necessary permission. According to the fourth respondent, if this property belongs to them, they cannot issue a notice they cannot pass an order of this nature, which is termed as a notice to vacate the premises. They cannot, in this manner, they cannot pass any order. And the fourth respondent has no jurisdiction to pass an order directing the petitioner to vacate the premises. In that view of the matter, this court is passing the following order. The notice dated so and so, notice impugned dated so and so is set aside. The respondents are at liberty to avail the appropriate remedies and to act in accordance with law. Yes, next.
Four, Prakash Image.
To the petitioner, Your Lordship. Your Lordship,
Where
insofar
is the
as
prayer? Come to your prayer. To set aside the order dated 31/3/2022 passed by the Deputy Commissioner under the maintenance and welfare of the parent citizens. What is wrong with the order?
Lordship, what
You're
has
the-
happened? Lordship, the authorities ordered the joint kata of all the respondents insofar as of the partition which was done in the name of petitioner. And he was
Switch on the
also
mic.
in, Your Lordship,
Switch on the mic. Yes.
Green light will.
the properties which were standing in the name of petitioner, after filing the application before the authority, Your Lordship, the respondent number
let's
2 is
Come to the cause title. Respondent number 3 and 4 are your
3 and
parents.
4 are parents of petitioner number 1.
Petitioner.
And respondent number 5 is the elder brother of the petitioner. In this case, the properties which were given to the petitioner in a family settlement was a joint family property. Thereon, the respondent number 2 had acquired through family partition. And whatever the partition were made insofar as
When was the
petitioner number
partition?
1,
When was the partition?
Lordship, the partition was done 26/7/2017.
26/7?
2017. Here, the petitioner number 1 gets residential property and trading premises, one trading premises, and also they had imposed that a sum of 35 lakhs to be paid to respondent number 5. That was also paid, and there was an outstanding loan in Arya Vaishya Society of rupees 21 lakhs 62,920. That was also paid, and at the instigate of respondent number 5, respondent number 2, 3 and 4 filed an application wherein seeking to cancellation of the property which was given
The
to
family
petitioner number
partition, what fell to the share of these 3 and 4?
3 and 4, they have a property or a lordship residential property.
No, in the
and
family.
trading premises.
In the family partition,
Please, Your
what fell to their share?
That is what, there were 2 residential properties. They are staying in one, and one was given to the petition number 1. Insofar as respondent number 5, he is working and settled in Bangalore. So he said that an amount of 35.
Come to the order. Where is that? What it says? What is the case of the respondent?
The respondent says that the property was fraudulently registered in petitioner number 1's name.
Registered on what date? Also, yes, next.
Number 5, Syed Umar.
What is this petition about? Any interim order in this? The present petition is filed. Seeking the following prayer. This is a writ petition of 2023. This has come up for the first time before the court on 3/3/2026. On the day there was no representation. It says interim order earlier granted is extended. Where is the interim order? You only wrote. It's never come up. Should verify before writing all this. Where is the interim order? It's coming up for the first time. Please make corrections. As there is no representation on behalf of the petitioner, the matter was directed to be listed today under the caption for dismissal. Today also there is no representation. Land counsel appearing for the respondent bank submits that the sale notice was questioned before this court, and for want of buyers, for want of bidders, they couldn't conduct the sale. Hence, nothing survives your consideration in this writ petition. Accordingly, writ petition is dismissed as instructions.
Number 6, Saraswati M.
Appearing for petitioner in this matter.
Yes.
They have initiated 138 proceedings, my lord. They have initiated 138 proceedings, my lord. Negotiation is going on, my lord. It may be disposed of.
No, 138 proceedings initiated
have,
and this writ petition has to be disposed of. I didn't understand this. Please come to the writ direction to quash the order dated. You questioned section 14 order.
Please, my lord. Now they are
To not to dispossess the petitioner from the physical possession. So what is the connection between 138 and this?
No, my lord, negotiation is going on, my lord. Or any 2 weeks may be granted, my lord.
There is an interim order in this.
Please, my lord.
Please come. The present writ petition is filed. Questioning an order dated 26/7/2020. The writ petition is filed seeking the following prayer. When the matter came up, Land Counsellor, the petitioner submits that 2 weeks' time may be granted. Negotiations are going on between the petitioner and the bank. This writ petition is filed in the year 2024. A coordinate bench of this court has passed an order that petition shall not be dispossessed if they are not already dispossessed as on today. Whether they are dispossessed or not.
No,
Yes. Whether they are dispossessed or in
no, my
possession.
lord, they are still in the premises. They are still in the schedule.
Dispossessed, and the said interim order is subsisting till today. The petitioner has come before the court questioning the order that is passed by the magistrate under section 14 of the Surface Act. The petitioner has an effective alternative remedy under section 17 of the Surface Act, and he shall approach the DRTs. In that view of the matter, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy in accordance with law. Yes, next.
7, Satish DJ.
Yes.
Satish.
Please come. This writ petition of the writ petition is filed seeking the following prayer. It's a writ petition of 2024. This has only come up before the court on 3/3/2026. As all the while, this is pending for complying with the office objections. And as there is no representation on behalf of the petitioner, the matter is directly listed today. Today also no representation, accordingly dismissed for non-prosecution. Yes, 8.
8, Somshekhar.
Filing memo for withdrawal, my lord.
Take that.
May permitted to approach the DRT challenging the.
Yes, the MO is filed seeking to withdraw the petition, permitting the petition to withdraw the writ petition with the liberty of approach the debt recovery tribunal. Accordingly, memo is taken on record and the writ petition is dismissed as withdrawn with the liberty to avail the remedy before DRT in accordance with law.
Number 9, Shivkumar.
Yes.
He's also filing. He's saying that there is a safety in his favor. Whereas the bank is filing there is a safety in their favor. There are two stages. I made a request to the bank to withdraw all the documents. The original documents number to verify. If he is having the prior charge number, we'll see the documents. They will make a submission according.
When you will file your objection. This is matter on 16th of March. By the time the respondent shall place before the court his objections, or else the writ petition will be heard on the merits of the matter.
Much.
Interim order is there?
No.
He is in two minds.
Actually, it is not being filed.
It is there earlier. Last 4 occasions, it's not extended, will not extend it now. Yes.
He has not filed.
Number 10, Nagaraj Shetty.
Appearing for petitioner. Process memo has been paid for respondent 1 2.
No, please, what is the writ petition about? Let's see first, process later. What is that you're questioning?
Auction notice.
To quash the impugned auction notice dated 2/1/2026. That is over long back. Auction has taken place.
Kindly pass over.
Pass over.
For order, serial number 11, Sangamesh RB.
Yes, memo for withdrawal. A memo is filed seeking to withdraw the petition stating that already the prayer that is sought by the petitioner is considered by the second respondent, hence nothing survives for consideration. Accordingly, the memo is taken on record. Dismissed as withdrawn. Yes, next.
12, PD Surana.
Appearing for petitioner, my lord. I'll file the memo for withdrawal.
The memo is filed stating that arbitration case number 38 of 1990 is disposed of. There's nothing survives accordingly. Memo is taken on record and dismissed as infractious. Yes, 13.
13, Shri Rajshekar.
Appearing for the petitioner, my lords. In this matter, the parties have arrived at the settlement, my lords. The bank and also the borrower, my lords. I am the agreement holder, my lords. We have to reduce in terms, my lords. It appears the borrowers.
It is submitted that the parties have arrived at a settlement that will be placed on record. This is the matter on 12th. 13. Yes, next 14.
14, Shiv Prasad Shantanagoda.
Petitioner, my lords, matter has become infructuous, my lords. The property has been sold and the loan account is
Where is
also
that
closed.
memo? Take the memo.
Howದು? On 2nd Jan 2024, my lord, the memo. Thereafter, my lord, the property has been sold and loan account is also closed, my lords.
Memo is filed stating that the writ petition is filed questioning the auction notice. Thereafter, a fresh notice seeking fiscal position was issued on 29/12/2023. You want to challenge the notice dated
No,
29?
lord, no, pursuant to this, the sale auction has been over and
Why should you file a return?
it was filed on my
File a
second.
proper memo. We can't, on this memo, we can't, or without the memo, I can record your submission.
Yes, please,
It
please.
is submitted with the counsel the petition that the writ petition has become infructuous. Hence he wants to withdraw hence it may be dismissed as infructuous. Yes, accordingly dismissed as infructuous.
Please.
Yes, 15.
15,
Kindly will be listed tomorrow.
Rajendra.
Kindly will be listed tomorrow. Senior is not in town. And what happened in the last 2 dates, we didn't have any.
Yes, what is
instructions
this
from the
matter
client.
about?
Assignment agreement. Lordship.
Lordship, this matter is basically an assignment of the debt from one bank to an ARC. Now, at the later stage of after 5 years, they challenge the assignment agreement saying that the assignment to ARC, we have not paid the stamp duty. That is the only crux of the matter. Now, it is debatable. Now, I have filed an idea for this vacancy. That has to be considered.
Kindly will be listed tomorrow. From last 2 dates, we didn't have any.
Yes, next.
Last 2 occasions, they did not turn up.
Your Lordship.
Now, this is the third.
List this matter tomorrow, no further adjournments will be granted. Yes, 16.
16, Farin.
Lordship, we have paid the process fees as well.
Why you have not taken hand summons as per the order dated
I'm for the
27 to?
petitioner, my lordship. I'm for the petitioner. The respondent should take. I have paid hand summons for process memos.
You are only supposed to take hand summons that you have not taken. What is this petition?
Seeking for the one-time settlement, my lordship. OTS, we are seeking for the bank from one-time settlement. We have went personally to the bank and we are seeking that. Even we have given a letter also, but bank has not.
What we'll do is, no, we'll consider it in accordance with law. No, that you can tell them, isn't it? Why should this be pending here? They're seeking, they have a representation. You do in accordance with law. If you can do it, you do it. If you can't, you tell them that they will question.
Lordship, in this we have paid almost 92%, lordship.
Whatever it is.
So we are seeking little bit
The
waiver of
writ
an
petition is
interest,
filed,
lordship.
seeking the following prayer. It's a case of the petitioner. They avail the loan from the respondents And they have been paying the amounts regularly and diligently. Despite having paid approximately 92% of the original disbursed loan amount, the respondent bank is claiming that a further sum of rupees 24 lakhs remains outstanding. That amount is highly excessive and without considering the repayment already made. The statement is that the bank has come to the said conclusion. They have issued a detailed written representation dated 39/20/25, reiterating their request to the respondent bank to grant them a humane and reasonable OTS and to communicate the terms of such OTS at the earliest. The bank has received the same and they have not responded to the same, and so have come before the court. This court, in the land counsel appearing for the respondent, submits that they will file their objections in the light of the law laid down by the Honorable Apex Court. The courts cannot issue a mandamus directing the respondents to grant a one-time settlement. However, the petitioner has made a representation to the respondents dated 39/20/25 for one-time settlement. The respondents shall consider the same in accordance with the law. Shall consider accordingly. This court is passing the following order: the petition is disposed of, directing the respondents to consider the representation dated 39/20/25 in accordance with law within a period of 4 weeks. Huh? When did you give? Now again you give again. Yes. So and so for respondent.
Suresh.
Suresh.
Number 17, Dwarakanath.
This matter had come up yesterday. They gave some decisions telling that the writ petition is not maintainable.
Yes.
The decisions are to the effect that the writ petition would not be maintainable against a private bank. This bank is described as A-class scheduled commercial bank. This is the one. It has been,
There is a direct judgment on this bank only. There is a, where is that? Give it to him. Judgment is directly on this bank, Karnataka Bank.
Yes, ma'am. Your lordship would kindly see that it is registered under second schedule of Reserve Bank.
Let's not, because if it is something else, we can understand. Have it in this judgment in WP number 11869. It was specifically dealing with Karnataka Bank. Not nothing else. If it is some other thing, we have to look into all those things you're saying. No, there is an order saying that a writ petition is not maintainable against Karnataka Bank.
Your lordship may kindly permit me to go to alternate remedy before DRT.
Yes.
The time spent may kindly be excused. Your lordship may give 30 days time for me to pay a DRT.
R1 is? You're the? Huh? Delete the name of Mr. S. Rajshekhar for R1. This should be the docket order.
In this case, the entire payment has been made. That is the reason for which I thought a writ would lie.
The writ petition is filed, seeking the following prayer. The respondent before this court is a Karnataka Bank Limited. When the matter came up for hearing, learned counsel appearing for the respondent, to whom you are representing, respondent bank. A respondent bank had placed before the court the judgment of the on order passed in writ petition number 11869 of 2017, clubbed with writ petition number 27352 of 2016, dated 4th March 2020, arising in case of Sri Gautam and Karnataka Bank Limited, wherein a coordinate bench of this court, considering the judgment of the apex court in MP Singh versus Union of India and others, reported in ARSCW, on 2013 ARSCW 2545 has held that since the respondent bank is similarly situated, the instant writ petition requires to be rejected as not being maintainable. Accordingly, the writ petition is rejected as not maintainable, and counsel submits that in respect of the very same Karnataka bank, this order is passed. As such, the writ petition before this court is not maintainable. Then counsel appearing for the petitioner submits that, and after discharging the entire amount, the present proceedings were initiated, which made the petitioner to come before this court. It is submitted that the writ is maintainable, and he has stated that it is you said something with regard to the maintainability.
Your Lordship, could I permit me to approach
No,
DRT?
you said some argument with regard to the maintainability of the writ petition.
See, it is a scheduled bank, A-class scheduled bank, registered before the RBI as in its second schedule, and it is discharging statutory functions. Hence, your Lordship may disagree with our.
No, there is another judgment of the latest judgment of the Supreme Court in the same line. It is submitted that the bank is discharging the statutory functions. It is registered with the Reserve Bank of India. In these circumstances, the bank is a bank cannot be termed as a private bank, and the writ is maintainable against the respondent. Next, having got the counsels on either side, there is a material non-record. The order that is refers supra in Gautam's case, the coordinate bench of this court has specifically held that a writ is not maintainable against Karnataka Bank. Even the submissions that are made on behalf of the petitioner cannot be considered for the reason in the light of the law laid down by the Honorable Apex Court in S. Soba versus Muthoot Finance Limited. It is reported in 2025 INSC 117. The court at paragraph number 9 has the entire paragraph number 9 extract as observed as below. In the light of the above, this writ petition is not maintainable, and the petitioner has to avail the appropriate remedy available to them. In that view of the matter, this court is passing the following order. Accordingly, the writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy within appropriate remedy. The petitioner will have the another section 14 of the Limitation Act, have the benefit of section 14 of the Limitation Act.
We will file it in 30 days, your
But
Lordship.
we can't, when the writ petition is not maintainable, we cannot grant any interim order. That will be another mistake by the court. Yes, next.
18, Manoj K.
Keep a short pass over, my lord.
Yes.
Pass over, my lord.
How many times you will ask a passover? Yesterday also you
Yes,
sought
this is
for.
another court, my lord. Maybe
Day after
passed
tomorrow.
over, my lord, they have
This is a
taken
matter
position.
day after tomorrow at the request of land counts for the respondent. Yes, next. 19.
19, Kulkarni.
At the outset of this matter, your lordship, respondent bank is misutilizing the provisions of SURFACE without having a proper valid mortgage.
What
your
is the prayer? Come to the prayer first.
Sale notice, where sale is to be conducted today itself, your lordship. They have
No,
challenged the
come to
sale
the
notice.
prayer. What is the prayer? Impugned auction notice. So you're questioning the auction notice. On what
Yes, your
ground?
lordship. On the grounds that they are not having a valid mortgage, your lordship. Your lordship, the property is mortgaged on 8/10/2021 to the petitioner bank, and subsequently it has turned to NPA on 14/2/2022. And OA was already filed, and it is also decreed on 11/12/2025 to recover a sum of 1,56 lakhs. Physical possession was taken by the petitioner bank,
Yes,
and also
Mr.
it still continues with the
Canara Bank
petitioner
who
bank.
appears? Where is Vignesh Shetty? Find out instructions.
Your lordship, you may please kindly see Annexure E in this.
Serve him the papers. In which this case? Oh, there is State Bank of India.
Petitioner is State Bank of India, Your Lordship.
State Bank of India against
Canara Bank, Your Lordship. Because we are having the proper valid
who
mortgage, Your
appeals for
Lordship,
the
which is
Canara Bank,
registered also.
apart from you. Huh? So and so is directed to take notice. So the papers also.
Your Lordship, one more kind submission, Your
We'll
Lordship.
hear. Two banks, no problem. We'll hear the matter. No urgency
Literally,
to you.
auction unnecessary third
Nothing
party.
will happen, nothing will happen. The list is, print the name of so and so.
Auction
So the
purchaser will be the sufferer,
Sir,
Your
the
Lordship.
papers on the council, list is matter day after tomorrow. Yes, next 20.
Great. Number 20, Nataraj Balal.
Appear for the petitioner. But learned friend has filed an early hearing application, my lord. Interim order was granted after hearing the respondent, after the statement of
Fine, then that
objections.
case from
there
2021
is-
it will be
yes,
pending.
my lord, your lordship may kindly see that there is an SLP, I mean, civil appeal pending before the Supreme Court.
Let's hear the matter on the merits.
Yes, my lord.
Whatever it is, it can't be pending.
Please, my lord.
Yes, whatever, what is that is questioned before the court?
Lord, a circular, my lord, which is issued, my lord, on merits. my lord.
Crash the circular number and the circular bearing. And what is the interim order in this?
Interim order not to implement, but the reason is this, my lord, the petitioner herein is an association of
When is the order? When is the interim order?
interim order, my lord.
My lord, your lordship may kindly take the synopsis, my lord.
Take that. By ad interim order, it is directed that pending disposal of this writ petition, services of pygmy collectors shall not be dispensed with. Commission payable shall be based on collection as per circulars dated so and so. Issued by the Canara Bank, Bangalore, and it shall be subject to result of the writ petition.
Yes.
Yes, let's see the synopsis. Gave him the copy.
Synopsis, I'll give.
Lord, may I seek one indulgence, my lord. Could it be taken up on Monday, my lord? I will take that synopsis. I will answer that synopsis also with written.
Yes,
my
let this
written-
matter on Monday.
Monday.
No further adjournments
Please,
will be
madam.
granted.
I will go on with matter.
Yes, at the request of counsel the petitioner, respondent counsel has filed the synopsis and a copy of it is served on the counsel for the petitioner. Yes, next 21.
21, Ajit Kalyan.
The petitioner in this case, my lord, sir. This is the
What is this
application for
clarification
clarification,
of
my
order
lord.
dated
My lord,
29/20?
this honorable court in WP, my lord, your lordship may kindly come to the order passed by this honorable court in WP.
Why you are seeking the clarification so early?
My lord, sir, in this, no, we have filed a review petition, my lord, prior to that. In the review petition, my lord, that order came to be passed with liberty to file a clarification
When was
application.
the order in the review petition?
Last 4 February 2026, my lord.
4th
4 2
February?
2026, my lord.
Uh,
After that, we have filed an application in the writ
No.
petition for clarification.
Main writ petition, again review, again no any other clarification.
No, your lordship may kindly come to the order passed by this honorable court in WP dated 29/2022, my lords.
Where is that order?
29/2022, my lords.
Hmm.
I may be permitted to read that relevant portion of the order, my lords. The grievance of the petitioners is against the coercive action of the recovery at the hands of the respondent lender bank. Learned senior panel counsel appearing for the said bank, having argued the matter for some time, now fairly agrees with the suggestion of this court that petitioners shall make a repayment
The
of
order is dated 20th September 2020.
22, my lords.
Review is when?
Review is filed after that. Your lordship, I may permitted to read that order, my lords. Then I will.
No, before all that I want to know, which order you are seeking clarification?
But writ petition order, my lords.
How can, why should we clarify in 26?
I will convince that, my lords. Your lordship, I permit to read further 3 lines, my lords. Matter for some time now fairly agrees with the suggestion of this court that petitioners shall make a repayment of entire amount due, including the interest accruing thereon, with an outer limit of 4 weeks. And the same shall be accepted by the bank. Until then, no coercive proceedings shall be taken against them who have undertaken to deposit a sum of rupees 10 lakhs only to the respondent bank within a week. Should the petitioners fail to discharge the undertaking given to this honorable court and to the respondent bank, it is open to the respondent bank to take physical possession of the property, treating this order as the one made under section 14 of the Surface Act 2002, it hardly needs to be stated that if the petitioners make entire payment as undertaken, the security document shall be returned to the concerned forthwith, Your Lordship. After this, my lords, in compliance of the order passed by this honorable court, within 4 weeks, my lords, I have cleared entire loan amount, my lords. Your Lordship may kindly come to the statement provided by the petitioner, my lords. Within 4 weeks, I have cleared entire amount, my lords. Access to the possession notice. In the possession notice, my lords, there was a amount outstanding is
The clarification required now.
interest accrued thereon, my lords.
I will not. Why should we do it?
No, my lords, actually, my lords, 2 crores 33 lakh.
Having filed a review, you cannot seek the original or clarification of the original order.
No, we have sought clarification of the order in the review, my lords. But in the review, there was a scope of the review is limited purpose. For that reason, my lords, this honorable court given liberty in the review petition to file a appropriate application for clarification in the same writ petition. My lords, for that reason, we have filed a application in this.
It's not a clerical mistake that you're really seeking a
For that reason, for that reason, review was not maintainable and liberty has been given to my lords.
As on the date, if the judge has asked you to pay the interest also, it is an appealable order, not review, not clarification.
My lords, we have paid entire amount. We have completed the order. They should return back the documents, my lords.
That is a contempt if they are not doing it. For that also, no clarification is required.
My lords, your lordship may kindly come to the your annexure B15, my lords. My lords, we have paid entire excess to that, my
We are
lords.
not here to clarify the order. Order is fast, order is very clear that interest and so accrued has to be paid. After that, they have to return the documents.
Please,
If they are not returning the documents, you have to file a contempt.
And also we have issued.
And if you say
Please.
that interest part, whatever is stated is wrong, file an appeal against that order. We can't clarify it in
My
a.
lords, as far as the impugned order is concerned, my lords, in the writ petition, my lords, after the entire amount paid by the petitioners, my lords, we have issued a legal notice to the bank also, my lords, for return of the documents.
That if they are not doing it after complying with the order, your remedy is not to seek clarification of the order. Please come.
My lords, I may have permitted, my lords. Your lordship may give liberty to file a contempt, my lords.
Why should we give a liberty?
My lords, because my lords, after that, my lords, review came to be filed. In the review petition, your lordship may kindly come to
Whatever,
order.
if it is, it should be in accordance with law. The writ petition is, the present IA is filed seeking clarification of the order dated 20th September 2022. Then counsel submits that the court has observed that petitioner shall make repayment of the entire amount due, including the interest accrued thereon, within an outer limit of 4 weeks, and the same shall be accepted by the bank. Further, the court has observed that if the petitioners make entire payment as undertaken, the security document shall be returned to the concerned forthwith. It is submitted that seeking clarification of seeking review of this order, they filed a review petition. Review petition came to be dismissed on
Disposed of with liberty to file a clarification application on 4/2/2026, my lords.
4/2/2026. It is disposed of giving liberty to the petitioner to seek clarification of the order, and as the review is not maintainable. Now the petitioner, the learned counsel appearing for the petitioner submits the clause that is incorporated with regard to the interest needs to be clarified. And the petitioner has paid the entire amount and the respondents have not returned the original document.
Entire amount as per the order passed in the.
As per the order. And why are you seeking clarification of interest? Without interest you have paid.
No, my lord, with interest we have paid, my lords.
Then why you want clarification?
For that, my lords, that is not, interest occurred thereon means, my lords, as on the date of disposal of the writ petition, my lords, we have paid the, along with interest, we have paid the amount, my lords.
It is, what did you write? Have not returned the documents by virtue of the order dated 20th September 2022. If the respondents have not returned the documents after the petitioner complying with the order passed by the court, the remedy available to the petitioner is elsewhere, but not before this court. Hence, this court, the petitioner by way of a clarification cannot seek the implementation of the order dated 20th September 2022. Hence, the IA is disposed of giving liberty to the petitioner to avail the appropriate remedies in accordance with law. Yes.
22,
Appearing for the respondent
Ananta
number 3,
Krishnamurthy.
I filed the application for vacating in.
In this case, many documents are Kannada, most of the documents. Most of the documents are in Kannada. I'll file translated copies and argue the matter. Likewise.
This is matter
on 16th.
on 16th of March. By the time all the Kannada documents, translated copies shall be filed. Yes, next.
23, Vasudevan.
My lord, in this case, now that moratorium, his matter has been admitted by NCLT, the moratorium is started now. And in place of the corporate debtor, my lord, RP has stepped in. There is an application filed before NCLT for replacement of the RP who was previously appointed. That is coming up on 18th. Now, technically, my lord, the new RP has to continue the matter on behalf of the corporate debtor. And in view of the operation of the moratorium, my lord, the matter needs to be stayed until the CRP process is completed.
I don't think the matter needs to be stayed. This, they have challenged 13-2, my lords, the order of the DRT. That will have to go.
Why should we
Why
know
should
when the
that
matter is seized off by the NCLT, whatever remedies
that-
available to, even they cannot, they also can't proceed. The
That-
bank also can't proceed. When the moratorium
He
is
has only
in,
challenged the petitioner.
that you can establish
Very well,
there.
my lord. The reason what I'm submitting, my lord, is that as on today, the moment the CRP process commenced, the RP steps into the shoes of the corporate debtor. Now the RP needs to, my only request is that the 18th, the application filed by the bank before the NCLT for the replacement of the RP is coming up. Once the RP is confirmed, so he'll be able to stand before this court and either to withdraw the matter or to continue the matter. Or
There are three
present the
petitioners
arguments.
here. My learned friend should remember, last time he made the same submission. Second petitioner says, I am the director and chairman. The third petitioner is a guarantor who's the wife. Now the first petitioner is the company. Whatever contentions they took here, twice from NCLT, it went to NCLAT to the Supreme Court. Ultimately, the
Let
Honorable
NCLT decide all that.
No,
this is
No, if the moratorium is in force, no, the bank can't proceed. Why should the matter be pending here?
That is the reason, Lord. Let the RP come in and withdraw the matter or prosecute the, any orders by this court, Lord, let me be made in the presence of the RP is only my request. Now I cannot even address
No,
arguments.
you are not, I said, this is what is your submission, and I'll record that, saying that it is
I'll
not
leave it.
necessary. Yes, do that.
That's the Supreme Court's order last time.
No, I'll be disposing of this petition with that, like, the 90, section 90 petition or
Section 17 petition.
17 petition before, no, NCLT.
In section 14, as per section 14, moratorium is operating. Section 7 petition before the NCLT.
So, because moratorium is operating, so now.
Your Lordship may record this order of the Supreme
Yes.
Yeah, in view of this, my lord, the matter has been admitted.
Because the company has been directed to be wound up.
So, only
This is-
The present writ petition is filed by on behalf of by the company, that is,
Your Lordship should get that, I don't know the page numbers.
where do you get the cost title?
Cost title, I don't have the page numbers.
The Metal Closures Private Limited, represented by its managing director.
Who is the second?
Who is the managing director?
Second petitioner.
Represented by the managing director, that is the second petitioner. And who is the third petitioner?
Guarantor.
And the third petitioner is the guarantor. The writ petition is filed seeking the following prayers. Where are the prayers?
At page number 6.
There are two orders.
60, my lord.
It's 64.
Page 60, my lord, all the prayers.
So they have filed the writ petition. Seeking the following prayer. View that order sheet.
Second petitioner.
Coordinate bench of this court on 24/4/2024 has granted an order of interim order of stay that is extended from time to time.
Stay was, my lords, their application before DRT was dismissed.
One
That
minute,
is,
1 minute. It is extended from time to time. When the matter came up today, then counsel appearing for the respondent, senior counsel appearing for the respondent submits that the Honorable Apex Court in Civil Appeal number 477 of 2022, dated 12th February 2026, has passed an order
dismissing the appeal file. In the first page, your lordship, page first para, that's filed by the second petition.
submits that the petitioners before this court has preferred a SLP
Second petitioner, right?
second petitioner has preferred an SLP questioning the order of the NCLAT dated 17/12/2021 passed in company appeal number 68 of 2009 and IA number 1078 of 2021. Where is the finding?
That's a finding of NCLT para 14, running page 8. Page 8 it starts, my lords.
Page 8.
Where the NCLAT has dismissed their appeal.
By order impugned dated 17/12/2021, the NCLT has dismissed the appeal of the managing director and held that section 7 application is within time. The Apex Court has affirmed the said order. It is submitted that now the proceedings are pending before the NCLT and the moratorium is in force
Only against the company, not against the guarantee.
against the company.
Corporate.
Against the company, and the second petitioner cannot represent the company before this court. It is submitted that cannot represent the company before this court. Then counsel appearing for the petitioner submits that now the bank has filed an application for change of
RP,
RP and the same is pending consideration.
coming up on 18th of this month.
Coming pending consideration, same is coming up on 18. It is submitted that once once that is ordered, then the petitioner can take up, will submit the same before the court and the court can pass appropriate orders. Next one. The undisputed fact in this case or that the moratorium is in force. As long as a moratorium is in force, the bank cannot take action against the company. Corporate debtor. And now this writ petition is filed on behalf of the company represented by the second petitioner. In that you have second petitioner, second petitioner and the third petitioner. But though he filed, but it can be represented by only second petitioner, company.
Company, my lord, but then the moratorium will operate only against the corporate debtor.
That's what.
Not against the guarantor.
So now the writ petition is by the company. So represented by the respondents. No, it is, now the company is what is matters before the court.
Good.
Did you write? Company, second and third respondents in view of the moratorium that is that's subsisting as far as the company is concerned in the considered opinion of the court. Now the proceedings under section, the proceedings that are challenged before the court do not survive for consideration, and if any, whatever the remedies that are available to the parties that can be agitated before the NCLT. In that view of the matter, the writ petition is disposed of in the writ petition accordingly. Nothing survives for the consultation in this writ petition in view of the pending moratorium. Yes, next.
24, S. Rajshekhar.
Yes.
So I pay for petitioners. Petitioners are, my lords, neither the borrowers nor the guarantors. Lords, respondent number
I
2.
think the e-auction
Yes,
sale
please.
notice issued by the first respondent.
Yes.
What happened?
Is it deferment? Deferred, my lords, pursuant to the interim order granted by this honorable court, my lords. The reason why, my lords, I am before my lords is, lords, the second respondent is the borrower. Lords, he enters into an agreement of sale, my lords, with the petitioners and various other persons, my lords. He is a developer. Lords, he,
His agreement of sale.
my lords, agreement of sale, B series, my lords, I have produced from 2018 till 2021, my lords. It varies from 2018 till 2020.
What is that, 18 to 21?
My lords, petitioners are, my lords, there are, my lords, totally about 37 or 39 apartments. Lords, so the present petitioners are, my lords, 2018 to 22.
How many are the petitioners?
Petitioners, my lords,
How can there be a writ petition of this nature by these many
13
people
petitions.
when they are claiming their independent right by way of different documents?
my lords, respondent is, my lords, the
Might be.
auction
But
sale
this
is,
is you're
my lords,
saying
now
about
the,
an
now the
agreement of
auction
sale.
sale, what they have brought is, my lords, for the entire
And
property.
you must be claiming different properties.
My lords, now different apartments. my lords.
That's what.
Different
How can one
apartments.
single writ petition be maintained?
Let's kindly see annexure A for a moment, my lords. Annexure A for a moment. They have brought the entire apartment, my lords, the property for sale. That is why we have joined together and, my lords, filed the writ petition.
Is it a tripartite agreement?
Lords, it is not a tripartite agreement.
Oh.
We are the we had agreed, my lords, at the time of development of the property itself, with an understanding that, my lords, he will clear the loan and execute the sale deed in our favor. Lords, he did not do so, resulting in, my lords, we approached, my lords, RERA authority, consumer court, my lords, civil court, and also, my lords,
By way of the agreement of sale, what did you pay to him?
my lords, we have paid substantial amount, my lords, 30 plus 30 lakhs, 32 lakhs, my lords, the petitioners have paid substantial amounts. And so far as that aspect of the matter is concerned, there is no dispute, my lords. They are not disputing it. Now, conduct of, my lords, second respondent may kindly be seen for a moment, my lords.
Who is the second respondent?
Second respondent is the borrower. My lords, he writes a letter, kindly turn to page 228 for a moment, my lords. When this property was brought for auction, my lords, in the year 2022, lords, he writes a letter to the residents, contending that, my lords, the property is brought for auction. You please pay the amount, balance amount, and, my lords, I'll pay the amount to the bank, and I'll, my lords, see that the loans are cleared. That I have produced, my lords, at annexure J, page 228. Subsequently, he goes to the bank and, my lords, addresses a letter saying that I am not in a position to clear the loan, since the loan is due from my end. Some of the persons are in occupation of the property unauthorizedly.
When was the property mortgaged to the bank?
My lords,
When was the property mortgaged to the bank?
2015.
2015. So his mortgage is, he has a prior charge?
Lords, the understanding was, my lords,
No,
that is-
no. Here, as far
Yes.
as the bank is concerned, now we are only concerned with who has a prior charge.
please,
Bank has a prior charge.
lords, bank has a prior charge with regard to the project loan, my lords. This is only for the entire project loan.
No, your dispute is with the second respondent.
Yes, please.
If your dispute is with the second respondent, you have paid the money.
Yes.
You want that money to be recovered, you have a remedy elsewhere.
Now,
You cannot stop
it is
the bank
not the
from.
question of, my lords, not only, my lords, that is why I said, my lords, series of litigations are there. And some orders are also passed. Now, my lords, kindly see the division bench order of this honorable court in commercial, my lords, appeal, wherein, my lords, our possessions are also, my lords, protected. Kindly go to page 255. Lords, when they wanted to, my lords, dispose us.
In that case, if your possession is protected, then therefore, if they.
That is insofar as, my lords, some two or three petitioners, not all the petitioners.
Then in that mode, in a commercial appeal only, commercial suit only, you have to have your remedy, but not in the writ petition.
My lords, my respectful submission is, my lords, when second respondent has played fraud on the, my lords, the bank, as well as the petitioners. Lords, now we have suggested, my lords, there is one commercial unit, my lords, which is still at the, my lords, hands of the second respondent. We said, my lords, we will being the owners of the, my lords, apartment, or, my lords, the purchasers. Lords, we said you bring it for auction, we will participate, we will buy that property, so that your liability will be cleared. That we, my lords, in fact, suggested to the bank also. Let them bring it for auction, my lords, that particular commercial property which is with them. Lords, instead of bringing the entire property for auction, their liability will be cleared if that particular property is auctioned. We will purchase that property as an association.
No, that is the inter se arrangement or the private arrangement between the
Yes,
parties. The court cannot express anything on that. And why don't you, when your other similarly situated people are having a benefit of an order from in the commercial suits, why don't you people go there and get it? Because it's already, you say that the division bench has confirmed that order.
Lords, now in some cases what happened, my lords, there is a direction to refund by the consumer court. But we are put in position pursuant to his own letter, my lords, in the year 2022.
Because now it is nothing but expanding the scope of 226.
My lords, I know, my lords.
You can understand in this tripartite agreements.
Yes.
Where there is some, they don't have the property. And there
May
is a
I
fraud.
trouble my lords to kindly see the order dated 21/8, my lords, passed in this split petition itself, my lords, for a moment. While granting the interim order, my lords, sir, direction was issued to the bank as well.
21/8/2025,
my lords. Fourth paragraph.
21/8.
21/8 minutes.
Unfortunately, we can't extend all this, can't decide also all
Lords,
these issues in a writ
the
petition.
petitioners, my lords, grievances, my lords, they have approached various authorities and my lords, they have the orders at their hands. Now, my lords, at this juncture, my lords, if the bank proceeds and brings this property, entire property for auction, but we are all about 38 apartment purchasers who are put in position, my lords, in the year 2022 when this property was brought for auction by the very same bank. That is why, my lords, I requested, my lords, bank was directed to produce, my lords, certain documents also. Kindly see para 5, my lords.
No, more or less, we are sitting on a commercial suit.
I know. Kindly for a moment, my lords.
Exercising jurisdiction under 226.
Para 5 of the order, my lords.
No, it is like this.
I know, my lords.
We can write 101 reasons to entertain a writ petition.
At this stage, when the e-auction is, I know, my lords, where do I stand? But still, my lords, para 5.
Yes.
At this stage, when the e-auction is scheduled to be held on 22/8/2025, the question for consideration will be, is the first respondent bringing the property that is under development to auction under the proceedings of Secularization Act or so and so Act?
So the tripartite agreement.
Yes.
That is not, there is no tripartite.
There is no tripartite agreement, my lords. So there is no tripartite agreement.
It is simply a dispute between the owner and the,
Lords,
the landowner, the builder and the purchaser.
Yes.
It has got the color of a writ petition, that's it.
Ultimately, my lords, now the orders passed by, my lords, various authorities, either consumer court or RERA authority or, my lords, the commercial court and also, my lords, civil courts.
The court has got all the sympathy for the petition.
Please, my lords.
But the problem is we can't decide these things.
Just because of the conduct of second respondent, my lords, we are, my lords, made to suffer. That is why, my lords, we, in fact, on the last date of hearing, I requested my learned friend.
Yes, Mr. Counsel, what do you say?
In this case, my lord, the loan was sanctioned to the respondent number 2. And as usual, the 13-2 notice issued and the account MP, and then they issued possession notice and they issued sale notice. And the sale notice was issued. Some of the persons, they are not the owners. Till today, they are not the owners. Because second respondent being the owner and builder, he has not
executed the sale deeds in the favor.
So now the bank wants to sell this property to recover the amount. The amount has come to about 7 crores. Now that when sale notice was issued, then they say the approach to the court says they don't defer the auction. Now it's auction. Now, my lord, because we also, what your lordship said, they are also in difficulties, they paid money and lot of problem is there. Now what I discussed with the bank also. What is the thing what we want to do, my lord? Your lordship may kindly, that this interim order, kindly permit the bank to sell the property. Now what will happen? Nobody will come for purchasing property. That is number 1. Number 2, even in case this honorable court says that don't confirm the sale. Now what is the position? Why I am telling this is as per the credit policy of the bank. Once the account has become the NPA and they initiate the action, then 2, they have to conduct the auction. If they fail to conduct the auction, then they can accept the OTS given by the borrower. Now the borrower has come forward with the bank, as I rightly said, that he is prepared to sell that commercial property, all those things will pay, provided the bank accepts their OTS. For accepting the OTS, one exercise has to be done. That is what the credit policy of the bank. They say that you have to go for the auction. If you are not successful in the auction, then he can come for the OTS. That is why if that is done, we can help that even those people who are occupied, illegally occupied that flats, they can become the owners. I think they have paid substantial
No,
amount.
in the process of that auction, pursuant to that auction, if somebody participates and again third
Not
party,
confirm
right?
that. This will not be given. It will not, bank will say that bank will not confirm the sale. And these people, already that person is coming for OTS. Or then that amount can be taken. This is only because, this is only the suggestion of discussion with the bank. But otherwise, my lord, the bank has got every right to sell the property and recover the money. Now, it is between the borrower and the bank. And these people, that the bank is not concerned. As your lordship rightly said, there is no triparty agreement. At least some hold is there for them. There is nothing is there. So legally, bank has got every right to sell the property and recover the amount.
Is what you said.
That is why I fairly submitted, my lords, let this matter be referred to mediation. So that, my lords, we will buy that commercial property.
Mediation
They
means,
can't, how can they enter into?
mediation, how can the bank, how is the bank?
Lords,
mediation
otherwise
means
what
that-
happens, my lord?
No, it is between you and the second respondent. It's
Yes,
a
lords.
different
Now
issue. How will the bank, they have their
now
own
the
procedure
We are
to
not-
conduct the auction and
Since
what
the
is the
second-
under the surface
since-
act?
Since the second respondent has come forward to settle the, my lords, outstanding amounts under OTS. Lord, so he will also get some money, my lords, if we purchase.
What are the orders you have against the second respondent?
My lord, second respondent, we have, my lords, in some cases, my lords, refund. Refund. And some cases are pending for adjudication, my lords, before the competent civil court, before the commercial court. In RERA authority, my lords, refund is also ordered. I have produced all those documents along with my writ petition. These are the orders, my lords, which we have. Ultimately, my lords, what happens, my lords?
Even for to file a civil suit also, now it's barred by limitation.
Now, my
for
lords,
your,
in some,
parties.
most of the cases have, my lords, civil suits are filed, my lords, and
No, no, in these cases, I think these
these-
parties might
these-
not have filed,
no,
otherwise how would they
they have filed civil suits also, my lords. That is pending adjudication before the jurisdictional civil court. In the meantime, my lords, since the bank brought this property for auction, it's left with no other alternative, my lords, since matters are seized off before the civil court and other authorities. We filed the writ petition. That is when, my lords, this honorable court directed us to pay deposit 2 lakh rupees as, my lords, tomorrow for any reason, if, my lords, I am at fault. That may be compensated, was the, my lords, view taken by this honorable court. Now the fact remains, my lords, bank is worried about their money. We are saying, my lords, we are ready to purchase that property, release that property. You will be, my lords, getting your money. We will be relieved.
Now, what about the conducting auction to that commercial, that is also stayed by this order?
No.
No, my lord.
Then why don't you conduct auction for the commercial property?
No, commercial, there is not the commercial property and all the entire building has been constructed now. These 13%, they have forcibly occupied. All others, they have not occupied because there is no sale deed, nothing is there. Now, if this is done, if he wants bank to OTS, then he may try
So
to sell
without
the
a
property.
sale deed, now you are in possession of the property.
My lord, sir, that is what,
If you want to
when
sell
this property was
sell
brought,
mortgage property. My lord, if the bank wants to sell, mortgage property has to be sold. Mortgage property means everything will come under the mortgage only. So.
No, why don't you do it in a phased manner? It's also like you will ultimately, what you want is you want to realize the money. No, by doing it in a phased manner, if you're able to realize the amount, what's the difficulty in
My lord,
that?
if this stay order is vacated, bank they will do that. They are also don't want to inconvenience those people. That respondent two will come forward. He will say that I will sell the property, commercial property. Bank will get the money. But the only thing is because of the stay order, we are unable to. That is what I'm telling, my lord.
that is
If
what
the stay
even I
order
am
is
submitting.
vacated,
No, this stay order is pertaining to the entire,
This is,
that mortgage property, entire property.
so then we'll do one thing, we'll vacate the stay.
Yes.
As far as some floors are concerned or whatever that commercial property they're
Commercial
saying,
properties.
that I'll modify this order.
Vacate the stay order, my lord. Vacate the stay order, then that bank.
No, what we do is, now if this order is modified, you will be getting an opportunity instead of whatever, no, in terms of what the landowner, the builder is saying and protecting their interest, protecting the bank's interest, this would be the via media.
If commercial property, how much it fetches and all those things has to see. The commercial property.
You will
you are
do
not
it
able to
later. No, you can do it later also, once the stay is vacated. How many floors are the
Stay is
commercial
vac-
property?
commercial property, one entire, my lords, one floor.
One floor, that is which floor?
That is in the ground floor, my lords, if I am not wrong, my lords, ground floor.
I also, these are problems which are.
No,
in Bangalore.
do one thing. I'll take up this matter tomorrow, day after tomorrow, whenever you want. you get instructions. What we will do is first, as far as this, wherever is a commercial ground floor or first floor, whatever it is, you please get instructions. To that floor, we will vacate the interim order. As far as that floor is concerned, now you sell the property, you get, if the amount is fetched, you have no problem.
No problem.
So that's why get the instructions.
Take it tomorrow. It might happen.
Tomorrow.
Tomorrow.
Does this matter tomorrow?
Let's,
At the request of,
could it be day after tomorrow?
day after tomorrow.
Please.
At the request of land counsel for the respondent bank. Yes, next.
Interim order.
Interim order earlier granted is extended till then. Yes, 25.
Great.
Kalyan R.
For petition. My lord, there was a direction to the respondent bank to file statement of objections.
What is this matter about?
My lord, in this matter, my lord, this matter was heard for some time, my lord.
Respondent shall
wherein
file
the
their objections.
Objections, my lord. Here is a case where, my lord, the
Have you filed your objections?
We are for Union of India, formal parties, my lordship.
You're representing Union of India. Respondent is only Union of India.
no, my lord, bank is also a party.
Who appears for the bank?
My lord, Vignesh Shetty appears.
Where is he? Where is Vignesh Shetty?
Vignesh Shetty.
Copies not served.
Copy is long back served. He appeared twice.
My lord, copies
And now
not
they are
served.
saying, even on the last date of hearing, they made submission that they'll file statement of objection.
This matter came up on 17/12/2025. This court says the respondent shall file their objections. Then on 31/2026, it has come up. This court on 17/12 had directed the
Some other
respondents to
counsel
file their
filed
objections.
Vakala.
Till now, the same is not filed. List this matter on 4/3. By the time shall file, or else the court will be constrained to pass orders on the merits of the matter. Ask him to come.
My lord, some other council filed wakalat, my
Huh?
lord. Some other council filed wakalat.
Some other
Even-
counsel, not you.
No.
Who is the other counsel?
Suresh.
Where is he?
Suresh HS.
It appears
Suresh,
for,
it is the Union of-
Delete the
Union
name
of
of
India.
Mr. Vignesh Shetty.
Union of.
No, my lord, Suresh appears for Union of India. And
No, my
other
lord.
than Vignesh Shetty, no one has, even the Vignesh Shetty
Suresh HS for R1.
R1.
We handed over file for branch only, my lord. Some other council appearing for this matter.
Ask him to come. Ask Mr. Vignesh Shetty to come. Yes. Next.
26. Sarath Kumar Shetty. 26.
No representation for dismissal tomorrow.
27 and 28. Rajendra MS.
Lord, serial number 27. The petitioner has paid the entire amount to the society. And it may be closed as infructuous.
Petitioner has paid the amount.
Entire amount, my lord.
Who appears? It is submitted with the land counsel. The petitioner submit that the petitioner has paid the entire amount to the society and the writ petition has become infructuous. Dismissed as infructuous.
Serial number 27.
27.
Hari Prasad. Hari Prasad.
No.
Advocate name.
Nagarajappa.
That is in second district. Verify. This is
Sorry,
first
my
one,
lord.
Petitioner.
Your matter, 28.
28.
Yes.
But some documents filed by myself and the other side are in
No, let us
Varnagal.
understand what is it.
Yes.
What is the writ petition? Please come to that.
One. The writ petition, my lord, here the petitioner, my lord, after his graduation in a bachelor.
Come to the prayer.
Prayer, my lord, seeking compensation
Come
of
to
65.
the, come to the prayer. Where is
Yes,
it?
my lord, yes, my lord.
Page number.
Page number is
Declare that inaction, negligence, lapses on the part of the respondent resulted in electrification of the petitioner. Directing the respondent to compensate the petitioner, awarding amount of rupees 65
lakhs.
lakhs. What is the procedure under the act?
Lord, I'm relying a judgment passed by this honorable court where
Let's not go to the judgment. First, you tell the court what is the procedure that is under the act. Then we'll go to the judgments. Yes, Mr. Counsel.
That under the act, that where the incident happened,
What is the act called?
the Electricity Act 2003.
Give that
The
act.
Electrical Act 2003 provides that the inquiry requires to be conducted by the electrical inspector. He has to submit a report. If the report is not the negligence on our part in the supply company,
What happened in this case?
That this case report is comes that there is no negligence on our part. Even their own complaint before the police station against the
No, no, no.
landowner. That the
When?
complaint, FIR registered against the landowner. Only that after lapse of 3 months that where the incident happened in the month of November 2019, that gives a representation
No,
only
let's
compensation.
please go slow. What are the dates, please tell the court.
My lord,
That incident happened.
before that, my lord, one thing, my lord, to clarify, he's from Haryana, my lord. After completion, it's, he was alone, my
I'll
lord.
hear you also. I'll hear you. Let us have the, yes. When was the incident taking place?
The incident, the alleged incident took place, may kindly be
Date of incident?
25/11/2018.
7/5.
25/11/2018.
25/11/2018.
18. That he lodges a complaint before the police station.
On?
On 5/12/2018.
5/12/2018.
That to the representation given to the BESCOM.
What is complaint to the police?
Allegations against the owner of the building.
What is
where
that?
he has violated the constructed the building.
Is that annexure? I filed the complaint copy.
The building, that landowner violating the rules and constructed the building without getting clarity, the clearance from the line. Line was in existence in the previous. That FIR registered against the landowner. There was no communication to the BESCOM. Only on 2/2/2019 that the representation annexure A was submitted. 2/2/2019.
45 days later, then the, my lord, the.
I'll hear.
Then that on
2/2/2019, he gave a complaint to BESCOM.
Representation to consider compensation. That immediately that we have came to know that on 7/2/2019 intimation was given to the electrical inspector because of his report is required. The same on 7/2/2019 the intimation that electrical inspector inspected the spot. Then that he has submitted a report.
Report dated?
Report dated that it is an 2021.
2021.
2/6/2021.
2020.
21.
20 or 21?
21.
What is the date? 21,
2/6/2021.
2/6/2021.
But inspection was conducted on 7/2/2019 itself.
So for how many days is pending? For 9 months?
The nine months.
It is almost 1.5 years.
1.5 years.
What is he doing for 1.5 years?
That's the electrical inspector who is the officer of the government. He has to give that he is also as a made a party thing.
No, as per the act.
No, he has not made. As per the act only that they have to electrical inspector who is the officer of the state, not an officer of the BESCOM or a supply company. He is the state of the.
No, he submits a report.
Yes.
If the party is aggrieved by that, what is the remedy available?
That against that report that appeal provides is there that 162 Electricity Act.
Section 162.
Yes, that the report is 161.
Appeal to the whom?
Chief Electrical Inspector.
Chief Electrical Inspector.
Inspector.
After that?
After that there is no penalty.
Then the writ petition.
That if the report comes against us, that we will pay some reasonable compensation. That earlier that they have to go before the suit in.
No, he has availed the appeal to the chief.
That they are not challenging that report is.
But based on the report, he has come here.
The report, not in based on the representation he has come. 2/2/2009 representation seeking for compensation.
Yes.
Kindly see, my lord, the report is very important. This is self-contradictory, the report on which they are relying, my lord.
When the act provides that.
No, I'm not challenging the report, my lord. I'm not challenging the report. I have come here seeking compensation for, my lord, having lost my right hand, my lord.
Give the act. You have the act. You have the act. Please look at 162.
That is to, my lord, to challenge the report
Not
submitted.
to challenge the report. If you're not happy with the
No,
compensation.
it is not against me, my lord. It is not against me. They say it's against me. It is not against me. In the report, the inspecting authorities clearly says, no, it is the.
Look at this. What 161 says, what 162 says. Let's read it. 161, please read.
One 61, my lord, the notice of accidents and injuries. If any accident occurs in connection with the generation, transmission, distribution, supply or use of electricity or in connection with any part of the electric lines or electrical plant of any person, and the accident results or is likely to have resulted in loss of human or animal life or in any injury to human being or an animal, such person shall give notice of the occurrence and of any such loss or injury actually caused by the accident in such form and within such time as may be prescribed to the electrical inspector or such other person as aforesaid, and to such other authorities as the appropriate government may by general or special order direct. The appropriate government may, if it thinks fit, require any electrical inspector or any other person appointed by it in this behalf to inquire and report as to the cause of any accident affecting the safety of the public which may have been occasioned by in connection with the generation, transmission, distribution, supply or use of electricity, or as to the manner in and extent to which the provisions of this act or rules and regulations made thereunder or any license so far as those provisions affect the safety of any person have been complied with. Every electrical inspector or other person holding an inquiry under subsection 2 shall have all the powers of a civil court under the Code of Civil Procedure for the purpose of enforcing the attendance of witnesses and compelling the production of documents and material objects, and every person required by an electrical inspector be legally bound to do so within the meaning of section 176 of the Indian Penal Code. Here I'm not, these things I have already done, my lord. They have conducted inquiry and they have filed the report, my lord. I'm not agreed by that, my lord. That report itself is in my favor.
Then what is your agreement?
My lord, I'm seeking compensation, my lord. I have lost
You are
my.
entitled for compensation. If compensation is not granted, or you are not happy with the compensation that is granted, there is a remedy under section 162. Why should you come before this
That
court?
is, my lord, that's why, my lord,
is
this
not
honorable
necessary.
this honorable court in writ petition, thereafter in writ appeal, have held, my lord, writ petition is maintainable. Under a strict liability, they are liable to pay the compensation, my lord.
I'm not saying that writ petition is not maintainable. When you have an alternative remedy, why you are not happy with an order that is not granting compensation. Not granting compensation, that's what it says. You should go before the appellate
Only to
authority.
conduct the inspection, my lord. It is to conduct the inspection, my lord. Notice of accident and inquiries. But they have taken the notice.
Yes.
They have conducted the inquiries,
Please
my lord.
come to your pleadings, please. Yes. What is that you want?
Lord, for that, my lord, I rely upon the judgment passed by this honorable court, my lord, where this honorable court held that, my lord, writ petition is maintainable. The reasons this court has given, my lord, for that, my lord. My request your lordship to, my lord.
No, not writ petition is maintainable. What is that you want the court to do?
Lord, to, my lord,
How will this court assess the compensation?
Yes, my lord. That is also discussed, my lord. Applying the Sarla Varma judgment, my lord, calculate, my lord. I have given, my lord, my credentials regarding my graduation, my salary slip, my lord, and considering my age and the multiplier, my lord, in the same manner, the court has considered, my lord.
There is no mistake on the part of the department.
So there is a mistake, my lord. I go through the report they have submitted, my lord.
Problem is for everything you have an answer, may not be appropriate answer. Now, you said your report is in your favor. Report is in your favor, then why did when they said that they are not responsible for this accident, how the report is in your favor?
Lord, in the my lord, in the inquiry, they have said, my lord, it is violation by the BESCOM, my lord. In the Canada, they say, my lord, BESCOM over notice kottilla. They have not complied with the regulations, my lord. The last portion, my lord, I will
Yes,
just.
Mr. Counsel, you are saying that.
That report says may kindly be ಸ್ಥಳದಲ್ಲಿ ಅಪಘಾತ ಆಗಿರುತ್ತದೆ ಅನ್ನುವುದು ಸಾಕ್ಷ್ಯಾಧಾರಗಳಿಂದ ಕಂಡುಬರುತ್ತದೆ.
They have reached, my lord.
Does it mean
that there is no incident happened in the spot it heart alleged
the
in that.
petitioner shall place before the translated copy of the report of the inspector? Place this matter on 16th of March.
Obliged.
Yes, next.
29 adjourn, 30. Nagaraj Naidu.
Lordship, appearing for a petitioner, a small request, your lordship, they argue, a small request, your lordship, the arguing counsel is undergoing lymph node treatment, your lordship. She's been advised for 2 weeks to take rest and she's not coming, if it's possible.
Yes, it is submitted, but the learned counsel for the petitioner is not well. Liz this matter after 2 weeks. Look at it. Oh, you are repairing, I didn't see.
Interim order is operating every time it's, please see the.
But now they're saying that some
I
medical
understand some
reasons which
date
we.
finally, I understand, my lord.
This is
because
matter on
13 to
16th of
13/4.
16th of March. On the day, if it is inconvenient to the counsel for the petitioner, alternative arrangements shall be made. No further adjournment.
Please, your lordship. Grateful.
Yes, next, 31.
31, K.V. Narasimhan.
Lord, in 31, by oversight, the file is not brought to the court. By oversight, my lord, the file is not brought to the court, my lord. Any date may be given. In fact, we have moved the matter before the last roster. It did not reach for 3 consecutive times, my lord. We are ready with the matter. Any date may be fixed.
Is this matter on 10th?
Lord,
10th
10th, my lord, 16th, Mayor. 16th.
No, there are so many matters on 16th. This is matter on 10th.
You will also have it 17th, my lord. 17/3.
I can have it in the month of April, not any other dates. List in the month of April, April 8th.
My lord, on similar note, on similar prayer, a SLP is said to have been pending before the Supreme Court. It may not possible, we are subject to that only we can able to answer.
Yes, list in the month, it is submitted that SLP is pending before the Honorable Apex Court. List this matter on 27th of April. Yes, next.
Great.
32, Leader Prabhu.
May it please. This matter, my lord, I was asked to give a representation to the office of the AG. In fact, my lord, a unique case where the Honorable Supreme.
Let us look at your prayer.
Yes, the prayer, your lordships will find on page 14, my lord. Sorry, 13, my lord. Issue a writ of certiorari quashing the notice dated so and so. Now, the
Quashing the notice.
C, yes, annexure C is the notice, my lord.
Who is the fifth respondent?
It is, my lord, the regional commissioner.
And Chairman
Yes,
Bandipur
yes, that,
Eco-Sensitive Zone. Monitoring
Eco-sensitive zone.
Yes.
Yes, the issue is this, my lord. I have constructed a dwelling house in this area. It is a revenue land, revenue pocket, and I have constructed a house now. Now, while I was.
You mean to say it's a patta land?
Patta land, the revenue land. Their claim is that it is ESZ, eco-sensitive zone. And the eco-sensitive zone regulations provide for a regulated, controlled or prohibited activities. Now, it is true, my lord, that before my construction commenced, the Honorable Supreme Court had laid an embargo on the ESZ activities, but not on the dwelling houses. But it was interpreted to be on buildings.
You have constructed a house and
the dwelling house for staying.
What is the extent of land you have?
It is, my lord, 1 acre, 24 guntas.
1 acre, 24 guntas.
Yes.
And in what extent you have constructed?
It is, my lord, I'll take the exact extent, my lord, in a minute's time.
Then what are these regulations?
Yes, the ESZ regulations, my lord, earlier the Honorable Supreme Court had interpreted them to mean that the certain activities are prohibited. But that was modified, and the my lord, the latest order, Annexure E order at page 32, my lord, substantially modifies that. And your lordships will see page 82. Page 82, my lord. The Honorable Supreme Court has held.
Is it the matter which is now, it's
Godavaram case closed by the Honorable Supreme
Court. No review?
No.
Godavaram case is now.
That is with regard to the Aravali, I think.
Aravali's case. Aravali, my lord. This is Bandipur forest.
Godavari is not related to Aravali, my lord. That's Godavaram is an
that
case
I know.
arising out of the Maharashtra case.
That much I know, I think.
Now, page 82, my lord, the Honorable Supreme Court says that the Honorable Supreme Court says we also modify the direction contained. Am I with your lordship? Page 60.
The 64 of the
Yes, modify the order dated so and so. And my lord, they say that your lordships will see direction number 1 on 60, para 66. MOF, CC and all state territories shall strictly follow the provisions of 9th February.
Now we have to see
this.
Yes.
No, I'll just conclude it, my lord. This matter was heard and interim order also was passed that I can construct the house. Now, if at all the Supreme Court order changes or there are any future developments, they can always come back to me and, my lord.
What is the present, what are the rules?
Yes, the
as of
present,
today?
as the things stand today, your lordships will see this order holds, my lord. Page annexure E order at page 82 holds. And the notification.
No, this order refers
Yes.
to 9th February 2011.
Yes.
9th February 2011, there is no prohibition on construction.
No, there was no prohibition.
When was that prohibition?
That interregnum, my lord, your lordships will, it was on 3rd June 2022 that Honorable Supreme Court order prohibited these activities for a brief.
Let's see that.
Yes.
Let's understand from the order.
Yes, yes, my lord. That order, your lordships will see, my lord. Where is that order? Page, yes, I have produced that by way of Lord separate page, Lord 32 of Lord the written submissions that I have submitted on 24th August 2023, Lord.
The
Annexure 2, Lord.
written submission stated?
Yes, 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 yes.
Dated?
Dated for 24th August 23, Lord. May I pass it on?
Yes, yes, yes.
Yes, in
yes.
that your lordships will find page 32 and para 56, my lord, of that judgment. Your lordships will find at page, sorry.
Para 56.
Yes, I'm sorry, my lord. In fact, that paragraph, my lord, is of the SCC online paragraph, but your lordships will see that directions which are, my lord, commencing at page 84, my lord.
Yes.
Page 84.
Yes.
Each protected forest, that is national park or so and so, then, my lord, SEZ minimum 1 kilometer measured from the demarcated boundary of such protected forest in so and so activities prescribed and prescribed in so and so shall be strictly adhered to. That also, my lord, refers to that. But in the event ESZ is already prescribed as per law, your lordships may skip that. Now your lordships may see, my lord, that page 86 on the last and the direction E in the event is already being undertaken within the 1 kilometer of buffer zone as the so and so. Such activities may continue with the permission of PCCF, territory so and so, shall obtain necessary permission. Such permission shall be given once PCCF is satisfied and activities concerned do not come within the prohibited list and were continued prior to the passing of the order in a legitimate manner. No new permanent structure shall be permitted to come up for whatever purpose within ES. That is what, my lord, was held. Now
This order is dated?
Is dated
3/6/2022.
Yes.
3/6/2022.
Page 92, my lord. 3rd June
The
22.
impugn notice is dated?
Notice dated 14/8/2023.
14/8/2023.
Much after.
Now, according to you, how this particular order is modified in the present order?
In the present order, my lord, the lordships will see
Page number?
page annexure E, my lord, page 82.
Yes.
Yes, my lord. There we also modify the direction. In fact, my lord, they have discussed why this merits, my lord, a change, which your lordships will find in the previous
We
paragraph.
also modify the directions contained
Yes.
in paragraph number 56.5.
Yes, your
This
lordships will
was
see
containing in which paragraph?
that paragraph, my lord, it was SCC paragraph, but this relates to the same paragraph that I was reading. My lord. There's no, that paragraph corresponds to, my lord, paragraph number 44 actually in this, but actually it is 56. That corresponds to the same, my lord. I'll produce the SCC version. There's no dispute on that. We both are on the same page. There's absolutely no, there is no dispute on that.
No, court has modified only 56 or
Please,
55.
which is
So
this-
why can't we look at the SCC
I will.
itself?
Your
So that
lordships will
little
find.
clear.
Yes, yes. Your lordships will find.
What is 56, that 0.5?
Yes.
Because by virtue of this order,
Yes.
only 56.5 of the order dated 3rd June is clarified.
Yes, yes. I will produce that judgment, my lord, in a minute's time. I'll have to take out the.
Pass over?
Let me be, yes.
Have this
But-
tomorrow, day after tomorrow.
I'll make one or two more submissions and I'll.
No, that's the only crux of it.
Yes, your lordships will see, I was directed by an interim order to make a representation to them.
Tomorrow, list this matter tomorrow, interim order earlier granted is extended till then.
No, there is no interim order.
Tomorrow?
There is a direction to them to consider.
Yes. Tomorrow we'll
Yes.
consider and pass on.
I'll bring that.
Yes. 33.
33. Vignesh TP Muttana.
The question, my lords, whether surface would prevail over KPID or otherwise, my lord. In fact, my lord, the writ petition itself is not maintainable because, my lords, the petitioner is challenging the correctness or otherwise of the order passed by the Honorable Special Court. And in terms of section 16 of the special statute, my lord, this is an appeal remedy. But I will not press for that. In other words, my lord, the proposition is now well settled. So the Honorable Supreme Court has categorically held, we have had the opportunity of assisting
Yes.
the Honorable Court, my
My
lord.
lord, now this Honorable Supreme Court also says there is no priority. But here our case is, my lord, that is regarding that mortgage, property has been mortgaged in 2015.
No,
Security
whatever
interest
these
been created.
properties are, they're part of the proceedings before the special court. If you are aggrieved or you say that the bank being a secured creditor, you have a dominance or any other creditors, then you have to go before the court and you're not agreed, then an appeal lies against that order passed by the special court, but not a writ petition.
For the time being, I will not press that submission, my lord, because it's a well settled principle of law now.
Your lordship may kindly take up on Monday, my lord, because
Monday.
see this.
At the request of Counsellor, the petitioner, this matter on Monday. Yes, 34.
34. Gopal KB.
Petitioner, my lords.
Hearing for the respondent. Lord.
Ready to schedule the matter, but some time.
No, my lord, I object because this is a possession notice. From 29/11/2025, he's paid 5 lakhs, but then, my lord, then we let it be disposed of. Let him go to DRT, my lord. There is, because he was willing to pay, we have
Petitioner
conducted, but
shall file
otherwise.
an undertaking affidavit mentioning how and when he is going to pay the amount. This was on 13/2/2026.
Even before that,
I'm
my
already
lord.
filed one
No,
affidavit.
that affidavit was not convincing. That's why the court has asked you to pay, specifically stating when are you going to pay. Finally, will grant time till 9th March. It's the matter on 9th March. By that time, if the undertaking affidavit is not filed, the court will pass orders on the merits of the matter.
35.
Appear for the petitioner in this matter, lordships. Seal number 35, seeking a short accommodation, lordships. My colleague is on a different court, lordships. So hence seeking for a short accommodation, lordships. In this.
Who appears on 35?
I appear for the
What
respondent.
about this?
Lord, this is in fact, they have the third party, my lord. Third party has challenged the possession notice. And they claim to be in possession, whereas so this, my lord, let them go to DRT, my lord, because even third party also,
It seems colleague is in Supreme
It's held up in a different court, lordships.
matter on 9th, this also on 9th.
Yes.
At the request of Land Council. No further time will be granted. Yes, 37.
36 urgent. 37. Kantrajappa.
Petition.
Yes.
I have challenged yesterday's matter. No, my lord. I have filed the 27, my lord. Same day is 2:30 is.
What is
Lord,
that?
what has happened is your lordship may kindly see page 53, my lord, annexure G.
No, what is questioned before this court?
I have vacation notice has been questioned.
What is
Vacation notice, annexure L, my lord. Page number
Vacation
66.
notice.
66, my lord.
It is a consequential to what?
The entire amount was paid, my lord.
This vacation notice is consequential to which order?
Criminal submission, criminal my lord. miss Page order, my 53. lord.
That is a question?
No,
Is it a question?
no, my by
Then how can you question that can't be, you can't even question that order.
Meanwhile, my lord, the petitioner was settled the matter before respondent, my lord. As per settlement, my lord, permanent annexure G, page number 53, my lord, before order, my lord. 14/1/2026, my lord. One-time settlement, my lord. 9,50,000. The respondent has agreed the joint memo, so one-time settlement. As per one-time settlement, the petitioner is paid the entire amount, my lord. There is no due. The respondent issued the vacating notice is not proper, my lord.
My lord, page 50.
There is no due the loan amount, my lord.
Oh, you said, let's hear him.
Please, my lord, earlier round of litigation, my lord, there was a direction to the bank to consider the OTS. In terms of that, my lord, we considered. As on, my lord, the outstanding was 12,16,000, my lord. We gave them an OTS for 9,50,000, which they have deposited.
He is supposed to pay by
Sorry,
what time?
By 2/2/2026, my lord.
Paid.
He has paid it. The only difficulty is, my lord, there are other proceedings which are pending before the consumer forum, which he had undertaken to withdraw. That, my lord, if they given
Then you
undertaking.
will give the portion notice if that is not undertaken.
No, no, my lord, that's not the case. What happened, my lord, in fact, there is some difficulty in this. After, my lord, making the payment also, my lord, he continued to issue legal notices as against the bank. Lord, there is a mistake on our part, my lord, I must admit that. But, my lord, if they are willing to withdraw, because it's a part of the compromise.
Whether he is willing to withdraw or not withdraw, you
Please.
can't issue an eviction notice in the light of the amount that he has.
Understood.
No,
I followed.
if he
I have
withdraws,
paid the
it's
2
fine. If he doesn't withdraw also, his writ petition has to be allowed.
Please, my lord, but your lordship may kindly see page 53 for a moment. My lord. There are certain terms of the agreement
He
on
is not
basis of
seeking-
which the
he is not-
OTS was
no.
given.
If for any
Please.
reason, if he doesn't withdraw the money, withdraw the pending cases, how can, on what basis you can continue the surface proceeding?
My lord, page 53.
Bank has to be
Suppress the
fair.
fact, my-
I understand,
The
my
trial
lord.
court is
To that-
suppress the
that's
fact
why,
of
my
the
lord.
respondent, my lord.
Lord, that's why I said, my lord, there is some difficulty in the matter. Please. The lordship may kindly see, my lord. The conditions have been stipulated. First is with respect to the payment, my lord, which is already been complied. The second, my lord, submission of duly signed notarized affidavit withdrawing all cases.
Question, that point number?
2, my lord. Point number 1, my lord, he has complied, my lord.
Nine
It is
lakh
with
50,
respect to
on or
payment, my
before
lord.
2/2/26.
Before 2/2 only, my lord, the entire payment has been done. Point 2, my lord, submission of duly signed notarized affidavit or withdrawing all the cases. My lord, after,
There is no second point, 1 and 3 straight away.
my lord, page 53, there is second point.
I'm looking at 49, I think.
No, please, 53,
ma'am.
please. 53.
OTS, yes.
OTS.
OTS, ma'am.
Annexure G, my lord.
Payment of rupees so and so.
Please, that is
9,50,000.
complied, my lord. Insofar as point number 2, my lord, submission of duly signed notarized
Point
affidavit
number 1 is completed.
of withdrawing all the cases against SBI so and so. And, my lord, further, your lordship may kindly see point 3. my lord.
Have you complied with 2?
Please, ma'am.
When
Page
is-
number 20.
That's our grievance, my lord, with that.
Page number,
Number?
page number 54, my lord. Next page. 4 lakhs is
Not
paid.
54. Second, point number 2.
Point number 2. All the cases is withdraw, my lord.
Where
There is
is
no
it?
cases pending, my lord.
Have you filed the notarized affidavit? As per clause number 2, you filed the notarized affidavit before this court. I will allow the writ petition. I'll allow the writ petition.
Please, ma'am.
Oh.
I am
Then
ready
counsel
for
for the
all the
petition
cases is withdraw, my lord.
Counsel for the petition submits that they are ready to withdraw all the pending cases.
And-
And in that regard, they'll file a notarized affidavit before this court. List this matter on Tuesday.
My lord,
Lord,
within
we'll
7
not-
days is vacating
not
the
proceed.
Will
position.
not
my lord.
do, and I'll record that. List
not
this
proceed
matter
with-
on Tuesday. The
Will not
respondent
proceed.
shall not take any coercive steps pursuant to the impugned notice.
Please,
In the same stage, my lord, it can be disposed.
please,
No, any stage it will be disposed of.
please.
Yes, next.
Obliged.
Number 2, serial number 1. Kanchan Srinivasan Chetty.
Give the file. The writ petition is filed seeking the following prayer. This writ petition is filed in the year 2022. An interim order was granted on 25/2/2022, subject to the petitioner paying 30% of the amount, failing which interim order stands rescinded, but the writ petition runs the risk of being rejected on the ground alone. On 9/1/2026, this court has observed that the petitioner had an interim order dated 25/2/2022. So far, the petitioners have not complied with the office objections. And also observed that there is no representation on behalf of the petitioner and directed the matter to be listed for disposal. Today, when the matter is listed under the caption for disposal, there is no representation even on today. It appears that the petitioner is not interested to prosecute the matter. Accordingly, the writ petition is dismissed for non-prosecution. 2.
Vandana PL. Vandana.
Same, writ petition is filed, seeking the following prayer. A coordinate bench of this court on 22/4/2022 has passed an order. The first respondent financial institution is directed to treat the amount deposited as part of one-time settlement. If one-time settlement is accepted, and the matter underwent adjournments, then finally, when the matter came up on 9/1/2026, there was no representation on behalf of the petitioner, and the matter is saved. Next. 3.
Qazi Salim.
The writ petition is filed, seeking the following prayer. This is a writ petition of,
My lords,
yes,
for the petitioner,
where is the prayer?
my lords, the parties have
Quash and set aside, modify the order passed by the Debt Recovery Tribunal 2, dated 25/5/2022.
My lords, the petition has become infructuous because the parties have settled the matter, my
It
lords.
is submitted that the matter has become infructuous. A memo is filed stating that the matter has become infructuous and the parties have settled the matter. Accordingly, dismissed as infructuous. Memo is taken on record.
My lords, it's serial number 2, my lords. I don't know, on the display board it was showing 2. I'm sorry, I was seeing
Serial
that.
number 2, 5 dismissed for non, 4 dismissed for non-prosecution. Yes, next.
Deeply obliged, my lord.
Next.
Instead of this, it may be taken on record that it's been withdrawn rather than obliged, my lord.
Yes, 4.
Serial number 4.
Appearing for the respondent bank.
Yes.
My lord, I filed NOC wakalat. If there is some office objection, I will comply with that, my lord. But then this is a case where there's an interim order
No
which is
representation
operating.
on behalf of the petitioner. This is matter for dismissal today, tomorrow.
Great.
Yes, next.
May be permitted to rectify the office objections on the wakalat.
Respondent is permitted to rectify the office objection. Counsellor respondent. Yes, 5.
5. Murthy K.
No representation for dismissal tomorrow. Yes. Move that. Yes.
Number 6. Vandana PL.
My lords, it's a similar matter between the same parties.
It is
This may also
submitted
be
that
withdrawn,
the
my
memo
lords.
is filed stating that the writ petition has become infructuous. Memo is
Ah,
taken on
nice.
record and dismissed as infructuous. Which case? At least right case, this is 1/6.
Yes, my lords. Yes.
Vandana PL.
Yes, my lords. I'm
Yes.
for Dr.
7.
7.
Obliged, my lords.
Vandana VR.
My lords, I appear for the respondent number 1. my lord.
No representation tomorrow but for dismissal. Yes, 8.
Number 8. L. Srinivas Babu.
Same, this also no representation for dismissal tomorrow.
Serial number 9.
No,
Vinay
time for the-
Swami.
no, time for the petitioner, my lord, we issued NOC in this matter because opposite is State Bank of India. We represent them. We have issued NOC in the year 2025 itself. But my lord, it seems like they have not intimated and our name is being
What to
shown.
do?
But the court notice may be issued, our name may
Why
be.
should we give? You have given, you have to file your no object, your retirement memo.
No, I'll file and return. I'll serve the.
List this matter on Wednesday by the time the council shall file the retirement memo.
I need the acknowledgement of being served of the return.
But whatever
I'll
you
file
have to
a-
do. List this matter on 12th of March.
Much.
Yes, 10.
Number 10. Somshekhar.
My lord, in this case, my lord, during the pendency of the application before the application committee for corrective action plan for revival, repetition under MSME, my lord, that period, my lord, when the Your lordship, can you turn to annexure B, my lord?
Come to your prayer first.
Your lordship heard the matter last time. They have taken time to file objections, they have filed objections.
Where's the order passed by the debt recovery tribunal?
Tribunal, my lord, rejected my claim, even though I have pointed out that the NPA has been done with during the application is pending before the corrective action plan. That too, when the lead bank has addressed it
Who
like that.
appears for the respondents? Which bank is this?
That is the Ganesh. Ganesh for R1 and 2. And
Karnataka Bank Limited, no writ petition lies. Just now an order is passed. Against Karnataka Bank, no writ petition lies. You have to go, you have to avail the appropriate remedy. Go before the DRAT.
But this is, that too when the matter is Melada.
Give him this judgment. Code officer, pass over. Next. Yes, next.
For 11.
I appeal for petitioner, my lordship. We have paid the process in the last.
What is the writ petition about? Let's forget about the process.
In this, we are challenging the order passed by the DRT1,
Even
my lordship.
2022, you will not even pay the process till now for issuance of notice. But what for you have filed the writ petition?
Lordship, we are neither the borrower nor the guarantor.
Whatever it is, if that is the case, then you don't have to pay process.
But our property was
set aside
wrongly.
the order passed by the debt recovery tribunal dated 29/6/2020, and you are just keeping quiet for the last 6 years.
Lordship,
Everything
we have
must have
served
happened.
we have served to the different address, my lordship. This is the third time we filed process.
Who appears for Union Bank of India? Who appears for Union Bank of India? Counsel, you appear? Mr. So-and-so is directed to take notice on behalf of the respondent in the land counsel for the petitioners to have the copy of the writ petition on the council today itself. Lessus matter on 16th March. Yes, next.
Number 12, Rajshekar S.
Give that.
Appearing for petitioner, ma'am. Appearing for petitioner, await.
Which is the respondent? Housing Finance Limited. The present writ petition is filed. Taking the following review. The respondent is Messrs. L&T Housing Finance Limited. In the light of the law laid down by the apex court in the judgment in so-and-so, the Supreme Court judgment, the writ petition is not maintainable against the finance, private finance. Accordingly, the writ petition is, accordingly, this court is passing the following order. Writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. Yes, 13.
13, Rameshan.
No representation for dismissal tomorrow. Yes, 14.
14, Yagade Sumana, Mahadev.
I appeal for respondent. Even otherwise, the writ petition is not maintainable. Matter went up to writ appeal in the, as against the interior order not granted, and honorable division bench.
Has dismissed the writ petition itself?
No, directed to approach the appropriate forum. And they are not before this one court.
Petition on term orders are already granted by this court, and view of the submission being advanced, that the applicant number shall not be disposed by effect of 1 month today and property in dispute. And the opposite signs on the appeal is dismissed. What is the consequences of this order?
Because
interim order is not granting interim order is what is appealed. Then it says alternative remedy. That is, writ petition itself is dismissed.
Writ petition, it's an infractuous now.
The writ petition
In view of the,
file seeking the following prayer. When no interim order is granted by the single judge, appeal is filed. Then the division bench has observed that in view of the availability of the alternative remedy, the appeal is dismissed. And it is also observed that since the appeal is dismissed, the deposit of ₹1 lakh each by appellant number 1 to 6 shall be returned to them by the registry as per rules. Since a conditional order was already granted by this court and in view of the submission being advanced by Land Counsel for the petitioner, appellant number 1 to 7 shall not be dispossessed for a period of 1 month from the date of order, that is 14th August 2025, from the property in dispute. There is no representation on behalf of the petitioner and counsel for the respondent submits that in the light of the order passed by the division bench, the writ petition is not maintainable. In the light of the order dated 14th August 2025 passed by the division bench, the writ petition is disposed of, giving liberty to avail the alternative remedy. Yes.
15. Armugam.
No representation for dismissal tomorrow.
16. Ankit S. Reddy.
Same order tomorrow.
17. Jaiprakash Shetty.
It's office notice that R1 is not ordered for notice. R2
Let's
may be
see,
there.
what is the writ petition about?
The question is the order passed under section 19 of the DRT Act and also order passed on the attachment of property by the R2.
Let's see the prayer.
Please.
Come to the prayer. Where is it?
Page 17.
Call for the records which ultimately resulted in passing the order dated, passed in OA number 2018 dated 8/7 passed by DRT. Order in OA number 22 by the DRT. What is the order passed by the DRT?
In the way I was not a party to it. I am a third party judgment and decree holder. I filed a suit for partition and separate possession that has been decreed, against which the aggrieved party filed a RFA before this court. Is pending before this consideration. Without waiting for this, the third respondent, fourth respondent, borrower default alone and defaulted, against which they filed an OA before the DRT. An ex parte order came to be passed. Thereafter, recovery officer issued a recovery proceeding, fixed the form number 16 under the second schedule of the Income Tax Act on the schedule secured assets. That was the question before as a third party, I questioned before the recovery officer. See, the recovery officer, without considering the second schedule of the Income Tax Act, they proceeded to pass the order, and the order passed by the presiding officer is the finality, and he has no jurisdiction to rectify the order.
How can the recovery officer do it?
That is the rules 17 of the 11 of the second schedule of income
No,
tax.
he is only executing an order.
No, there is a
That passed
provision.
under OA.
There is a provision under rules 11 of the second schedule of the Income Tax Act.
So
If there is a
what do you expect him to do?
if there is a third party claim, he should investigate the matter in detail. If he comes to the conclusion that if there is no valid charge on the property, he can exclude the property from the record.
Yes.
And this property has already been sold.
When?
Sold, yeah,
That is December. I filed, I questioned the sales certificate
My lord.
before this court, and same is pending consideration.
Which is that writ petition?
My lord,
I'll furnish in the.
Give it to the court of.
RFA and all is already disposed. He says it's pending, it's
But
order
we
also.
will- we will dispose of both the writ petitions.
Please.
List along with, give the number to the court officer. List along with so and so on 24th March.
Lord, mine, I accept notice for R1 also. For R2, my name is wrongly printed in the cost list.
Then council submits
Spelling
that, so and so submits that she is appearing for R1, but in the cost list is showing as R2.
Spelling is wrongly mentioned.
Give it,
Yes,
that will
I
be
will,
corrected.
I will.
Correct, the registry is directed to print the correct name. Yes, 18.
18. Shri Rajshekar.
Yes, in this matter, senior will be appearing, my lords. The prayer, we have multiple prayers have been sought, my lords. Now I'm informed that the bank is under liquidation, my lords. because we have alleged fraud in the writ petition, my lords. My lords, what had happened is, my lords, we had borrowed the amounts. The account was declared as NPA. Subsequently,
Which bank is this?
My lords,
Again, is this bank? However, it is maintainable.
it is maintainable, my lords.
How?
My lords, the Panduranga judgment, my lords, wherein
Let's
even.
see, get the judgment, we'll see afternoon. Pass over. Yes, next, 19.
19.
I appear for the respondents.
The matter is almost settled. Now, payment is all made. Because the bank, I'm not sure whether they have withdrawn the case in DRT or not. We'll report the settlement by a week or 10 days.
It is submitted that the matter is settled between the
Short
parties
accommodation be made.
for reporting the settlement. Let's this matter on 11th. 11th March. Yes, 20th.
20. Ganga
Petition has become infectious.
My lords, we have given NOC Wakala to the client. We pray a week's time. I will file memo.
Who are you?
Lord, I received NOC and file. I request for a week time, my lord.
Kindly look into the prayer minutes. Only sale notice is challenged. Sale did not take place. Petition has become infectious. Since 22 it is.
What we'll do is, today is Wednesday. We'll take up this matter on Friday. In the meantime, let him have the advantage of filing the
Wakalat. The prayer itself has become.
We'll pass the orders on the day. It is submitted that the council on record has given a wakalat and so has instructions. Write your name and give. So has instructions to file wakalat. This is matter day after tomorrow. Yes, 21.
21. Lata Shetty.
On the.
Sorry.
My lord, in fact, some direction on me in this matter, whether any settlement can be explored between the party. But I need one more week in this. Reason is this.
I've already given my
The
representation.
request of land council appearing for the bank. This matter on 11th of March.
Wait.
Yes,
So
next,
obliged.
22.
Interim order needs to be extended.
Interim order earlier granted is extended. Look at it.
Great.
Serial
Whether it
number
is there or
21, my lord, interim order has to be extended, my lord.
That's what I said.
Much obliged.
22.
22. I'm for the petitioner in this case, Your Honor. Your Honor, in the last date of hearing, they have given the
Account is
statement of
regularized, physical
account.
portion is handed over back to them.
Your
Petition has become
Honor,
infectious.
when the stay is there, they have taken the physical portion of the property on January 19th. And we made, by force, we made another 57 lakhs, where they have claimed 68 lakhs. Now again, they are claiming another 22 lakhs, Your Honor. We don't know how much money they are claiming.
It seems, my lord,
22 lakhs is more than they have given the statement here for 68 lakhs. 57 lakhs we paid on that. And now again, 22 lakhs they are claiming.
this interim order was not extended by this court consciously because she
Honor-
was told to file. Let me complete, madam, please. She was told to file affidavit, no proper
We have
affidavit.
filed
Kindly look into
affidavit.
the order sheets, my lords. No proper affidavit is not filed. Interim order was not extended. We took the physical portion of the property. He has regularized the loan account. The physical portion of the property is handed over to him. Now the account is regular. In fact, he has told, given a letter to bank that he is going to withdraw the case. But my learned friend is.
Your Honor, 68 lakhs, they themselves, they've given the statement.
It's
Here,
voluntarily paid.
in the court also they have given. Now.
Oh, the account is regularized. What is your grievance before the
Your
court?
Honor, regularized means they have 68 lakhs full and final, they have given the statement here. Another 22 lakhs, they are
What
again
is
claiming.
questioned before this court? And what are we supposed to decide? Come to the prayer. What is that you are seeking?
We are not to take the physical portion of the property, Your Honor, they have taken it.
Staying
Without,
the
when the stay is there,
vacating
they have
notice
taken the
dated-
physical portion.
Vacating notice dated 12/12/2022. Now, your property is given back, proposition is restored to you. There are no proceedings pending under the Surface Act as on today, isn't it?
No, yes, madam. Yes, absolutely.
So, if any proceedings are initiated, you will come to the court. Why this petition will be pending?
Your Honor, they are claiming another 22 lakhs extra, Your Honor.
Then come question that order. Please come.
But
Present petition is
as
filed.
per this, the
Seeking
11
the
lakhs is
following
pending.
prayer. Land council appearing for the respondent submits that as per the order passed by the court, the position is restored, the account is regularized, no surface proceedings are pending. Land council appearing for the petitioner submits that now the bank is demanding an amount of rupees.
They are asking 22 lakhs and monthly EMI paid.
22
They are
lakhs
telling
along
like
with the monthly EMI. Next para. If the petitioner has any grievance with regard to the subsequent claims made by the bank that cannot form part of the present writ petition, As on today, no surface proceedings are pending before the surface proceedings initiated by the bank or pending. In that view of the matter, this court, there is nothing to be adjudicated by this court. Accordingly, this court is passing the following order. In the light of the account being regularized, nothing survives for consideration in this writ petition. If the petitioner has any other cause of action, he is at liberty to avail the appropriate remedy. Yes, next.
23, Kavita D.
Yes, no representation for dismissal tomorrow. 24,
24,
you appear for Bank of Baroda.
Please, my lord.
24, your
Please,
name
my
is not there.
My lord,
Mr. Vignesh Shetty is directed to take notice on behalf of the respondents. No representation on behalf of the petitioner. Place this matter for dismissal tomorrow. 25,
25, Saravanan,
Account is closed, Vimas. Loan account is closed.
Land counsel appearing to the respondent bank submits that the entire, the amount is paid and the loan account is closed, hence nothing survives for consideration. Consider recording the submission of the land counsel appearing for the bank. The writ petition is dismissed as infructuous. 26,
26,
In this case,
Dinesh Chandra,
13-4 proceedings has been challenged. 10-5-2022, 13-4 notice has been issued.
Possession notice has been issued by the respondent
Let them go
number
to the
3.
DRT, my lord, if such.
after that, so many things must have happened.
Yes, my lord.
With
Give
regard,
that. The present writ petition is filed, seeing the following prayer. This writ petition is filed in the year 2022. There is no interim order in this writ petition. If the bank has taken any further proceedings, it is for the petitioner to avail the appropriate remedy. Accordingly, this court is passing the following order. Writ petition is disposed of, giving liberty to the petitioner to avail the appropriate remedy. 27,
27,
In this, the petitioner has paid entire dues to the respondent society. Hence, this petition may be closed as infructuous.
submitted that the petitioner has paid the entire amount and the loan account is closed. Hence, nothing survives for consideration. Accordingly, dismissed as infructuous. 28,
Thank you.
I'm
For the
appealing to the
respondent number
respondent.
3, my lords. One
My lord, in
submission, my
this-
lords.
Passover may be done.
password,
My lord,
this 29.
my lord, entire set of papers are not served on us. We,
Who are you?
for respondent number 3, my lords.
Who is respondent number
RBI, my lords. RBI, my lords.
You are the?
Reserve Bank of India.
Reserve
RBI
Bank.
is a.
We'll see. We'll see. If necessary, we'll adjourn.
My lord, there's a prayer against us. We'll have to see.
That's
if
what we'll
file
see. We'll
objections.
see, we'll hear. If required, we'll adjourn the matter. 29,
29, Rajendra, Rajendra,
no representation for dismissal. 30,
13, I'm appearing for respondent but 12.
Appearing for the petitioner, my lords.
Yes.
I'm being led by senior counsel, Mr. Nandakumar.
Huh?
I am being led by senior counsel, Mr. Nandakumar. He's on his legs in Court Hall 12.
password.
Much obliged.
Yes.
31, Abhinav,
Yes. No representation for dismissal tomorrow. 32,
32, Prashant,
My lords, appearing for the petitioner, my lord. Lord, we had mentioned the matter in the morning. We're being led by senior counsel, Mr. Sajan Puvaya, my lord. He's not available. Mr. Sajan Puvaya, we're being led by. We require some time, my lord. 2 weeks' time, my lord. This was last listed in
we will not
2024.
grant
my
2,
lord.
3 weeks time. This is a matter of 2020.
Yes,
If you're led by the senior counsel, maximum time you will get is by 10th of March, nothing more than that. This is matter on 10th of March.
Okay.
No further adjournments. The matter will be heard on the merits of it.
Okay.
Yes, 33.
33, Anup,
Orders will be passed on the merits of
Respondent
it,
back,
not
my lord.
heard. Orders will be passed on the merits of it. Yes, 33.
Petitioner, a short passover, my lord.
33,
Passover. Yes, 34.
34, Anant Kumar Shetty,
Yes, 34.
Sir, I am for the respondent bank in this matter.
Yes.
Lord, the petitioner,
Where is your prayer? Please come to the
Yes,
prayer first. To quash the decision of the respondent bank in their objection statement, denying the entitled to avail the benefits as per the guidelines, credit guarantee scheme for stressed NPA, the objection statement. What is this prayer?
My lord,
Lord,
there-
there is a scheme, my lord. Under the scheme, it is provided that if they are NPA as on the particular date, they should be treated as eligible borrowers. And my lord, the bank has.
I'm not able to understand what is this prayer. To
My lord,
catch
I
the
had made a representation to afford the benefits that are conferred on the stressed borrower by the scheme, and that representation has been rejected.
Hmm.
Therefore, my lord, I,
So you're saying something about objection statement.
in the objection statement for the first time, they said, my lord, they are not entitled for the benefit.
Objection statement,
Filed to my application before the DRT, I had made a representation to afford me the benefits that are conferred on the
then who went to the DRT? Who
Well,
went to-
DRT is not competent to grant such a relief. That relief cannot be granted by the DRT because though that scheme has to be.
Yes. What is
My
this?
lord, in this case, my lord, they are asking the benefit under CGSST scheme, credit guarantee scheme, my lord. There is a scheme introduced by the government under which the eligible borrower, they were having right to get the benefit under this scheme. My lord, the issue has already been decided by this coordinate bench.
Take that. Give him a copy of it.
They have already provided. This matter was heard in the coordinate bench.
Pass over.
A coordinate bench.
Pass over. Give him a copy.
Keep it. Provided the
Yes.
judgment copy.
Yes, next, 35.
35, Chidambara, GS.
No representation for dismissal tomorrow. 36.
36,
Paper for petitioner. The petitioner is challenging the order at Annexure A that demanding the poundage fee by the respondent number 1. The petitioner is the lender and the borrower shares were sold by the recovery officer and poundage fee is demanded.
Who appears for the bank?
I appear.
Who appears?
Yes. New statement. I appear for State Bank of India. He appears for Canara Securities, who is the agent, sold the shares.
In 36.
36, I just.
Huh?
Read my, I have not.
Yes. Huh? Yes, pass over. Yes, 37.
37, Nayak Nityanand.
Who is, where is the petitioner?
They have not appeared, my lord.
Huh?
They're challenging the possession notice.
No representation for dismissal tomorrow? Yes, 38.
38, Rajendra. Rajendra MEA.
Same order. 39.
39, Sukanya.
Respondent bank, my lord. Section 14 orders under challenge.
No representation for dismissal tomorrow.
40, Jagan Mohan.
Same order. Tomorrow for dismissal.
41 urgent, 42 disposed of, 43.
43.
K. Shashikant.
For respondent, not section 14 order is challenged. Interim order is granted in 2022.
No representation for dismissal. 44.
44, Shri Rajshekar.
In this matter, the entire amount is paid, my lords, but they are not releasing the collateral documents which we had given, my lords.
Pass over. Who appears? Inform him. 45.
May I please, my lords? May I please, my lords?
Yes.
My lords, I am appearing for the petitioner in this matter, my lords. We have challenged the order of the Debt Recovery Tribunal in two parts, my lord. One was that we, out of an escrow account, we had to transfer certain amounts to IDBI Bank, which is the first respondent over here. And the second portion, the DRT directed us to transfer it to.
1 minute. Yes.
I'm for the respondent number 2 to 4, my lords. So far as this matter is concerned, my lords, an order is passed on 13/6/2023 also to hear.
We'll hear it. We'll hear it in the afternoon. Yes, pass over. Yes, 46.
In the meantime, my lords, I have filed an application. I don't know whether the Canara Bank has.
We'll see in the afternoon. Yes, 46.
46.
Pass over. 47.
Respond in this case. Repeatedly, they have not appeared.
47, no representation for dismissal. 48.
48, Kavita.
My lord, in this pattern, my lord, subsequently the account has been normalized, regularized.
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 Mm.
My lord,
Then counsel appearing for the respondent bank submits that the, after filing of the writ petition, during the pendency of this writ petition, the account is regularized, hence nothing survives for consideration. Recording the submission of the learned counsel for the bank, the writ petition is dismissed as infructuous.
much less.
We'll see in the afternoon.
My lord, I have one submission, serial number 70, my lord, in least, my lord, one, serial number 25, State Bank of India matter. As per their instruction, my lord, I have given the NOC along with the file to one, my lord, advocate name, my lord, J. Satish Kumar. Have it tomorrow, I'll inform them today.
In that case, print the name of Mr. Satish Kumar.
J. Satish Kumar.
J. Satish Kumar. It is submitted that Mr. Vignesh Shetty has given no objection, has given the file along with no objection.
My lord,
Yes.
32 was adjourned tomorrow. This, I'm submitting the Supreme Court judgments, my lord, for lordship's kind.
You wanted a pass, he was asking for time, I think.
Yes, yes. The
You can
judgments
give it
are
on
here.
that day. You can give it on that day. Yes.
Serial number.
Serial number, madam, 25.
25 first list.
First list.
25.
37, na?
ಚೂರೆಲ್ಲ separate ಮಾಡೋಣ.
Dispose ಆಗಿದೆ. 25 dispose ಆಗಿದೆ.
ಇಲ್ಲ ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
Sir, list number 237, sir.
ಏನಾಗಬೇಕದ್ರಲ್ಲಿ?
ಅದರಲ್ಲಿ J. ಸತೀಶ್ ಕುಮಾರ್ ಅಂತ ಹಾಕಿ ನನ್ನ ಹೆಸರು ತೆಗ್ಬಿಟ್ಟು.
J. ಸತೀಶ್
J.
ಕುಮಾರ್.
ಸತೀಶ್ ಕುಮಾರ್.
ಅದೇ
ಬರ್ಕೊಡ್ತಾರೆ, ಕೊಲಿ ಬರ್ಕೊಡ್ತಾರೆ. ನಾನು ಕೊಲಿ
ಹೇಳಿ ಸರ್.
So serial number 4, list number 1, serial number 4, sir.
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಫಸ್ಟ್ ಅದೇ ಕರೆಯೋದು ಇವಾಗೆಲ್ಲ ಪಾಸ್ ಓವರ್ ಇರೋದಿಲ್ಲ.
Serial number 4,
ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಪಾಸ್ ಓವರ್ ಆಗಿದೆ.
ಸರ್ ಲಿಸ್ಟ್ ನಂಬರ್ 2 ಸೀರಿಯಲ್ ನಂಬರ್ 37 ಸರ್.
ಲಿಸ್ಟ್ ನಂಬರ್
2 ಸೀರಿಯಲ್ ನಂಬರ್ 37.
37 tomorrow for dismissal.
Sir, 41 time ಕೇಳ್ತೀನಿ.
ಎಲ್ಲ ಮರೆ ಇದ ಹೋಗುತ್ತೆ ನೋಡಿ. ನೋಡ್ತಾ ಇರ್ಬೇಕಂತ ಏನು ಗೊತ್ತಾಗೋದಿಲ್ಲ ನಿಮ್ಗೆ.
41 for tomorrow.
41.
Tomorrow 53.
For dismissal ಅಂತ ಹಾಕಿದಾರ ಮತ್ತೆ?
ಏನಿಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ.
Madam, serial number, second list, serial number 42.
16-3. 25 pass over. ಜನ ಹೆಸರು ತೋರಿಸಿದ್ರಲ್ಲ.
Madam.
ಪಾಸ್ ಓವರ್ ಆಗಿದೆಲ್ಲ. 25 ನಾಳೆಗೆ ಅಂತ ಮೇಡಮ್ ಅದು ಫಸ್ಟ್ ಲಿಸ್ಟ್. ಹೆಸರು ತೋರಿಸಿ ಅಂತ ಸರ್. ಹೆಸರು ತೋರಿಸಿ ಅಂತ
ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 42 ಏನಾಗಿದೆ ಸರ್?
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್
42.
ಇಲ್ಲ ಇನ್ನೊಂದ್ಸರಿ ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀವಿ ಬಿಡಿ, ಅವಾಗ ಹೇಳಿವ್ರ ನೀವು ಇರ್ತಿರಲ್ಲ, ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬನ್ನಿ.
ಮೇಡಮ್ ಸರ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ 42.
ಒಂದ್ ನಿಮಿಷ ಇದೆ ಅವ್ರೇನು 42
ಅಲ್ಲ, ಅಲ್ಲಿ 80ಗೆ ಹೋಗ್ಬೇಕಿತ್ತು ಅದಕ್ಕೆ.
42 ಮೆಮೋ ಡಿಸ್ಮಿಸ್ಡ್.
ಡಿಸ್ಮಿಸ್ಡಾ? ಸರಿ.
ಡಿಸ್ಮಿಸ್ಡ್ ಆಸ್ ವಿಡ್ರಾನ್.
ವಿಡ್ರಾಲ್ ಸರಿ.
ಹೇಳಿ ಸರ್. ನೋಡೋಣ ಅವ್ರಿಗೆ ಏನೋ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಬೋರ್ಡ್ ಅವ್ರಿಗೆ, ಎಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಎಲ್ಲ ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲೇ ಬರ್ಬೋದು. ಲಿಸ್ಟ್ ಅಲ್ಲ ಡಿಸ್ಮಿಸಲ್ ಎಲ್ಲ ಇರೋದು ಪಾಸ್ ಓವರ್ ಸೀರಿಯಲ್ ಪ್ರಕಾರ ಕರಿತೀವಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್. ಬನ್ನಿ ಎಲ್ಲ ರೀಚ್ ಆಯ್ತಲ್ಲ, ಇರೋದೇ ಪಾಸ್ ಓವರ್ಸ್. ನೀವು ಕೇಳ್ಬಿಟ್ಟು ಅವಲೇ ಇರ್ಬೇಕು ಇವ್ರೆ, ನೋಡಿದ್ರೆ ಅವ್ರು ಎಷ್ಟು ಫಾಸ್ಟ್ ಆಗಿ ಹೋಗ್ತಾ ಇದೆ. ನಾಳೆ ಹೋಗಿದ್ದೆ ಫೈಲ್ ಸ್ವಲ್ಪ ಒಂದು 5 ನಿಮಿಷ ಇರಿ, ಅಲ್ಲಿ ಬರ್ತೀನಿ, ನೀವು ಕೊಡ್ತೀನಿ. ಹೇಳಿ ಮೇಡಮ್. There are so many passwords. Please wait. First list is there. Then- Huh? 240. Madam, date matters ಎಲ್ಲ ಕಳಿಸ್ತೀರಲ್ಲ? 5-3 tomorrow for dismissal. ಇವಾಗೆಲ್ಲ ಜೋಡಿಸ್ಕೊಳ್ಳೋದೇ ಇರೋದು ಇವಾಗ ನಾವು. ಜೋಡಿಸ್ಕೊಳ್ಳೋದೇ.
ನಮ್ಮ ಲಿಸ್ಟ್ 1 25 ಆಮೇಲೆ ಕರೀತಾರಲ್ಲ ಪಾಸ್ ಅವರ್ ಆಗಿದೆ ಮೇಡಮ್. ಲಿಸ್ಟ್ 1 25 ಆಮೇಲೆ
ಹೋಗ್ಬಿಟ್ರೆ ಹೆಂಗ್ ಜೋಡಿಸ್ಕೊಳ್ಳೋದು ನಾವು ಫೈಲ್ಸ್?
ಪಾಸ್ ಅವರ್ ಆಗಿದೆ. ಅವ್ರು NOC ಕೊಟ್ಟಿದ್ದಾರೆ ಮೇಡಮ್, ಅವರು ಬೇರೆ ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಅವರು.
ಹೇಳಿ. ಸೀರಿಯಲ್ ನಂಬರ್ ಇವಾಗ ಕೊಡ್ತಾ ಇದ್ದೀರಾ? ಅವರೇ ಕೊಡ್ಬೇಕಾಯ್ತಲ್ಲ. ಯಾವ ಲಿಸ್ಟು?
ಇಲ್ಲ ಇವಾಗಲೇ ಬರ್ತಾರೆ.
25 which list? Second list or first list? ಪಾಸ್ ಓವರ್ ಆಗಿದೆಯಲ್ಲ. ಇಲ್ಲ ಅರೆ ಬೇರೆ ರೊಕ್ಕ ತಗೊಂತಾನಂತಲ್ಲ ಜೆ ಸತೀಶ್ ಕುಮಾರ್. ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಬದಲು ಜೆ ಸತೀಶ್ ಕುಮಾರ್ ಹೆಸರು ತೋರಿಸ್ತಾರೆ. ಕರಿತೀವಿ ಬನ್ನಿ ಮೇಡಮ್ ಏನಾದ್ರು ಯಾವ ಡೇಟ್ ಕೊಡ್ತಾರೆ ನೋಡುವ. ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಅವ್ರು ಬರಲ್ಲ ಅಂತ ಕೇಸ್. ನೋಡು ಸೀರಿಯಲ್ 25. ಅವ್ರು ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಬದಲು ಇವರು ಸತೀಶ್ ಕುಮಾರ್. ಏನಲ್ಲ ಜೆ ಸತೀಶ್ ಕುಮಾರ್. SATHISH ಸತೀಶ್ ಕುಮಾರ್. ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ. ವಿಘ್ನೇಶ್ ಶೆಟ್ಟಿ ಬ್ಯಾಂಕ್ಗಂತೆ. ಬಂದೈತಾ ರಿಪೋರ್ಟ್ ಬಂದದ ಬಂತಾರಮ್ಮ ರಿಪೋರ್ಟ್ ಬಂದೈತಾ ಅಂದೆ. ನಿಧಾನಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟು ಬರ್ರಿ. ಇಲ್ಲ ನಮ್ಮ ಎಲ್ಲ ಆಟೋ ಲಿಸ್ಟಿಂಗ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಆಫೀಸರ್ ಲಿಸ್ಟಿಂಗ್ ಕಂಪ್ಲೈ ಆದ್ರೆ ಮೇಡಮ್ ಕೇಳಿ ಬೆಳಿಗ್ಗೆ ಒಂದು ತಗೊಂಡಿಲ್ಲ FD ಯಾರು? 2 and 3 ಗೊತ್ತು. ಮೇಡಮ್ ಹಂಗೆ ಡಿಸೈಡ್ ಆದ್ರೆ ಏನ್ ನೋಟಿಸ್ ಏನ್ ನೋಡಕ್ ಹೋಗಲ್ಲ. ಇದೊಂದ್ಸರಿ ಅವರು ಎಮ್ಇಜಿ ಕೊಟ್ಬಿಡಪ್ಪ. ಎಮ್ಇಜಿ ಚೇಂಬರ್ ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ನಂಬರ್ ಕೊಟ್ಟವ್ರೆ, ಅಡ್ವೊಕೇಟ್ ನೇಮ್ ಲಿಸ್ಟ್ ಸ್ಲಿಪ್ ಕೊಟ್ಟು ಗೊತ್ತಾಗುತ್ತೆ. ಹಾ ಹೌದು ಇಲ್ಲೇ ಇದೆ, ಅದು ಕೊಟ್ಬಿಡಿ ಸರ್. ಅದೊಂದು ಮಾತ್ರ ಕೊಡಿ. ಅವರು ಕನೆಕ್ಟ್ ಮಾಡಬೇಕು. ಸೀರಿಯಲ್ ನಂಬರ್ ಎಷ್ಟಕ್ಕೆ ನೋಡ್ತಾರೆ. 2 ಸೀರಿಯಲ್ ನಂಬರ್ 19.
ಬರೀ ಅದೇ ಅವತ್ತು ನನ್ನಂತೆ ಆಗಿತ್ತು, ಡಿಕ್ಟೇಷನ್ ಆಗಿತ್ತು. ಈಗ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಬಂದು ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ ಮೇಲೆ ಮೇಂಟೈನ್ ಆಗುತ್ತೆ. ಪಾರ್ಟಿ ಪಾಪ ಏನ್ ಸರ್ ಅವತ್ತು ಡಿಕ್ಟೇಷನ್ ಆಗೋಗಿತ್ತು, ಅದರ್ ಸೈಡು ಬಹಳ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ದ, ಹಂಗಾಗಿ ಟೈಮ್ ಕೊಟ್ಟು ಮೇಡಮ್. ಈಗ ಅವ್ರಿಗೆ ನಾಲೆಡ್ಜಿಗೆ ಬಂದ್ಮೇಲೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಈಗ ಡಿಸೆಂಬರ್ ಆಗಿ ಬಂದಿರೋದು. ಈಗ ಮೆಮೊ ಫಾರ್ ಡಿಸ್ಪೋಸಲ್ ಟು ಅಪ್ರೋಚ್ ದಿ DRAT, ಆಮೇಲೆ ಟೈಮ್ ಸ್ಪೆಂಡ್ ಮಾಡಿದ್ದು ಇದು ಮಾಡ್ಬೇಕಲ್ಲ, ಅದನ್ನ ಅಬ್ಸರ್ವೇಷನ್ ಅದಕ್ಕೆ ಹಾಕಿದ್ದೀನಿ.
ನಾಳೆಗೆ ಇಷ್ಟೊಂದು ಡೇಟ್ ಮಾಡ್ರವಲ್ವಾ, ಒಂದು ಇಷ್ಟೊಂದು ಬರ್ಬೋದು ಡಿಸ್ಮಿಸಲ್. ಹೇಳಕ್ಕಾಗ ವೇಟ್ ಮಾಡಿ. Before 28. 10 is there, 18 is there. And the next matter is yours, third case. ಗೊತ್ತಾ?
And the serial number 10 list 2.
ತೋರ್ಸಕ್ ಹೋಗ್ಬಿಡಿ ಬಿಡಿ ಎಲ್ಲ ಮುಗ್ದ ಬಿಸಿ ಕೊರೋನಾ ಪೀರಿಯಡ್. ಹೌದಾ ಹೇಗೆ ಯಾರು ಇಳಿಸಿರ್ಬೇಕು ನಾವು ಮಾಡಿ ಅಲ್ಲಿ ಮೇಲೆ ತಗೊಂಡ್ಬಿಡ್ತಾರ ಅವ್ರ ಅದಕ್ಕೆ. ಎಂದ್ರಲ್ಲೂ ಅದ್ರಲ್ಲಿ ಬರ್ತಾ ಇತ್ತು ಮೇಲೆ ಇರೋದ್ರಲ್ಲಿ. ಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಬೇಕು. ಕಾರ್ಡ್ ಲಿಸ್ಟ್ ಕೊಡ್ತಾರ? ಇದೆ. ಒಂದು 15ವರೆಗೂ ಇದೆ. ಡಿಸ್ಪೋಸಲ್ ಫೈಲ್ ಹೋಗಿಲ್ವಾ? ಇಲ್ಲೇ ಇದೆಯಾ? ಕಳಿಸ್ಕೊಡ್ತಾರೆ. ಕಾರ್ಡ್ ಶೀಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಎಷ್ಟು ಮೇಡಮ್ ಡಿಸ್ಪೋಸಲ್? 25 ಡಿಸ್ಪೋಸಲ್ ಮಾಡಿ. ಬರಷ್ಟು ಅವ್ರಿಗೆ ಜಾಸ್ತಿ ಆಗಿದೆ. ಡಿಸ್ಕೌಂಟ್ನಲ್ಲಿ 4 10 ಡಿಸ್ಕೌಂಟ್ನಲ್ಲಿ ನಾನು ಹೇಳಿದ್ದು 4 and 10 45 ಒಂದಲ್ಲಿ ಇದಿಷ್ಟು ಅಲ್ಲಿ ಆದ್ಮೇಲೆ 18 8 30 53 54 36 44 45 6 ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಕರಿತೀನಿ. ಫಸ್ಟ್ ಲಿಸ್ಟ್ ನಂಬರ್ 1 ನಲ್ಲಿ 4 ಅದು ಲಿಸ್ಟ್ 2 10 ಅವರು ಲಿಸ್ಟ್ 1 10 ಅಂತ ಸೋಮಶೇಖರಯ್ಯ. ಲಿಸ್ಟ್ 2 10
ಹೌದು, ಲಿಸ್ಟ್ ಸೀರಿಯಲ್ ನಂಬರ್ 10.
ಲಿಸ್ಟ್ 2 10 ಅದು ಡ್ರಾ ಮಾಡ್ತಾರೆ. ಲಿಸ್ಟ್ 2 10 ಮೇಡಮ್ ಬಂದ್ರೆ
All the passwords.
Verified the judgment.
Huh?
I verified that judgment, Supreme Court. It is not maintainable in view of this judgment. I may permitted to approach the DRIT. Now I am filing memo for disposal. Because the writ petition is of the year 2022. The time spent before the Sam Court may have made.
The sale certificate has been issued, my lordship.
Whatever, that I'll record.
Yes, my lordship.
This is
Because
which one item number?
Serial number 10, list 2. It is under challenge.
it is the DRT order which is under challenge.
During the pendency of the appeal
List
before
2,
the DRIT
10.
itself, sale certificate was issued.
A memo is filed.
Stated so in paragraph.
The memo is fine.
Page 2, in view of the selfie.
Copy has not been.
I'll. Tell you.
It is submitted that in view of the judgment of the apex court in so and so, and also the two judgments with to her.
Yes.
And in the light of the judgment of a coordinate bench of this court,
Stated so in the
that the
writ itself.
writ petition in WP number 11867 of 2017, dated 4/3/2020, wherein it is held that the writ is not maintainable against the Karnataka Bank, the petitioner permitted to avail the alternative remedy before the DRAT. Next one. Considering the memo is taken on the land council appearing for the respondent
Respondent number 1.
submits that the auction is conducted.
Auction has been taken place, sale certificate has been issued, my lordship.
Sale certificate is issued. The
My lordship,
taking into consideration the memo filed with the petitioner.
sale
This
certificate
court is
is,
passing the following order. The writ petition is disposed of giving liberty to the petitioner to avail the appropriate remedy, if any, in accordance with law. However, petitioner is entitled to the benefit under section 14 of the Limitation Act.
my lordship, one small submission. The sale certificate is issued on 10th December 2021, that is prior
10th
to.
December 2021.
It
If
is
at all
where-
he has a remedy, he'll go.
Yes, ma'am. But limitation will come in the way, my lordship, for DRT appeal.
As far as the pending proceedings are concerned, I said section 14 limitation will come to us.
Obliged.
First four cases, list number 1, serial number 4, Prakash MH.
Serial number 4.
Sorry, my lord, yesterday we were not present and
Yes.
this listed for dismissal. Here for 3 and 4. But arise out of the proceedings,
So I was asking your colleague in the morning,
please.
what is the date of,
My lord, the first partition taken place in the year 2009-1-2006.
2009 and?
9/1/2006. Wherein the respondent number 3, my father was the party along with his brothers. He acquired certain properties. Lord, in the year 26/7/2017, which is the recent partition, in which my father, myself and my brother, the respondent number 5, are the parties. So they have not taken any properties so far as the business is concerned, and my brother was allocated, I was given responsibility.
why the second partition?
Yes, between, because at that point in time we were minors, and in the 2017, my lords, my father want to allot the properties in between the petitioner, himself, and the respondent number 5, who is.
Any recital in the partition deed mentioning the.
Exactly.
the
It is a
parents,
registered partition. It's a registered partition.
No, that is true.
Yeah,
In the
please.
partition, is there any recital with regard to the welfare and other things of the parents?
No, that is quite, it is not present in the said registered partition, and the my lord, the principle laid down by this honorable court, a cognate bench of this honorable court, is that the partition will not come within the context of the gift deed or otherwise, which is as under the
We
Act
will go, we will
2007.
first see the order passed by the.
Yes, yes,
Where is it?
kindly.
That's in Kannada.
Yes, Annexure D is the order passed by the tribunal.
What it says?
Authority 42. Lord, it says that the properties which are given to the petitioner are to be, a reference has to be made jointly in the name of the my father, myself, and along with the fifth respondent, brother, and 25,000 is the compensation maintenance awarded without specifying who is need to pay the said amount, because the petition is filed against myself and my brother, who is the fifth respondent herein. This was challenged before the appellate tribunal. What the appellate tribunal did, it has set aside the order.
The primary, for the first order, what it says?
My lord, whatever the properties which are allotted to the share of the petitioner, in respect of which a joint kata is to be made, including the name of the father and his brother.
On what ground?
Not simply it says that there is no, I mean, finding as to.
Your brother's rights have come in between before the senior citizens.
No, it is the manner in which the tribunal has passed
What
the
is the
order.
appellate authority?
The appellate authority has went still one step ahead and to separate the properties which are given to the share of the petitioner, and it has specifically directed the petitioner to pay entire 25,000 rupees maintenance. But not under the 2017 partition, apart from taking the properties wherein I have entrusted with the responsibility of giving 35 lakhs to my brother and clearing 25 lakhs, which was the loan, so which in respect of which he was liable to pay. And subsequent to clearance of all these, my lord, the present petition was filed by my parents, wherein they have invoked the jurisdiction of this 2007 Act before the tribunal. So without discussing as to the aspect of legality is very much involved in this, whether a partition deed that can be invocable within the context of the act, that is one aspect. And the payment of maintenance is concerned, my lord, rightly though they have made both of their sons as the parties to the proceeding, and ultimately the appellate tribunal has pointed towards me.
No,
to
it
pay.
is cancellation of the deed is also ordered.
Not cancellation of the deed. Deed is not cancelled.
Only 25,000.
Or 25,000 liable to pay, and the so far as the tribunal is concerned, joint existence of the kata
In
the name of father, the
Four sons.
two sons, including me. There are two sons.
Yes.
My lord, the present respondent number 3, my son, he lost 2 kidneys, my lord. 2 kidneys at that moment.
No. You are appearing for the brother or the parents?
I am appearing for the father and mother, my lord.
That is 3 and 4.
Yes, my son, second, the respondent number 3 lost 2 kidneys.
No, not 5. Respondent number 5 is the
Five,
brother.
And one thing, my lord, I'm sorry. Because
And for that, we spent plenty of money, and my wife, that is respondent number 3, has given the kidney, and they made an emotion blackmail and taken all the properties in their name, my lord. When I was in the hospital, I was given the kidney, I gave the kidney to my son. Both are in hospital. At that moment, they have taken an emotional event, and this my son and his father-in-law.
When did you file the petition?
In the year
23/9/19.
20?
After about 2 years from the date of partition. More than 2 years. 26/7/2017 is the
I
registered
face all the
partition.
documents, my lord. I may give you one week time. I face all the documents when I gave my kidney to my son, and what was the moment, and how much money we have spent, and my son.
What is the relevancy of that to the partition deed?
Because partition was taken by fraud, my lord. Position in fraud.
You realized it after 2 years.
No.
In that case, you have to go and file a suit.
No.
Because you are a
No, my
senior
lord, because
citizen.
my son was suffering. Kidney was, the treatment given to my son was not yet saturated. When we gave 2 kidneys, one kidney for my wife gave 1 kidney, and she was again fall ill health, and we are behind him to treat and saturate his health, my lord. And small girl is there, and we should take care of girl and daughter-in-law.
All that aside. No, a registered partition deed was executed in the year 2017.
Yes, my lord.
No, you come before the authorities in the year 2019.
90, yes, my lord, because we were I was hospitalized. The mother was hospitalized along with the son. She gave a kidney and she was ill health, and my even son also, he was not in a good healthy condition. He was hospitalized. For that, we were roaming.
Then what happened to the properties that fell to the share of 5th respondent?
Because they have not given any property for us. No property has been given to me, husband and wife.
Who has cleared 25 lakhs loan?
No, it is the business money. It is not his personal money. Because
these are all disputed questions which can be decided by a civil suit, but not by the.
Clearly, they have taken that running business to himself also. Sunata Traders.
Anyhow, the court has granted 25,000 maintenance.
I am paying.
Irrespective of, let us
Yes.
not go into
Yes.
any other things.
Yes.
They are entitled for the maintenance.
They are entitled for the maintenance, sir. So that is though the prescribed
Now,
limit under the
as
Act
far
is
as the second,
10,000.
fifth respondent is concerned, it is submitted that he is, because of his ill health, is completely incapacitated to provide any maintenance.
My lord, the thing is, he is employed in a reputed software company in Bangalore.
At least do
And-
you accept
and-
the fact
yes,
that
and-
he has
and-
undergone kidney
Yes,
replacement?
and I have kindly come to page 34. Kindly come to page 34, wherein the payments which I have made, 25 lakhs through checks and 10 lakhs, which was
What is the
already.
property worth?
Property worth more than 5 to 8 crores.
Huh?
5 to 8 crores.
One license, trade license shop is given to the petitioner and one residence. My lord, my parents are also having residence and they have retained all valuables. My lord, just for the purpose of taking some score, the forum should not be, I mean, misused in this way. My lord, this was the, I mean, I have no, I mean, impediment for paying the maintenance. Well, since the date of, I mean, getting the
Because
interim
they are
order, I am paying it. You know, the 4 years are over. It is my responsibility, despite the fact that my brother is also one of their kids and who is also.
Do you dispute the fact that your brother has undergone kidney replacement?
There is some health issues. There are some
No, it
health
is not
issues.
some health issue. Kidney replacement
Yes,
and
yes.
mother donating the kidney.
They have also volunteered. This was not, as my learned friend is arguing, an outcome of any mistake or fraud. And so far as 60 lakhs are concerned, which was shown as the share of my brother in 2017, which I have, discharged. After 2 years, if they were of the, impression that
She is bearing
are,
ornament of worth about 9 lakhs.
they are not supposed
They're
to.
telling it is my share.
Everybody is comfortable. My lord, the thing is now they want to, corner me. So this is their intention.
And even
I am paying the maintenance, 25,000 rupees.
My lord, even in this,
Yes.
And if you're paying and if you're comfortable, we'll confirm the order.
My lord, so far as the properties are concerned, my lord, the fora would be the civil court. They have to approach it.
What did the court, the appellate authority said with regard to the properties?
Yes, the exclusivity.
That is with regard to the kata to be maintained.
Yes, exclusive
Can't be.
kata.
That it can't be.
No,
So
my
you
lord,
go before the civil
my
court
lord,
and.
regarding this business also, he has built another house of worth about 8 crores, my lord, another house.
No.
My son, we are
As far-
barehanded
as
and
far
nothing
as-
has given to us.
No. As far as the maintenance of 25,000 is concerned, that we will confirm. As far as the second finding with regard to the properties, that is not at all within the jurisdiction
My
of.
lord, one 2 weeks time, I'll place all the documents, my lord, because how much money he has got, how much property he has got,
How does it matter?
because
Let
here,
him have 100 crores.
section 23 is very clear. My lord.
What it says?
It says that regarding,
Now, if any property, any gift deed or anything is executed in favor of them and the recitals in that contain that he has assured to take care of the parents, and in that regard, if it is done, then only that will fall under the act. Not every family transaction.
because at the time of executing this document, my son was about to go for operation. I was about to donate the kidney.
Any recital in the partition deed.
My evidence is same, my lord. In trial court, both courts have specifically my contention is.
That is not the domain of this act. You have all these things which you are.
Where any senior citizen who after the commencement of this has transferred by way of gift or otherwise is property subject to condition, the transfer shall provide the basic amenities and basic physical needs to transferor, and such transfer refuses or fails to provide such amenities and physical needs, the said transfer of property shall be deemed to have been made by fraud, coercion or undue influence. Because my son is suffering now, small kid is there, I should take care, and my wife is suffering, I should take care, and they are enjoying my business, entire business he has taken away. And goodwill, money he has taken away. And he has made plenty of property basing on my business money, my lord. So I may
Because your financial condition is not right now, you basing on.
Any moment they will quit my house, my lord. He has got big house. Any moment they will throw my.
No, you have a separate house of yours.
No, house is there. We are residing there.
Hmm.
But they have got another house. They have purchased new building and they have constructed new house and they are there. But now they are trying to evict me from that house.
If they do it, then the court will
No,
come to your
here,
rescue.
My lord, I may grant 2 weeks time. I place all the records.
So far as the analogy is concerned,
No,
it is
what is
settled, my lord,
happening
sir.
is beyond the scope of the act, all these orders are passed.
In fact,
Because how did they influence me?
Your financial condition deteriorating
No,
of the
because
health of your
it was
son.
emotion blackmail, my
will
lord,
not-
because
will
we were
not-
not healthy. My wife was not healthy, my son was not in a good condition, there was no person to give kidney. We are roaming to have a person to give the kidney, but finally my wife gave the kidney. At that moment, they were taken this document and we undergone the operation.
I want to have one clarification whether
So
he is
two
still
weeks I
working
placed
or not.
entire all the
Let him-
documents, my lord.
Let him, submit before this honorable court, whether he has quit the job or whether he's continuing.
Everything
By the next date of hearing, all the orders that are passed by the authorities and all other documents, the translated copies shall be filed. And the respondent, the fifth respondent shall also file an affidavit before the court.
Lord,
I am not appearing
one
for,
thing, my lord.
Notice has not been issued. Notice has not been issued.
It was issued, unclaimed. So I am filing.
Notice to sixth respondent returned unclaimed.
Unclaimed.
The petitioner, the respondents, counsel appearing for the respondents 3 to 4 submits that he has been taking care of the sixth respondent. 3 to 4 or 4 to 5?
No.
3, 4, and 5.
3, 4.
3, 4 and
3 to 4, my
5
lord.
submits that. 3 and 4 submits that he is taking care of the fifth respondent. As such, the council shall get necessary instructions. And if by the next date of hearing, if the wakalat is not filed on behalf of the fifth respondent, if no wakalat is filed on behalf of the fifth respondent, this court has to assume that, has to presume that there is collusion between the parties in not appearing before the court. And by the next date of hearing, the land council appearing for the respondents 4, 3 and 4 shall intimate the same to the party, and the fifth respondent shall come up with an affidavit whether he is working as on today or not. Yes,
19,
this is matter
19.
on 24th of March. Yes, next.
Interim order.
Interim order earlier granted is extended.
Great.
Next.
Seal number 10, Nagaraj Shetty.
Appearing for petitioner. On the day of auctioning, rupees 5 lakh has been paid. Copy of payment receipt.
Morning, I made a submission, my lord, auction has not taken place. Petitioner does not survey for consideration.
What he is submitting is, you have questioned the auction. Auction could not be conducted. So what remains in the writ petition?
That is the prayer. That's all.
Nothing remains. If at all any cause of action for you, you question it.
Yes. That is dated 9/2/2026, my lord.
The present writ petition is filed seeking the following prayer. Learned counsel for the petitioner submits that on the date of auction, he has paid an amount of rupees 5 lakhs.
Yes, ma'am.
5 lakhs to the respondent. You are appearing for?
Respondent statement. Respondent number 2 and 4, my lord.
Learned counsel appearing for the respondent number 2 and 4, learned AGA, learned HCGP appearing for the respondent number 2 and 4 submits that the auction could not be conducted on the day for want of bidders. Hence, nothing survives for consideration in this petition. The prayer that is sought before this court is questioning the auction, as auction was not conducted. Nothing remains to be adjudicated in this writ petition. Accordingly, the writ petition is disposed of, giving liberty
Account
to
of
the petitioner.
account of the petitioner could be regularized as it has become NPA, my lords.
That we will not tell them. If the petitioner has any other cause of action, is it at liberty to pursue the same? Yes, next.
45, Kalyana.
Yes.
Lord, I'm told that
Yes, he
Dinesh
said
Shetty has
somebody
issued
to
some
some
other-
advocate.
some other
I said to
advocate.
record it. That name is given, no? Print the name of so-and-so. It is submitted by land counsel, Mr. Vignesh Shetty, that file is given to him along with an
Date
objection. There's this matter on 17th
Please.
March.
Much. of-
Next,
My lord, instead of 17th, 18th. my lord. I have some inconvenience.
18th March.
Much.
Yes, next.
List number 2, serial number 18. Shri Rajshekar.
Lordships wanted to know as to whether a writ can be maintained against a Sauharda. But this issue came to be answered in Mardia Chemicals itself. I'll just file a synopsis because there is a confusion created as to whether a bank or a Sauharda society or that matter an asset reconstruction company should be called by those names or it becomes a secured creditor because of this act. This was the precise question which
The
was,
latest judgment of the Supreme Court is also there.
no, that is only on the public duty, my lords.
No. It
Mardia
is,
Chemicals, the three judges
not
bench.
Malda Chemicals, with regard to Muthoot Finance.
Muthoot Finance, I read that it is relating to the public duty as to whether they are discharging the
But then they
public
said-
duty. Let's square the provisions of the Surface Act. The arguments which was advanced in Mardia Chemicals, particularly
The
this.
judgment, have you seen that?
Lords, yesterday I had a cursory look at that because this is not under the Surface Act as I could understand because the court extracts the judgment of another. May I just
And before that.
public duty, my lord. They say
have you
that we
seen-
find
have
that
you
there is
seen
no.
the judgment of Justice G. Narendra.
That I see, my lords. Now that's the reason why I said. Now if I am in a
This
position
is
to.
after Malda Chemicals.
Lords, that's okay, but Mardia Chemicals, if it is not considered, if I were to just take
Even
that.
the others, give it to him, give it to senior counsel, this one.
Lords, at
this
least
judgment.
there are two judgments of three judges bench of the Supreme Court where this question was argued. And then the Supreme Court said, I'll just indicate, my lords, what the Supreme Court said. The argument was, this is purely contractual transactions between two parties. And if there is some power which is exercised, there is no question of the writ court, writ jurisdiction being exercised. So the remedy is not there other than the ones provided. This was the argument canvassed in Mardia Chemicals. Then what the Supreme Court said is, it is not as simple as that. What ordinarily was a contractual term is now superseded by the contract being regulated under the provisions of the statute where the powers of adjudication of the ordinary civil courts is taken away and they are entitled to exercise their powers. So once the statute vests them with the powers and they act under the statute, they are the statutory authorities required to exercise the power in accordance with the scheme of the statute. If they don't do so or act fairly, then writ jurisdiction is always applicable. The argument itself was that the writ jurisdiction should not be invoked in Mardia Chemicals. That's why a three judges bench. If any other larger bench decision is there, my lords, of course, but this is one view. The second judgment came about in Vasu P. Shetty versus Vandana Palace. There again, the argument canvassed was that even if there is an aberration under the statute, it would not be permissible for Article 226 being invoked. So they said, my lords, the question is only this, my lords. If your lordships is dealing with the issue of a secured creditor enforcing its rights under the statute, it is a statutory authority exercising statutory powers. In the absence of this statute, they don't have powers. They have to go to the ordinary civil court or the DRT to get the original the certificate and then implement the same.
Examine that.
That's the only point, my lords. I'll assist your lordships on that. Because this question I had argued before another bench, but eventually that matter got settled. So as a result of which, my lords, that the judgment did not come about.
Examine when?
Lords, any date your lordship fixes, my lords, next week.
List on 12th of March.
Lordships.
28. A Mahesh Chaudhary.
But I appear for respondent number 3 in this case.
Yes.
For the petitioner, your lordship.
But before they commence, I'd like to make a submission. We have not been served with the entire set of papers. They may be directed to file.
What are you doing from 2022 without
I
papers?
filed the wakalat in June 2025. Let the directory be registry be directed to enter our name in the.
What is the writ petition? Let us first see what is it.
The writ petition, my lords, is challenging the initiation of OA proceedings by ICICI Bank as against the petitioner without having jurisdiction. My lords, the facts, my lords, which lead to the present case.
There is no provision before the DRT to say that DRT has no authority
That's
to.
respectfully, my lords, under the RDBF Act or the surfacey, my lords, of course, surfacey, I can't use it here.
No, when
Under the,
proceedings were initiated before the DRT.
that's right.
Can't you tell the DRT that DRT has no jurisdiction?
That's the, I could have, my lords, but there's no provision under the law for me
No,
to
there
make.
is no provision required when proceedings are initiated, when notice is issued to you, you go before the DRT, you tell the DRT that you
Please.
don't have the power or jurisdiction to entertain this, and the DRT would pass an order, and by this time, something would have happened. You are coming in 2022 and from 2022 it's here.
That's the reason why even the petition is pending, is also for the reason, my lords, the OS is still pending. Now, my lords, the.
Interim order,
Please, my lords, the interim order was granted.
as in WP number, what is this WP?
My lords, all these are connected matters. That's why, my lords, I was about to place the facts before my lords. These are group of home buyers.
Few papers on him.
I would.
You serve the papers on him.
Seeing my friend for
And,
the first time, I'll do so, my lords. I'll do that.
What is it pertaining to those Skylark mentioned, is that tripartite agreements?
Please, my lords. But my lords, the issue is very different, not the one which is pending before the Supreme Court or the connected bench, my lords.
Oh, those matters are before me, Pater.
Oh, is it? Please, my lords, I did not know, my lords. I'm sorry. My lords, the issue is slightly different here for the simple reason that, my lords, before.
Do one thing, where is your, this post along with 18014 of 2022, any other matter?
That's serial number 46 and 46 and 46.1. In today's list.
46.1 and this, along with this 18014, give all the set of papers to the
I would do
councillor.
so.
Today is sent, then councillor, the petition shall furnish. By tomorrow, the entire, all these writ petitions, the papers will be served on the council for the respondent. This is matters for hearing on 12th.
My lord, kindly direct the registrar to print my name in the cause list.
Have you filed your
Yes,
wakalat?
please, my lord.
So and so submits that, write on a paper and give that he has filed wakalat. Registry is directed to
Is
verify
it-
and print his name.
My lords, is it convenient to the bench to have it on 16th, my lords?
Yes,
I'm sorry,
16th,
it's only a
16th,
request.
16th, there are so many matters, 17th will take up.
Please, my lords.
Yes,
I'm
next.
grateful. That's the interim orders we continue.
Interim order earlier granted is extended. to the
Grateful.
Next date of hearing, yes.
In fact, the number which my lords have seen in the interim order is what is serial number 46.
Oh.
Yes. So anyways,
By
I'm
that.
giving the numbers now to the.
Give the,
court
all the
officer.
numbers.
I shall do so.
30?
Suvarna, take all those numbers and write the same thing. Nothing else to be added. Yes,
I appear for the petitioners council,
what is the number?
serial number 30.
Hmm.
Sorry, I wasn't here in the morning session. Matter relates to a proceeding that is sought to be initiated before the DRT involving my property when it has nothing to do with, I was never a party before the DRT. Very quickly, the other listed dates from 22.
In this matter, my lord, the JK Bank is the lead banker.
Huh?
That's right. So though there are a number of respondent parties,
Maningi K.
Jammu and Kashmir Bank is the one that really has to answer. Matter was heard at length before coordinate bench. They kept seeking adjournments. The short question is if they're able to show they have a registered mortgage or not, or registered charge. They don't
So,
have it.
Let's see who are the respondents.
I'll point out. May I just request the court to look at the cause title?
Who represents one?
I don't know if anybody represents one. I'll have to verify. I'm sorry, I stand corrected.
Your name is there in the cause list? Yes, then number two, Jammu
Number
Kashmir.
2 is important. Number 2 is the one who has to answer. No objections are filed, but they've
No,
filed
who
some
is-
documents.
Who's the council?
Mr. Sailesh, I'm told, is there.
It's there, his name is there.
I'm just pulling out the cause title. Please bear with me for 1 minute.
Sailesh Kumar for R2.
Please.
They are the answering respondents.
Yes, ma'am.
Where is he?
He is the one who has to really point out.
You're representing which bank? State Bank of Mysore?
HDFC Bank. ma'am.
What is the role of HDFC Bank in this?
It is a consortium law.
Oh, consortium.
Yes,
loan.
my lord.
Hmm.
Jammu and Kashmir is the lead banker.
So all the banks are served?
Yes, everybody's been
Everybody
served.
is,
That's
morning,
not-
some of
that's
the
not-
advocates have appeared in this matter. Mr. Muttane had appeared on behalf
It is submitted that the whole issue is whether there is a mortgage in favor of
Registered
the
charge.
registered mortgage in favor of the second respondent.
Please.
It is submitted with the learned counsel that earlier extensively arguments were heard before the coordinate bench of this court. And the second respondent has to come up with objections, oblique instructions, whether there is a registered mortgage or not. There is no representation on behalf of the second respondent today. The list this matter on 11th of March. By the date, the second respondent shall place before the court his instructions, objections, whether there is a registered mortgage or not.
May I please request for 12th instead of 11th if it's not
Well,
inconvenient? I'm so
basing on
grateful.
that, further orders will be passed.
Great.
Yes.
Anuparna?
Dr. AC. Yes.
My lords, I have assailed an order of the DRT, my lords. I am a third party, my lords. I am not a borrower. I am not a guarantor. The property is standing on my name since before the account has become NPA. My husband is a guarantor and revenue records, all the sale deeds, everything is standing in my name. In spite of that, bank has filed an affidavit saying that I don't have an independent income, my husband has income. Therefore, property, those standing in my name, should be attached.
There is no dispute about the fact that your husband has taken the loan.
My lords, my husband has not taken loan. My husband is one of the guarantor, and there are properties which are secured under that loan. A particular company who has taken a loan, and my husband is one of the guarantor of that particular loan. And my lords, the loan was slipped into.
Title deeds were they are mortgaged with the bank.
Which one? This property? No, my lords. But this property was jointly bought in joint name in 2005. Thereafter, in 2017, my husband gifted the property. In the 50% of his shares is gifted to me because there was a company that we were running together, and the company shut down.
When was the mortgage?
The mortgage was created in 2012, my lords. This
And
property is purchased in 2005.
when was the gift deed?
Please, my lord.
When was the gift deed?
2017. NPA happened in 2018.
No, whatever it is, when the property was mortgaged,
Please, my lord.
you were not
This
having.
property was not mortgaged. This was never mortgaged. This is not, my lords may kindly peruse, that is an admitted fact that this property was never mortgaged. Because
How come they have been?
Please, my lords may kindly see the affidavit. The affidavit, they have gone on a presumption that this property is bought out of the funds of dependent number 5, who's my husband. Whereas all the revenue records, everything stands in my.
Hear him. Yes.
My lord, we have submitted short notes of arguments on 9/9/25, which may kindly be thorough so that there will be no digression or destruction. It's very short, but to the point. 9/9/21, my lord.
9/9/25, yes.
This writ petitioner is the wife of defendant number 4 in the OA number so and so.
5, defendant number 5.
Present debt in the OA is about rupees 42 crores. She
One
has
minute.
sought.
Let me open.
Please. Not more than 5 minutes, madam. This writ petitioner is the wife of defendant 4 in the OA so and so. Present debt is about 42 crores, and the writ petitioner has sought for setting aside annexures C and D, page 43 and 60 of the writ petition. And orders, these orders were passed in IS by the DRT1. There is an alternate efficacious remedy under section 20 of the RDB Act 1993, which includes appeals against interim orders of DRT to DRAT. Next, order dated 19/4/21 of this honorable court has said, no coercive steps by the bank. At the same time, the petitioner shall not encumber the property. Next point, DRT and 22/3/21, while dismissing the petitioner third party applicant, IA number so and so, held that the petitioner's application is not bona fide and made with a view to deny and deprive the applicant bank from proceeding against the property in which defendant number 4, husband of this petitioner, undoubtedly has half share as per the sale deed of the year 2005. Next point, small point. The order dated 16/12/2020 in banks, in our banks, IA 2284 of 2020, therefore would bind 50% of the share of defendant number 4.
I've
and
seen,
therefore-
I've seen.
Please.
So, the property is not mortgaged.
It's not mortgage. We had taken ABJ, attachment before judgment of the property of half share of the defendant number 4. Because it was a sham gift, that's what I explained. It is a gratuitous gift and it's violative of the section 53 of the Transfer of Property Act. And that's why we are before this honorable court. She is before court and we have submitted our detailed.
It's not under Securitization Act, it is under the
RDB, both.
Please, my lords, my lords may kindly see the application what they have filed. They do not see 50% and all. They say that the entire property belongs to my husband. My lords, in 2005, this.
We will clarify that.
Please, my lords.
We'll clarify that.
My lords, the DRT has literally gone on the basis that the title of the property, that this property belongs to the husband, 50% share.
He has gifted you.
My lords, there is a registered gift deed.
Gift deed which is of the year 2017.
NP happened in 2018. The guarantees has been extended in 2018. Now, my lords, and there are properties. May kindly see the original application that they have filed. There are secured assets. They do not go against those secured assets. They go after this property which belongs to me. And they do not do a due diligence, my lords. There are revenue records, everything available which clearly shows the property is standing in my name, the entire property. Not even half, entire property is standing in my name from 2017. The property was shown as a joint owner from 2005. And in 2017, after the sale deed has been, gift deed has been executed, the property is standing in my name exclusively. Thereafter, I have also executed another agreement, registered agreement. That is also, can be seen in the EC. The bank do not do any due diligence, goes before the court and files a false affidavit, my lords, stating that this property belongs to defendant number 5. On that basis, my lords, the order 38 rule 5 order has been passed, my lords.
There are no other
Sir,
properties.
it's not a fair submission, my lord. I think we can just.
No, there are no other properties.
My lords, may kindly see page number.
1 minute, 1 minute.
Yes, my lord.
Jointly
There are other properties. Why should you go to?
No, there are no
page
other properties.
property which is
NCLT
listed?
has declared this company as. NCLT has declared this company is being bound up. And these are the guarantors. These are all technical people who have whatever done is done. And we are only to proceed against these people. Against these people individually, only that. And there is no property, single property of the company.
No, it is not a case that there is a charge created in favor of the bank in respect of this property. Later, gift deed is executed in her favor.
In a
Then
2007
that is a different aspect. Here, that is not the case. As on 2017, the gift deed is executed in her favor. The account has become NPA in the year 2018. And as of now, there is a gift deed in favor of the wife.
The loan was granted in the year 2012, over a period of time. See,
No,
this
whatever it is,
property was
it is not a mortgage property.
it's not a mortgage property, but it belongs to the defendant number 4.
No, at the time of the attachment before the judge, how can the court decide all these aspects? Whether that property belongs to her, or is she a binami, or is it the entire property belongs to the husband? How can all that be decided by the DRT?
No, see, we have also mentioned there, in the year 2005, the sale consideration was rupees 54 lakhs. In the year 2005, when the property.
Oh, this is even a civil court can't do it in an application that's filed under order 38. The DRT has done it.
No,
Prima facie,
there's a beautiful speaking order, my lord.
Prima facie, there is a gift deed in her favor in the year 2017. It is not your case that a charge is created in respect of this property much before the gift deed, and only to defraud the interest of the bank it is done. That's not your case.
Please.
Then in that case, how can there be an attachment of the property which doesn't stand in the name of a guarantor?
It stands because it was a gratuitous gift.
Should be decided not in attachment before judgment. Not in that. Where is order? Order.
My lords, is at page number 43, my lords.
129, yeah.
Page number 43.
40?
43, my lords. Annexure C.
Let's read.
Please, my
The
lords.
operative portion.
My lords,
I
at
mean,
page number 57.
the
is operative.
reasoning
It-
part.
Yes, my lords, at page number 57, ink page 15.
We'll read from
Please, my lord.
the
Thus,
reasoning.
it is observed that third-party applicant has filed present IA for setting aside the order dated 16.
Come to page 54.
54, my
Paragraph
lord.
number 10.
Please. I have considered above arguments advanced by the rival counsels. I have also perused the records of the case and memo with affidavit of third party and documents filed by the third party on 3/3/2021 and memo with documents filed by the applicant bank on 18/3/2021, along with the original application and documents produced by applicant bank. From the memo with the documents produced by third party annexure R9 to annexure R11, it is clear that applicant bank has sanctioned facilities aggregating to rupees 17.5 crore on 31/7/2012 by annexure R10. The defendant number 1 as borrower has always also executed documents including composite hypothecation agreement annexure R11. These facilities and loans were enhanced from time to time as per document produced by applicant bank in the original application on 9/11/2015 to 30 crores, which was guaranteed inter alia by defendant number 4 along with defendant number 2, 3 and 5. Subsequently, the facilities were again renewed to 57 crores on 29/2016 and defendant number 4 had guaranteed the additional loans and facilities along with defendant number 2, 3 and 5. It is under this circumstance the gift deed relied upon by the third party applicant came to be executed in favor of her by defendant number 4 for the scheduled property on 13/7/2017. Further, the third party applicant and defendant number 4 entered into agreement to sell with another third party Green Google Mercantile on 14/2/2018, offering to sell the scheduled property to the Green Gold Mercantile for rupees 2.2 crore. The copy of the agreement is attached. The third party applicant is stated to have received 2 checks of 2.5 lakhs each for total 5 lakhs. The balance sale consideration was payable as per clause 2.1 and 2.13 on the execution of the registration. As per clause 5.1 of the agreement to sell, the sale deed was to be executed within 90 days from the date of agreement to sell, which is 14/2/2018 or before 15/5/2018. Clause 6 of the said agreement state the physical vacant possession of the scheduled property would be delivered to the purchaser on the date of execution of registration of sale deed. The applicant also produced the Khata certificate dated 20/10/2020 and Khata extract of the same date. This shows that the property still stands in the name of third party applicant when the agreement to sell provides for execution of sale deed within 90 days thereof on or before 15/5/2018. There is nothing to show why the parties have not proceeded further in terms of the said agreement, which calls for execution of sale deed after payment of full consideration by the purchaser vendor. In the absence of payment of full sale consideration, execution of sale deed, the third party applicant cannot say the property has been transferred yet another third party. On the property, she has produced proof of Khata certificate, Khata extract dated 20/10/2020 showing that the property still stands in the name of third party applicant herein. It is observed that while the third party applicant herein produced Khata certificate and Khata extract showing that the property is standing in her name, the same is not consistent with her contention. The property was transferred to another third party as per sale agreement, which was done to raise money to meet urgent requirement of the third party applicant. In any case, the said agreement only speaks handing over 2 checks of rupees so and so to be paid within 90 days. The sale agreement with another third party is not helping the argument of third party applicant herein, as it has not evidently concluded. There is no whisper of compliance of the terms and conditions of the said agreement between the parties. Further, the claim of the third party applicant that the property still stands in her name as per Khata certificate and extract would only go to show that transfer by way of a gift of the share of defendant number 4 to the third party applicant is done ostensibly to deny the creditor applicant bank which was granted substantial amount by way of a loan and advance facilities right from 2012 to 2017 based on guarantee of defendant number 5 with guarantees of defendant number 2, 3 and 5. It is also pertinent to note the agreement holder from the third party applicant has not raised any objection to the order passed which is sought to be set aside. Thus, it is observed that third party applicant and the present IA for setting aside order dated so and so on the basis of gift deed executed by defendant number 4 in favor on 13/7/2017 and the said gift deed by the defendant number 4 in her favor is found to have been executed after defendant number 4 availing substantial amount of loans and facilities from the applicant bank along with the defendant number 1. And
Please come. The present writ petition is filed. Agreed with the order passed in I number 381 of 2021 dated 22nd March 2021 by the Debt Recovery Tribunal 1
In OA number.
in OA number 1804 of 2018. The respondent bank has filed the OA against the borrower and the guarantors for recovery of a sum of rupees. What is that? 41 crores.
Yes.
59,87,237.60 together with interest. In that, they have filed an IA 2284 of 2020. Where is that IA order?
my lords, the IA order is at page number 2284 is my lords annexure A page 32.
Last page 65 is the order, madam.
Page 32.
My lords, page 32 is the IA 2284, wherein my lords may kindly produce 35 page
An
number.
IA was filed.
Page 35, my lords, standing in the joint name
Order
of
38 Rule 5 CPC. The court by order dated 22nd date order is dated
16th December 2020.
page number
Page number 61, internal
Not
page
51.
61. Page number
my lords.
it's not 51.
61.
My lords, which page, my lords?
No, I'm asking you.
IA
Yes, my lords.
IA number
Yes, my lords.
2284 of 2020.
2284 is at
Page
my lords,
61.
page number 32, my lords.
page number 30.
32. My lords, it's filed under order 38 rule 5.
Hey, where is the order passed under that?
My lords, together it is passed by way of a common judgment. This order, my lords, 2284 order
Not
is at,
that. What it says is, come to the order.
please, my lords.
The present OE is filed with the applicant against her for recovery. Then after that,
Please, my
to
lords.
set aside the order dated 16/12/2020 passed in IA number 2284 of
Oh,
20.
please, my lords, I will just take my lords to that.
That's the order.
Yes, my lords, that's the order. That, my lords, it's page number 61, my lords.
What did you write? Not order. The filed an application on order 38 rule 5. And the court by order dated 16 December 2020 in I number 2284 of 2020 had passed an order directing the defendant to furnish the security equivalent to OA claim amount on or before the next date of hearing, or to appear and show cause why the defendant should not furnish security, failing which interim relief sought on I number 2284 of 2020 will stand allowed. Then the petitioner before this court, who is the wife of the fourth defendant,
Please.
who is a wife of the fourth defendant, the defendant has filed the present IA, that is IA number 381 of
2021.
2021. stating that the said property is gifted, in fact purchased by both of them in the year 2005 by contributing equally. And in the year 2017, on 30/7/2017, a gift deed is executed by the husband in her favor, and she has become an absolute owner of the property. As such, there cannot be any order attaching this property. The court, by order impugned, had dismissed the said application. While dismissing the application, the DRT has observed that the third party applicant has filed the IA for setting aside the order dated 16/12/2020 on the basis of a gift deed executed by defendant number 4 in her favor on 13/7/2017. And the said gift by the defendant number 4 in her favor is found to have been executed after defendant number 4 availing substantial amount of loans and facilities from the applicant bank, along with defendant number 1 to 3 and 5. Hence, it appears that the transfer by way of a gift appears to have been done to deny or deprive the applicant from recovering the loan dues from the defendant number 4's property. Further, to deprive the bank, they have entered the third party has entered into a agreement of sale with another third party, which also does not appear to have been concluded, though it provided for conclusion of the deal within 90 days. The fact that the present application has been filed by the wife of defendant number 4 and not the purchaser under the said agreement to sell would clearly show that the aggrieved party is not the purchaser, as sale has not been concluded by payment of full sale consideration as stipulated in the agreement. Under the circumstances, the application by third party applicant is found to be not bona fide and made with a view to deny and deprive the applicant back from proceeding against the property in which defendant number 4 undoubtedly has half share as per sale deed of the year 2005 executed in their favor. The order dated 16/12/2020 therefore would bind their 50% share of defendant number 4, and therefore the present application filed by third party applicant, who is the wife of defendant number 4, fails to pass the merit and is liable to be dismissed and accordingly dismissed. Learned counsel appearing for the petitioner, who is the wife of the 4th defendant, submits that the property is gifted to her in the year 2012 by way of a registered gift deed dated 13/7/2007, and by virtue of the gift deed executed in her favor, she has become the absolute owner of the property. The husband of the petitioner is a guarantor. The property which stands in her name cannot be attached on an application that's filed under order 38 rule 5. Even the finding of the court that the sale deed executed in the year 2005 shows that defendant number 4 has half share as per the sale deed. It is submitted that the court has failed to consider the gift deed which is executed in the year 2017. It is submitted that the order, the court had failed to consider IA number 381 of 2021. Where is your IA number 381? Page
My
number?
lords. My I number 381 is at page number 38, my lords.
One small interruption, my lord. One small interruption. Annexure N submitted by the petitioner, because the page number is different in mine and hers.
Yes, yes.
Annexure N, the agreement to sell, is signed by my defendant 4 as a confirming party, which shows that this See, this gift deed has not become absolute.
There is a registered document.
Please.
There is a registered document.
It is,
No, gift deed is a registered document.
sure. But
I'll record in your submission.
Please.
Uh,
Annex N.
381 of 2021 and its proper perspective. Next paragraph. Then counsel appearing for the respondent bank submits that according to the respondent, according to the petitioner, they have entered into an agreement of sale with a third party, and that agreement of sale is entered by the defendant number 4, which shows that the property. That is a submission.
Confirming, so it's a confirming party, sure, she's a confirming party, executed.
My lord, it's not executed between defendant number 4 and the third party. It is executed between me and the third party.
But where from you saying that?
My lords, the document speaks for itself, my lords.
Executed, see, this is between them only. See, I think kindly, please, Annexure N, please.
Page number?
Page number, I don't know. What is the page number?
Annexure N, what is the page number?
Page 125, my lords.
25.
125.
My lords,
It's an agreement
vendor
to
is
sell.
mentioned, vendor,
1 minute.
page number 125, my lords.
Minute, please. It's an agreement to sell
No,
between Madam
agreement of sale between Srimati M.R. Shubha.
and C.R. Ramesh.
No, he's a confirming party.
C. Ramesh.
Vendor is M.R. Shubha.
Vendor, which
Vendor
term
between
unless
them.
repugnant.
It is an absolute
It is
gift.
submitted that
Yeah.
it is submitted that the agreement of sale, in the agreement of sale, the petitioner and the husband is shown as a confirming party, which shows that the gift deed is not acted upon. As such, the court has rightly considered all these facts and rightly held that as the defendant number 4 is having 50% share in the property, as per the sale deed in the year 2005, both of them have contributed and jointly purchased the property. Court had rightly held that there would be a charge as far as the 50% of the property is concerned. It is submitted that the petitioner is not at all an income tax assessee when she has no income. When he has no income, question of purchasing the properties or any contribution from her side is completely ruled out. It is submitted that the court, in spite of the said fact, had considered only 50% of that, and an order is passed. It is submitted that the order passed by the court is a well-considered order and it doesn't require any interference by this court. Next part, having heard the counsels on either side, produce some material on record. The admitted facts in this case are defendant number 4, who is the husband of the petitioner herein, is a guarantor for the loan, for the loan granted by the respondent bank. When there was default in payment of the loan amount, they have initiated the proceedings by filing a OA under the RDB Act. Under the RDB Act, the
Jointly and severally liable to pay.
RDB Act, the property which is in question is purchased in the year 2005 by the petitioner and her husband in the joint name. Then in the year 2017, a gift deed is executed by the husband in favor of the wife. The account has become NPA in the year 2018. It is nobody's case that this is a property which is mortgaged by the mortgage in favor of the bank. And as on 2017, the account has become NPA, and to defraud the interest of the bank, a gift deed is executed in favor of the wife. When there is a registered gift deed as on today, it has to be that property belongs to the bank, and the property belongs to the wife. If the bank wants to prove otherwise, saying that it is a transaction to defraud the interest of the bank or any other thing, that is for the bank to prove the same. However, when an application is filed under Order 38 Rule 5 CPC seeking attachment before judgment, basing on these disputed questions of fact, where with regard to the ownership of the property, where the ownership of the property itself is in question, the court ought not to have passed such an order. In that view of the matter, the order dated so and so. What is the order?
My lords, order is dated page.
The order dated 16/12/2020 passed on I number 2284 of 2020 is set aside and the writ petition is allowed.
Grateful.
Yes, next.
34,
34.
34. Sanat Kumar Shetty.
Yes.
Yes. Lord, petitioner is a micro, small and medium enterprises. They had availed loan from the respondent bank.
He was referring to some judgment.
Yes, my lord, I will refer to
Has
that.
it, does the judgment has an application?
My lord, my respectful submission, my lord, that it's not applicable. Is
Give the judge.
My lord, this is the judgments, my lord, will be applicable to the facts of the matter.
Let me look at it. Take that copy.
Already it is there in the court. Sir, also got judgment code.
Switch on, ask him to switch on the AC.
Similar, my lord, similar judgment, similar matter,
Let's read the facts.
facts.
My lord, fact is, my lord.
Let us read the judgment. Facts
Yes,
in this.
Yes, ma'am. This is what you are doing.
What is this?
My lord.
According to you, what is the ratio laid down in this judgment?
My lord, in this judgments, my lord, the circular which is referring CGTMC circular that has been referred by the coordinate bench in E. If you go through the judgments, my lord, page number 3E, page number 3E. You permitted to read, my lord. The claim of the relief which the petitioner has pressed into service before the lender bank under the credit guarantee scheme. Where exactly, my lord, he is pressing the scheme under the credit guarantee scheme now. Now the writ is before this court. He is entitled the benefit under the credit guarantee scheme. My lord, does not exclude the exercise of banker prudence, which is of necessary invocable while making the commercial decision of kind. After all, the bank which handled the public money as a trustee cannot be compelled to undertake the ventures which may possibly be detrimental to the public money at its hand. The following paragraph of 9.4 and 9.2, my lord, my statement of objection, kindly be taken. Same paragraphs are referred by the coordinate bench. Of the credit guarantee, MLI means, my lord, member of lending institution, shall carry out their own due diligence, assess viability, need and requirement of sub-debt facilities in respect of restructuring of stretched MSME unit. The secondly, the lending institution shall evaluate credit application by using prudent banking judgment and shall use their business discretion due diligence in selecting the commercially viable proposal and conduct accounts of the borrower with
Before
normal bank.
understanding this judgment, it's better I understand the facts of the case.
Yes, my lord, I mean,
Please come.
Yes. Lord, we are micro, small and medium enterprise. We had availed loan from the bank. My lord, that was classified as a non-performing asset in the year 2019, that the bank also admits. My lord, thereafter, my lord, they have instituted the proceedings before the DRT for recovery of the amount.
No, when they have declared it as NPA, they've instituted the proceedings under the Securitization Act.
Not my lord, debt recovery tribunal, they have filed a recovery proceedings. My lord, that is pending for consideration. In the meanwhile, the central government evolved a scheme, my lord, for restructuring the
No, as far as this MSMEs was concerned, before they declaring it as a non-performing asset, NPA, what is the procedure to?
My lord, that's what's my lord. See, there is two. One, my lord, the recent prone its judgments, my lord is well aware. My lord, they have to claim before issuance of the notice under section 13(2) of the Surface Act. That's what.
You have not initiated the
No,
proceedings.
my lord, here, my lord, they are not claiming, they are restructuring the MSME. We have initiated, my lord, on 10/12/2019. 10/12/2019, a proceedings under section 13(2) of the Surface Act was initiated.
Lord,
That's what.
under the scheme,
Let him conclude, my lord.
1 minute. No, both of you not
Yes,
required
yes,
to elaborately argue. If you are, if you can answer the queries of the court, that will cut the issue.
Yes.
So 13(2) notice is issued to you or not?
My lord, it is not a proceedings under the Surface Act.
I am asking 13(2) notice is issued to you or not?
13(2) has been issued, property has been sold under the Surface proceedings.
13(2) notice is issued.
Yes.
If you are entitled for all these, whatever you are saying, then you should have given a reply to them saying that you can't declare my
Lord, at that time, my lord,
account. No,
the scheme
that
was
is what
not
is the-
evolved, my lord. The
No,
scheme
that
was not.
there. In 2019 was there?
No, my lord.
When was
20,
the-
my
when
lord.
was
20, my
this,
lord. It was in.
This scheme was introduced on 1/4/2020.
Then as on that date, it is not available to him.
As on date, it was not, that is my case before this honorable court.
Then how can you seek retrospectively?
My lord,
something?
that is what is stated in the scheme itself, my lord. If my account was non-performing asset as on 34/20, my lord, I am entitled for the benefit under the scheme. And if that scheme is available, all the pending proceedings will have to be withdrawn.
This writ petition is of the year 2020.
21.
What useful purpose would be served after these many? What were you doing from 21 to 2026?
My lord, it was
They
pending.
sell
my
the
lord.
property.
My lord,
Now third party rights have accrued. What is that we can do with this
my
now?
lord, what I pray, my lord, that restructure me and my lord, all pending proceedings will have to be withdrawn. That is the scheme. That is the.
And the scheme never said that you just keep quiet from 21 to 26 by filing a writ petition.
My lord, they have not given me the benefit of the scheme, my lord.
No, you're not deficient in, no, third party rights have accrued. Your property is sold. Isn't it?
My lord, what I beg to say, my lord.
And the account must have been closed by this time.
My lord, the proceeding is pending before the DRT, my lord.
What proceeding?
Recovery proceedings.
My due is more than 14 crores. 8 crores we sold the property.
My lord, what the
My lord,
scheme says, my
For
lord.
the DRT, raise all these issues.
My lord, this cannot be granted by DRT, my
Why
lord.
not?
My lord,
When the scheme provides for something, that should be granted to you. If you're
my
entitled.
lord, that to grant such a scheme, they have refused to grant being the relief that is claimed under this scheme.
No, when the recovery proceedings are pending before the court, you raise all the, because I'm entitled for so and so, they have not granted. This is one of the legal grounds to be raised before the DRT, because in a 2021 writ petition, when the proceedings are pending before DRT, we cannot deal with it. After now the sale is also done. You have to question that sale also. To set aside that sale also, you have to initiate appropriate proceedings. So better go there. I'll leave it open
All the
to contest
contestants
all
are
this
kept
before
open.
the DRT. Please come. The present writ petition is filed. Seeking the following prayer. The land counsel appearing, when the matter came up for hearing, land counsel appearing for the respondent bank submits that the auction was conducted The property was delivered to the
Auction purchaser.
auction purchaser. Sale certificate was
Everything has been
also
completed.
issued.
Yes, my lord.
Was also issued. It is submitted that the present writ petition is covered by an order passed by the coordinate bench of this court in Trajan Systems Private Limited and others versus South India Bank Limited and others arising out of WP number 1307 of 2020 dated 4/10/2021. Land counsel appearing for the respondent has denied the same and it is submitted, appearing for the petitioner has denied the same and submits that it is not covered with the said judgment. It is submitted that when there is when the petitioner's company is registered as an MSME, and whenever the account has to be declared as a NPA, they have to follow the procedure as contemplated by the Reserve Bank of India in the scheme. It is submitted that the respondents have failed to follow the procedure. Though his account is declared as NPA in the year 2019, as per the scheme, if a particular account stands as NPA as on
33/20/18. One.
I will tell the eligibility. 34/2020. As on 34/2020.
As on 34/2020, they are entitled for the benefit. It is submitted that when he has made the said request, the same was rejected by the respondents. Hence, he has come before the court. Next, having heard so and so. It is an undisputed fact that before the DRT, the proceedings or recovery proceedings initiated by the bank are pending. Now, during the pendency of this writ petition, already sale is concluded and sale certificate is issued. The sale certificate is issued. The contention of the petitioner that all these aspects cannot be considered, what has been raised before this court cannot be considered by the DRT, has no legs to stand. Before the DRT, when a particular circular is given by issued by the Reserve Bank of India.
Not Reserve Bank,
By the Union of India, and if there is no complaints by the respondent bank, the petitioner is always at liberty to agitate and the DRT is bound to answer the same. Considering the fact that the sale certificate is also issued and this is a writ petition of 2021, no useful purpose would be served in going into the merits of the matter at this point of time. Accordingly, this court is passing the following order. The writ petition is disposed of, giving liberty to the petitioner to avail the alternative remedy before the DRT. It is open to the petitioner to raise all grounds.
Including the ground of, availability of benefit of this fund scheme.
This is what is the writ petition about, to raise all the grounds that are raised before this court. The petitioner will have the benefit of section 14 of the limitation.
My lord, my submission in this matter, my lord, the respondent has submitted that he is not met with criteria under the CGTMC.
It is submitted that by the in his submissions.
As per the criteria.
Submitted that the petitioner is not entitled for the benefits as he is seeking under the.
As per the terms and conditions stipulated under the scheme.
Under the scheme.
Yes, my lord.
Yes.
And hence rejected. My lord, all my grounds I have also permitted to urge my grounds before the DRT by filing of
It is open to all the parties to raise their grounds.
36, Virendra Patil.
Lords, the petitioners are the bank certificate.
Who appears to the respondent? Yes. Yes.
I appear for Canara Bank Security. There is separate on brokerage company is there of Canara Bank. Canara Bank Security. Is the respondent, my lord. Here, my lord, I filed an objection. Your lordship can kindly see the objection, my lord. Objection date filed on
Secretary said the demand
1st April 23.
dated 8/6/2020.
What has happened in this
issued
case?
by the respondent number 1. Directing the petitioner to pay the
Poundage.
poundage fee.
Poundage fee.
That is,
I've been directed to pay the poundage fee on the sale of shares. I am the certificate creator. The shares of the borrowers were sold by Canara Securities with the assistance, and said proclamation was also issued by the recovery officer. That is the respondent number 1, which my lords could find place at page.
What is this poundage fees?
Poundage fee is levied on every sale by the recovery officer for the expenses and all those things.
Incidental expenses.
Incidental expenses to cover that. There is a poundage fee which
According
can be
to you, who
levied
should pay
according to income tax certificate proceedings rules.
No. According to you, who should pay?
Purchaser. My lord, so rule 57 specifically says 57(4) poundage fee under sub rule 1 shall be paid by the purchaser of the property as soon as the sale is completed.
My lord, my objection mechanism taken only one part. Number 2 of my objection.
And respondent number 3
It
is
is
a broker appointed by the recovery officer.
We'll hear you.
It is submitted that the respondent company, being a stockbroker, has been appointed as a securities broker by the Debt Recovery Tribunal 2, Karnataka by order dated 15/4/2018. Lords, should that page number 2 of the objection statement. The respondent company is entitled to collect brokerage charge as mutually decided and necessary security transaction tax, the brokerage fixed at 0.4%, which includes exchange so and so, stamp duty, GST and so. The brokerage does not include securities transaction charges, and the same was charged by at the rate of 1% on the actual transactions value of the exchange. Apart from that, there was the DP transaction charges so and so. Accordingly, sum of rupees
We'll see some
3,47,000.
other day. This is smarter on 23rd February. Yes. Any other passages?
44, Shri Rajshekhar.
I appear
Shri Rajshekhar.
for the State Bank of India, my lord.
When which one?
44.
Oh, you appear. Where is she?
He is not there, but I also want 2 days time to find out from the branch exactly what happened.
This is smart after 2 weeks. Yes, next.
45, Chaitra Nirmala.
May I please, my lords? Appearing for the petitioner bank in this matter, my lords, we have assailed the.
You are appearing for the bank.
For the bank, my lords. For Canara Bank, we have assailed the order of the Debt Recovery Tribunal passed on 4/10/2022, my lords.
No, you people always appear and say why there is alternative remedy of going to DRA.
It's not that. This is totally a different fact, my lord.
No. Generally, any order is passed for DRT, all your bank advocates will say that alternative remedy to DRAT. Why you people have come to the High Court?
This is actually not that kind of an issue.
No, whatever issue, appeal like against any order of DRT.
For an appeal before DRAT, my lords, for the very simple reason, let me give the facts in a very short manner.
No, before going into that, everybody has their own simple reason to come here.
But here it is basically against.
What will
another-
happen is now if you say that this appeal is maintainable, from tomorrow onwards, wherever you appear, we will say that appeal, their petition is also maintainable.
Here, the main ground is against another bank, my lords. It's IDBI Bank, against IDBI Bank. And it's also against.
What is that? What is the order dated? Huh? 13/6/2023. From the above, what emerges is that the amount of rupees 30 crores 30 lakhs
Please, ma'am.
held in escrow account of Canara Bank needs to be remitted immediately to the respondent IDBI Bank. What should happen to rest of the amount shall be a matter of examination when the petition is taken up for consideration.
Yes.
Please.
My lords, in this matter, my lords, both the Canara Bank and IDBI Bank had funded the borrower, my lords. I'm going very simple. We had filed an original application 510 before Debt Recovery Tribunal. Likewise, IDBI had also filed an application.
How
before-
much money you have lent?
We have lent around 14,320 crores, my lords. And
That means how many crores? 14,000
14,320 crores.
crores you have lent.
Yes, my lord. They are, the borrower is involved in import and export of gold ornaments, gold and all those metals, my lords.
Figures are wrong. In fact, I'll explain, my lords. 14,000 was my deposit. It is not the bank lent. I clarify.
Who are you? You're appearing for the bank.
I am appearing for the company, the respondent number 2, my lords.
Bank, we are now with the,
If I am permitted, very short point. IDBI had lent money to the respondent number 2. Canara Bank also had lent money to respondent number 2.
how much you have lent? How much they have lent?
Lent about 500 crores, but.
How many? 5?
There were various loans. Facility was to the extent about 500 crores, which was secured. Respondent number 2 approached this honorable court, filed a writ petition and said, there is 139 crores due according to IDBI Bank. According to respondent, what is due is about 79 crores. It said it will deposit the entire money in the court, an auditor may be appointed. He appeared and said, see, the dispute is correct, but why auditor? RDBI Act is there. We will go before DRT and we will get it adjudicated. Ultimately, this honorable court in writ petition first was then writ appeal. Finally, this honorable court said out of 137 crores by way of interim order, 79 crore admitted amount was released to us, and balance about 58 crores was there. It said let the amount remain escrow account with Canara Bank. Escrow account opened by Canara Bank. You go to DRT, you make an application for release of that amount. At that point of time, dispute was only between IDBI and respondent number 2, the borrower. We went to DRT, we made an application for release of the amount. In the meantime, it appears Canara Bank's account with respondent number 2 also became an NPA. They also initiated proceedings for recovery. We were not aware. We made an application for release of the amount. Dispute between IDBI Bank and respondent number 2 got settled. We reported to DRT. We said as per terms, and this honorable court had said for release of 58 crores in escrow account, we can make an application before DRT. DRT should consider that application. That application was still pending from 2018 to 22. By 22, we settled the disputes. Some 53 crores were to be paid, 23 toward bank guarantee, 30 crores in that escrow account had to come to us. We went before DRT and made an application and said, see, we have settled the dispute, terms of settlement are this. Let the 58 crores be released, and if it is released, I have to take 30 crores out of it, and 28 crores is to be released. Now, in my application which I made to DRT versionally to release the amount from escrow account, I had to make bank a party because escrow account was with bank. Therefore, DRT said, okay, summon Canara Bank also. Canara Bank opposed release of the amount, and DRT passed an order saying that entire 58 crores should be released. DRT observed Canara Bank had at that point of time already filed OA. They don't make an application in their OA for attachment of any portion of the amount. In my suit, as in my case before DRT, as an escrow, they come and say, don't release this amount. I said, if money is given to me, I am entitled as of right for 30 crore rupees. 28, I will have to pay to them.
Can I
Then
substantiate
what
that?
order was passed, but the DRT passed an order and said release entire 58 crores because in the meanwhile what happened was DRT posted the matter by 2 other days. Canara Bank went and encashed the entire amount available in the escrow account and adjusted it towards their use.
How much is available in escrow?
My lord, I will
account?
have
About 57 crores plus interest.
I will have to
So
clarify
then
this portion, my
DRT
lord.
Then DRT passed an order. I am not justifying DRT's orders in entirety. DRT passed an order and said release the entire amount.
They cannot
challenged
say
the
that,
order
they are
in
not,
favor.
they have taken benefit under the order.
I will just complete, sir, please. I am not justifying.
No,
I'm not saying
you
they are wrong.
cannot say that, we are not.
Sir, let's not take it personally.
No,
please,
it's
sir.
okay.
The amount was released, directed to be released. Canara Bank against that order filed a writ petition in the honorable court. IDBI came and said, Canara Bank is saying 30 crore is not disputed to me. Respondent number 2 is saying 30 crore is payable to me. That amount may be released to me. Insofar as balance amount is concerned, it is between the petitioner and respondent number 2. I have no claim on the amount. My dispute has been settled. And accordingly, this honorable court passed an interim order in 23, which your lordship just knows a cursory. That amount was released in my favor. Now, as regards the balance of amount and whether the DRT's order accepting the compromise and releasing entire amount in entirety is correct or not, is the aspect which is to be considered by this honorable court. That's why they have filed a report.
So this portion I will try to clarify, my lord. From the day when we have got involved, as correctly stated by my learned friend, they in their original OA proceedings before DRT, they had filed an application for release of the amount from Canara Bank. Though we were made a party number 4 in that IA, we were never issued any notice. When it came to the fact that they had filed this IA in 2019. In 2022, when the matter came up for the final adjudication, by that time there was a settlement between respondent 1 and respondent 2, where respondent 1 agreed to settle all its dues for 30 crores, 30.32 crores. At that point of time, there were 58 crores. But the settlement stated that the entire amount from that account has to go to IDBI. IDBI has to absorb 30.32 crores, and whatever balance is there, the 28 and odd crores, it has to be released to the corporate, that is the corporate borrower. It has to be released. Fine, my lord. IDBI is concerned only with 30.32 crores.
Why was that order passed by the court?
Yes,
By
my
the
lord, that
DRT?
is the issue. So when it came before DRT, we had contested that, yes,
So
IDBI
why
has
should
a
there be
right.
an order directing that remaining amount to be given to the borrower?
Why should they say we have an outstanding of 451 crores by the time before the DRT itself? We had appeared and stated that we have such huge dues, let us appropriate that amount. But, and all the arguments were heard by the senior counsel representing the Canara Bank, my lord, on 29/9/2022. My lord, it was a Friday. Saturday, Sunday, holiday. Monday was 3rd, my lord. 3rd, when the arguments were going, the DRT responded, yes, IDBI is entitled for 30 crores, the rest we will take. By that time, my lord, on 3rd, 3/10/2022, the corporate borrower, he comes and files a memo without any notice to me. I do not know about IDBI. Without any notice to Canara Bank, they come and say we are going to withdraw that settlement, because if you are going to release the balance amount to Canara Bank, then I am not for this settlement at all. The matter is immediately posted on the next day on 4/10/2022, my lord, which is an Ayudha Puja day, when the banks, courts, everything was on leave. The DRT sits in the court. It sits in the court and entertains only this application and passes an order saying that entire amount from Canara Bank will have
Now
to
it
be
is
released.
withdrawn.
My lord,
Now it is withdrawn.
No.
30 crore is released, balance is there.
30 crores we have already released to them. Balance we had adjusted to their liability, my lord, to the liability of the corporate company. And my lord, but that is because there are serious strictures passed against Canara Bank in that order of DRT. We were not granted any opportunity. Thanks to my respondent one friend, he had informed me over phone that it is suddenly listed on 4th of 10. Why don't you come down?
No,
I
DRT
rushed.
asked us to inform, my lord. It should be fair and it was not a holiday.
Whoever informed me, I am just thanking him. I rushed from Hosur coming here, but by the time order was passed. When I entered the court and asked them what is the order, we are the interested party, we should have been heard. Court says that order has already been passed, but I will mark your appearance that you appeared after the order has been passed. Why on a holiday? Why on a state holiday, which is an Ayudha Puja? All that, okay, while that is a intention, that is a total discretion of the court. I'm not going into that. But my lord, my OA before them is pending for 451 crores as on 2021. Today, imagine, my lord, in 2026, what would be the outstanding? Number one. Number two, my lord, IDBI has settled, the entire amount has been given to IDBI. Why should there be a direction to Canara Bank to transfer the entire amount to IDBI and for IDBI to transfer it to the corporate company? When they have so much dues to us, whether the dues is to be paid, not, that is a separate part of adjudication. How could a DRT direct release?
May I submit, my lords? Completely, my lords. It is off the record, my lords. I'll take your lordships through the documents, my lords. I'll show it to your lordships as per the documents. Lords, the submissions were incorrect.
Before my
Kindly have
friend,
it on.
my lord, before my friend continues, I want to.
Please, 1 minute.
Lords, your lordships can.
Only one clarification. In a particular amount is lying in the escrow account. They said they had a settlement with you. Then the court has, the DRT was right in saying that release 30 lakhs in favor of the IDBI. Why should the remaining amount be released in your favor?
My lords, that your lordships have to see the statement of objection in that regard. My lords, the earlier 1/2/2023, I mean 22, my lords, in the month of January, their entire dues was secured by the DRT, Honorable DRT. Lords, that is the reason. Lords, may I request your lordships to turn to, lords, they produced their own document. They forget to read the document at page number 126.
DRT directed us to
I understood your submissions. Again, if I have any doubt, I'll ask you.
Yes, madam.
Yes.
Because if we
Please, my lords,
understand that
your lordships
concept,
You can reply.
Sorry,
to
ma'am.
Yes.
Lords, your lordships can turn to page number 126.
120.
126. The please. ಸ್ವಲ್ಪ ಇದೆ.
Oh, sorry.
Yes.
Please, my lords, this is the settlement, my lords. The settlement arrived between the IDBI Bank, that is respond number 1, and the respond number 2. Your lordships can turn to the terms of the settlement. May I read, my lords? We refer to your letter dated 13th May 2021, submitting an offer for a settlement of dispute. The letter of intent dated March 24th, 2022, duly accepted by the company and the guarantors. Your email dated so and so, requesting for extending of a sanction by 30 days, and subsequent letter dated July 30th, 2022, and discussion on the subject. Upon considering your request, the IDBI Bank is agreeable in principle for extension of a period of settlement of the dispute as under, subject to the other terms and conditions as mentioned in Annexure I. Lords, the first column, my lords, balance settlement amount. Settlement amount is 30 crores, interest 32 lakh and odd. Total is 30 crores, 32 lakh 69,589. Second column, my lords, payment terms 30 crore, 32 lakh 69,589 to be paid on or before 31st of August 2022. Settlement expiry date so and so. Release of security. Release of security so and so, my lords. Now your lordships can turn to the next page. Lords, the third condition, filing of a joint consent terms by the REL and the bank before the DRT Bangalore on the dispute settlement. Fourth term, unconditional withdrawal of all litigation claims, disputes, including the counterclaim of 14,788.66 crores pending before various courts, tribunals, and forums filed by REL and its directors against the IDBI Bank and its officials. Intimation of a categorization of account as NPA to RBI, civil so and so, so and so. The sixth condition, Rajesh Exports Limited shall make a necessary and a timely efforts to collect the original BG or discharge the letter from the customs department so and so with regard to the outstanding bank guarantee so and so, so and so, and return to the IDBI Bank. My lords, this offer so and so, so and so.
For what purpose you want to read it? I didn't understand.
My lords, so far as the dispute is not the 14,000 crores what they have said, my lords, it is a figure which has emanated as a loan lent, first of all. So far as the discussion, discussion between the Canara Bank or the IDBI Bank is concerned, my lords, so far as this company is concerned, my lords, it doesn't take a loan, in fact. My lords, the entire transaction is a forex transaction covered under FEMA. I give a deposit up till 2016, up till RBI imposed a restriction on a gold loan or a loan for the purpose of gold as a commodity. My lords, the loan was extended. After 2016, there was a complete restriction by the RBI. My lords, after that, what has happened is, I used to deposit the entire 100% whatever facility I wanted. My lords, be that be 1,000 crores, be that be 14,000 crores, 20,000 crores. Indeed, it was the deposit as on that date, one particular date available was, liquidated was more than 14,000 crores in the month of August 2020. That was the dispute between the Canara Bank and Rajesh Exports. That is the point of trigger. So far as this matter is concerned, my lords, the IDBI Bank classified the Rajesh Exports as a NPA. I mean, issued a demand notice, classifying it as a non-performing asset in the month of November 2017. Immediately, I came before this honorable court. I said that they are claiming around 137 crores. According to my balance sheet, because it's an everyday transaction, my lords, it is not a transaction where debit happens on occasionally or maybe once in a month or twice in a year. My lords, it's a transaction. My lords, my limit was transaction was every day almost around on an average 400 to 500 crores. The limit as well as the interest calculation is a subject matter of always been a disputed part. Even with the Canara Bank as well as the IDBI Bank, that was the one of the ground for dispute. Lord, subsequently, what happened? I came before this honorable court. This honorable court said, "Look here, so far as your dues are concerned, the claim is around 137 crores. You have stated in your, you are admitting that it is 79 crores." Lord, so with the orders of this honorable court, though I deposited pursuant to the orders of this honorable court, I completely deposited entire amount before this honorable court. They were been, IDBI Bank was been permitted to withdraw 79 the admitted amount. Rightly, my lords, subsequently, we were been sent to DRT for the purpose of adjudication of a dispute. In that, at that point of time, my lords, your lordships can turn to Annexure R1 of produced with my statement of objection.
When was it filed?
My lords, statement of objection was filed on 24th March 2023. Page number 27, Annexure R1.
There is nothing dated 24th March.
Lords, may I
Take that.
see the other?
This is 14/12/2022.
I'm sorry, my lords, I read it wrongly.
That is here 14/12/2022.
I read the seal wrongly.
I am looking at the date on which it is filed.
I'm sorry.
Yes.
The Lords, this arrangement was done between Rajesh Exports as well as Canara Bank is because Canara Bank at that point of time was a neutral party. And there, since there was a dispute, escrow account was opened. Lords, your lordships can turn to the certificate. This is to clarify, this is to certify that Rajesh Exports Limited have today made a deposit of.
Where is that page number?
Page number 27. Lord, because the certificate was issued, because I was supposed to produce before this honorable court of complaints with respect to the deposit.
Hmm.
This is to certify that Mrs. Rajesh Exports Limited have today made a deposit of 137 crores 22 lakhs 25,086 in an escrow account towards the settlement of their dues with IDBI Bank pursuant to the orders of the Honorable High Court of Karnataka in writ petition number 8991 of 2018. The amount has been deposited in the form of a fixed deposit.
So the purpose of opening a escrow account is to settle the dues between IDBI Bank and the petitioner.
That's the next condition.
Absolutely,
Next,
ma'am.
next
Once
paragraph.
the settlement with IDBI Bank is completed, the proceeds in that escrow account becomes a general balance in a general account, which as
Under which
yes, we don't.
provision?
Under provisions of the Contract Act, my lord, where Honorable High Court has directed that an escrow account has to be opened for a particular purpose, and the purpose is satisfied. When the purpose is satisfied, it becomes a general account, not an escrow
No,
account.
for example, well, let's take an example of this nature. The petitioner has nothing to do with your bank.
And
The
Company,
respondent has nothing to do with the Canara Bank.
no, it has obtained so many liabilities.
I'm
Assume-
telling you an example,
assume-
understand. The respondent has nothing to do with Canara Bank. For the purpose of this or nature, he opens an account with Canara Bank for this purpose. Then what will happen?
If I don't have anything to do with it, and if there is anything over and above, I will return it to the holder.
Oh.
Your lordships have to turn to second question, my lords.
Purpose of opening, no, because somebody has an account in your bank. So you want to recover some money, whatever is the purpose, you will recover it from somebody else's account.
No, cannot recover it from somebody else's account. Here, it was an escrow account where the
Purpose, there won't be any purpose for that.
Ma'am, in a normal account,
Please
there is no
read
purpose.
that certificate.
Yes, my lord. In this certificate, what we have stated is, we hereby certify that the amount will be held with the bank as escrow account until further orders from the Honorable High Court of Karnataka. In case no orders are received from within the maturity period of deposit, then we will renew the fixed deposit until we receive orders from High Court of Karnataka. Here, apart from the first writ petition, the amount was deposited. In the second writ petition, what has happened is that 79 lakhs was already given to IDBI, and in that order, there was also a direction that one escrow account should also be opened with IDBI. But then it didn't get opened, and it was represented before court that there is already an escrow account with Canara Bank. High Court permitted us to continue with Canara Bank. And High Court also stated IDBI to go before DRT to seek for release of the amounts. IDBI came before DRT to seek for release of amounts. There they settled the account. When the account is settled, it was settled only for 30.32. If they had settled for the entire 58, we would have transferred it to IDBI. But they settled only for 30.32. And behind the back of Canara Bank, because by the time our account also became NPA, behind the back of Canara Bank, the settlement.
Why should somebody anticipate about it behind your back?
Because the settlement was entered between these two parties.
It was very simple for them. They had filed OA. In that
They could have, you could have. Why this unnecessary anxiety, excitement for the Canara Bank?
No anxiety.
Exactly, my lord. So this was the mortal hurry.
5 minutes to explain certain things before your lordship. Just 5 minutes. Because I have very 5 points to tell before your lordships. My lords, when already my OA was before the debt recovery. My lord, let me finish.
No, please, you please.
My lord, what
I
I
understood.
Say, what your lordships.
I am asking a simple question. An account is, for a particular purpose, an account is opened. That is satisfied. Whatever is the person who has deposited the amount in that is given to them. As far as your transaction, petition transaction with the respondent is concerned, you feel anything is required, any relief you require, then you have to file, you have already filed an OA, you will file your appropriate application and seek the relief. You are unconnected with the transaction with the IDBI bank and the respondent.
My lord, in this case, your lordships, I would request your lordships also to consider that as a creditor banker, I have been permitted by the Indian Contract Act to exercise my lien and right of set-off of any general balances which I have in my custody. My lord, in this case, when the escrow account became a general balance account, I as a creditor, I exercise my right under section 171 of the Indian Contract Act on the general balances.
What is the amount that you have lent to them?
My lord, I have lent around 14,620 crores.
What will happen with this 28 crores?
I will adjust it to their account only. Where will I take it? I will not take it for myself. I have
That's not the way you argue. You are arguing as if like you are asking questions to the court. You are with all that, that's not the way you argue the matter.
My lord,
Can't ask a question to me.
Yes, my lord.
You only have to answer.
My lord, one more issue is that I would like to explain. One more issue is that which they had raised that we had not taken any facility. It was only out of the foreign.
And here this list is marked as first tomorrow on the top of the list. I'll pass orders tomorrow. But I am indicating my mind. I am really not convinced with it, subject to what you say tomorrow.
Submission, my lord. In fact, in DRT also I said, why are they coming and fighting in my OA?
Correct.
And I was unnecessarily dragged into this in the process.
But we are a party in that IA, my lord. And
No, we'll consider tomorrow you can address your arguments. As of now, I'm indicating that I'm not convinced, subject to what you say tomorrow. Tomorrow as a first case.
endeavor to satisfy your lordships.
No, or else we'll do one thing. This matter at 1 o'clock, not one, day after tomorrow, top of the list. Tomorrow I have a full bench at 2:30. I may have to complete the matters.
46.
No, what we'll do is, court officer, this will find out the day when I don't have the full bench, that day at 2:30.
Lord, sir.
Yes.
I was told, my lords, your lordship should be sitting full bench for this week, my lords.
That's what. So I may be having next week.
Please.
Because I need to hear it again. If I take it up at 10:30, by 2:30 I won't be able to finish the other matters.
Please, my lords.
Just look at it. Whenever I don't have the full bench at 2:30, then that day at 2:30 this matter. Keep it. Yes. Any signatures?
Date madam 28 ಆಯ್ತಲ್ಲ serial along with 28 serial date ಅವ್ರದ್ದು ಹೇಳ್ತೀನಿ ಇದಕ್ಕೆ ಇನ್ನು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಿಲ್ಲ ಅದು ನೋಡ್ಬೇಕು ಫುಲ್ ಬೆಂಚ್ ಯಾವತ್ತಿಲ್ಲ ಅವತ್ತು ಹಾಕಿರ್ತೀನಿ
ಈ ವಾರ ಇರೋದಾ ಸರ್?
ಈ ವಾರ ಡೌಟ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಇದಕ್ಕ ನಾನ್ ತಿಳ್ಕೊಂಡ್ ಬೋರ್ಡ್ ಬಂದು ತಿಳ್ಕೊಬೇಕಮ್ಮ ಮ್ಯಾಟ್ರ್ ಎಷ್ಟು ನಡೆಯುತ್ತೆ ಗೊತ್ತಿಲ್ಲ ಫುಲ್ ಬೆಂಚ್ ರೆಗ್ಯುಲರ್ ಆಗಿ ಇರುತ್ತಂತೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಯಾವಾಗ ಇಲ್ಲ ಫುಲ್ ಬೆಂಚ್ ಅವಾಗ 2:30 ಹಾಕಿ ಅಂತ ಹೇಳಿದ್ರು ತಿಳ್ಕೊಂಡು ಹಾಕ್ತೀವಿ ಆಮೇಲೆ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ ನೋಡ್ಕೊಂಡು
ಇವತ್ತು ಅಪ್ಡೇಟ್ ಆಗುತ್ತಾ ಸರ್? ಇವತ್ತು ಆಗುತ್ತಾ ಅಪ್ಡೇಟ್?
ತಿಳ್ಕೊತೀನಿ ಗೊತ್ತಾದ್ರೆ ಮಾಡ್ತೀವಿ ಇಲ್ಲಾಂದ್ರೆ ನಾಳೆ ನಾಡ್ದಲ್ಲಿ ಮಾಡ್ತೀವಿ ಕಂಪ್ಯೂಟರ್ ಅಪ್ಡೇಟ್ ಮಾಡ್ತೀವಿ ಒಟ್ನಲ್ಲಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 36 ಒಂದು ಡೇಟ್
ಇದನ್ನ 46 ನ ಸೀರಿಯಲ್ 28 ಜೊತೆ ಮಾಡ್ಕೊಡ್ತೀವಿ.
ಸೀರಿಯಲ್ ನಂಬರ್ 28 ಆಗಿದೆ
ಇವರು TS ಆಗಿದೆ ನಮಗೆ ಸೀರಿಯಲ್ ನಂಬರ್ 28
ಅವ್ರಿಗೆ ಕೇಳ್ತೀನಿ ಮೇಡಮ್ ಯಾವ ಡೇಟ್ ಆಗಿದೆ ಆ ಡೇಟ್
28 ಅದು 17/3 ಆಗಿದೆ
17 ಅಂತ ಇಷ್ಟು ದಿವಸ ಮ್ಯಾಟರ್
17/3 ಅಂತ ಹಾಕ್ಬಿಡಿ.
ಓಕೆ ಸರ್ ಆಯ್ತು ಇದು 36 ಒಂದು ಹೇಳ್ಬಿಡಿ ಸರ್
17/3 ಅಲ್ವಾ 36 ಮೇಡಮ್ ಏನು ಡೇಟ್ ಹೇಳಲಿಲ್ಲ ಅಲ್ಲೇನು ರೆಕಾರ್ಡ್ ಆಗಿಲ್ಲ
ಇಲ್ಲ ಸರ್
ಸಮ್ ಅದರ್ ಡೇಟ್ ಅಂದ್ರು
ಯಾವ ಡೇಟ್ ಆಯ್ತು ನೀವು ಹೇಳ್ಬಿಡಿ ಸರ್
ಯಾವ್ದನ್ನ ಡೇಟ್ ಹೇಳ್ತಾರೆ
ಬರ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ
ಬೇಡ ಅದ್ರ ನೆಕ್ಸ್ಟ್ ವೀಕ್ 3 ದಿನ ಇರೋದು 16, 17, 18 3 ದಿನ 3 ದಿನ ರಜೆ ಬಂದ್ಬಿಟ್ಟಿದೆ ಅದಕ್ಕೆ 12th ಹಾಕ್ಬಿಡಿ ಇಲ್ಲಿ ಮೇಲೆ 12 ಹಾಕ್ಬಿಡಿ 36 12 ಹಾಕ್ಬಿಡೋಣ ನಾವೇನೆ ಸಮ್ ಅದರ್ ಡೇಟ್ ಅಂದ್ರು ನಾನು ಕೇಳಿಸ್ಕೊಂಡೆ ಸಮ್ ಅದರ್ ಡೇಟ್ ಅಂದ್ರು ಯಾವ್ದು ಡೇಟ್ ಹೇಳಲಿಲ್ಲ 36 12/3 ಎಲ್ಲರೂ 12/3 ನೇ ಹಾಕ್ಬಿಡಿ
ಇದೊಂದು 45 ಅಂತ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ ಸರ್
ಏನ್ ಹೇಳಿದ್ರು
ಇದು ಸರ್ ಹೇಳಿದ್ರು
45 ಅದನ್ನ ಯಾವ ಫುಲ್ ಬೆಂಚ್ ಯಾವತ್ತಿಲ್ಲ ಅವತ್ತು ಹಾಕಿ 2:30 ಅಂತ ಗೊತ್ತಾಯ್ತು 2:30 2:30 ನಾಳೆ 2:30 ನಿನ್ನ ಹಾಫ್ ಡೇ ನಾಳೆ ಹಂಗಾರೆ
ಫುಲ್ ಬೆಂಚ್ ಯಾವತ್ತಿಲ್ಲ ಅವತ್ತು ಹಾಕಿ ಅಂತ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ ನಮ್ಗೆ ನಾಡಿದ್ದು ಕಂಟಿನ್ಯೂ ಆದ್ರೆ ನಾಳೆ ತಾನೇ ಗೊತ್ತಾಗೋದು ನಾಳೆ ಇದೆಯಾ
ಮಂಡೇ ಹಾಕ್ಬಿಡ್ತೀರಾ ಹಂಗಾರೆ ಮಂಡೇ 2:30 ಇಲ್ಬಿಟ್ರೆ ತಿರ್ಗಿ ಕಂಟಿನ್ಯೂ ಆದ್ರೆ
ಸರ್ ಕೇಳ್ಬಿಟ್ಟು ಸ್ವಲ್ಪ ನಮಗೆ ಚೇಂಬರ್
ಫೈಲ್ ನಿಮ್ ಕಡೆ ಇಟ್ಕೊಂಡಿರಿ
46 ಯಾರಿಗೆ 46 ಯಾರಿಗೆ ಕೊಡ್ತೀರಾ ಸರ್
46 17/3
ಅಷ್ಟೇನಾ
ಸರಿ
ಅದು ಅದ್ರಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಮಾಡಿ ಅಂತ ಆರ್ಡರ್ ಆಗಿದೆಯಲ್ಲ ಇದಕ್ಕೂ ಇನ್ನೊಂದ್ಸರಿ ಕನೆಕ್ಟ್ ಅಂತ ಬೇಡ ಹೆಡ್ ಕ್ವಾರ್ಟರ್ ಸಾಕು
ಅಷ್ಟೇ ಇದು ನಿಮ್ಗೆ ಪಿಕೆ
ಪಿಕೆ
ಇದನ್ನು ಯಾವತ್ತು ಹಾಕ್ತೀರಾ ಡೇಟ್ ಅನ್ನು ಚೆಕ್ ಮಾಡಿ ಬೋರ್ಡ್ ಅವ್ರಿಗೆ ಕೇಳಿ ಸರ್ ಇಲ್ಲ ಮಂಜು ಕೇಳ್ಬೇಕು ನೀವು ಮಂಜು ಕೇಳ್ಕೊಳ್ಳಿ
ಮಂಜು ಗೊತ್ತಿಲ್ವಲ್ಲ ಎಷ್ಟು ದಿನ ಮುಗೀತದೆ ಅಂತ
ಅದು ಲಿಸ್ಟ್
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಒಂದು ಲಾಂಗ್ ಡೇಟ್ ಕೊಟ್ಬಿಟ್ರೆ
ಅದು ಇಯರ್ ಮಾಡಿದೆ
16th ಕೊಟ್ಬಿಟ್ರೆ ಅಷ್ಟು ದಿನ ಏನಿರಲ್ಲ
16th ಎಷ್ಟೊಂದು ಹಾಕೊಂಡಿದ್ದೀರಾ ಮೇಡಮ್
23rd ಹಬ್ಬ
10ನೇ ತಾರೀಕು ಹಾಕಿ ಸರ್ 10ನೇ ತಾರೀಕು ಹಾಕಿ
10ನೇ ತಾರೀಕು 2:30 ಅಂತ ಬರೆದ್ಬಿಟ್ರೆ ಅದು ಇನ್ನ
ಕಂಟಿನ್ಯೂ ಏನ್ ಮಾಡ್ತೀರಾ
2:30ಗೆ ಹಾಕಿ ಅಂದಿದ್ದಾರೆ ಆಗ ಹೆಂಗ್ ಗೊತ್ತಾಗುತ್ತೆ
after completion of full bench whenever the full bench is not sitting will be listed at 2:30
ಅಡ್ಜರ್ನ್ ಅಂತ ತೋರಿಸ್ಕೊಳ್ಳಿ ಆಮೇಲೆ ಅದನ್ನ ನೋಟ್ ಮಾಡ್ಕೊಂಡು ಲಿಸ್ಟ್ ಮಾಡಿಸಿ ಇಲ್ಲ ಡೇಟೇ ಕೊಡಬೇಕಾಗುತ್ತಲ್ಲ
ಇದೊಂದು ಫೈಲ್ ಹಂಗೆ ಇಟ್ಕೊಂಡಿದೆ
ನಾಳೆ
ನಿಮ್ಗೆ ಕಳಿಸಿರ್ತೀನಿ ಸಪರೇಟ್ ಇಟ್ಕೊಂಡಿದೆ ಅದು ನಾವು ಇಲ್ಲಿ ಅಪ್ಡೇಟ್ ಮಾಡಿರಲ್ಲ ಅದನ್ನ ತಿಳ್ಕೊಂಡು ಮಾಡೋಣ ಮೇಡಮ್ ತಿಳ್ಕೊಂಡು ಇದು ಹಂಗೆ ಬಿಟ್ಬಿಟ್ಟಿದೆ ಅದನ್ನ ಅಪ್ಡೇಟ್ ಮಾಡ್ಲೇಬೇಕು